ಏನಿದು ಎಕ್ಸಿಬಿಟ್ P11 ಏನಂತಿದೆ ನೋಡಿ ತೋರ್ಸಿ.
Exhibit P11
ಆಟೋ ರಿಕ್ಷಾ ಹೋಗ್ತಿದ್ಯಾ?
ಆಟೋ ರಿಕ್ಷಾ ನಿಂತಿದೆ.
ನಿಂತಿದೆ, ಆಯ್ತು. ರೋಡಲ್ಲಿ ತಾನು ನಿಂತಿರೋದು?
ಹೌದು, ರೋಡಲ್ಲೇ ನಿಂತಿರೋದು.
ಅದು ಎದುರುಗಡೆ ಅಲ್ಲಿ ಏನೋ ಒಂದು ಕಾಂಪೌಂಡ್ ತರ
ಅದು ನೆಕ್ಸ್ಟ್ ನಮ್ದಲ್ಲ ಅದು.
ಮತ್ತೆ ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಎಲ್ಲಿದೆ?
ನಮ್ ಬಿಲ್ಡಿಂಗ್ ವಿಚ್ ವಿ ಹ್ಯಾವ್ ಶೋನ್, ಇದು ನಮ್ ಬಿಲ್ಡಿಂಗ್, ಆಟೋ ರಿಕ್ಷಾ ನಿಂತ್ಕೊಂಡಿರೋ ಬಿಲ್ಡಿಂಗ್ ಇದು. ಆ ಕಡೆಯಿಂದ ಮೇನ್ ರೋಡ್ ಇಂದ ಬರುತ್ತೆ ರೋಡು. ಅವ್ರದ್ದು ಡೆಡ್ ಎಂಡ್ ರನ್ ಆಗತ್ತೆ ರೋಡ್ ಅಂತ ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ಕಂಟೆನ್ಷನ್. ಕೈಂಡ್ಲಿ ಸಿ.
ಈ ಫೋಟೋಲ್ ನಿಮ್ ಬಿಲ್ಡಿಂಗ್ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಿರೋದು. ಈ ಫೋಟೋಲ್ಲಿ ನಿಮ್ಮ ಬಿಲ್ಡಿಂಗ್ ಎಲ್ಲಿದೆ?
ನನ್ನ ಬಿಲ್ಡಿಂಗ್ ಆಟೋ ರಿಕ್ಷಾ ಎದುರುಗಡೆ ಇರೋ ಬಿಲ್ಡಿಂಗ್ ನಮ್ದು. ಹೊಸ ಫೋಟೋಗ್ರಾಫ್ ಬೇಕಾದ್ರೆ ತಂದು ಕೊಡ್ತೀನಿ ನಾನು ನಾಳೆ. ಎಂಟೈರ್ photographs ತಂದು ಕೊಡ್ತೀನಿ.
This is the building,
please.
Then you have to take position in accordance with
it would be, my lords, invoking either, my lords, the Public Premises Act, my lords, coupled with the BDA Act. What I wanted to bring to my lords' notice was limited extent, my lords, that it can't be waived for filing a suit for possession. It can't be waived for suit for possession.
Waived for possession, correct. So that is what the I think John B. James
please.
There is 2 orders from this honorable
there
court.
Was, in fact, lords, proceedings
Exhibit
were initiated much
P8
earlier also.
And 9.
They were able to dodge the same at that point in time. They do not participate in the proceedings when notices
take out
were
proceedings as provided under the BDA Act.
Please.
That as per recovery proceeding. However, my lord, kindly see, there are 2 decisions of this honorable court insofar as existence of the building much prior to the acquisition.
Oh, then
even then, my lords, it becomes very clear, my lords, that along
30,
with that,
38
no. This finding of the trial court that the entire extent of 1 acre 33 guntas is not acquired, I think is wrong. Going by that, I think it is wrong. If that is so, I don't know how you can maintain a suit for injunction against BDA. That is a judgment of the Supreme Court also.
case.
That
Just
so far as my lord, that exhibit P8 and 9
ಬಂದಿದೆ ನೋಡಿ. ಬ್ರಿಜೇಶ್ ರೆಡ್ಡಿ ಆದ್ಮೇಲೆ ಇನ್ನ 3-4 ಬಂದಿದೆ.
Please.
ಬಂದಿದೆ ನೋಡಿ.
Provided,
my lord, insofar as
judgment, division bench
30,
judgment
38, since my lord, this honorable court observed that there is an existence of the building but prior to the acquisition, and they have made representation before the BDA for reconvey, which has not been considered antane bardidare.
What is there to show that there was a building prior to the acquisition?
That is what, my lord, this honorable court observed. Kindly see.
ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ, ಜಸ್ಟಿಸ್ ಶ್ರೀನಾಥ್ ಉಳ್ಳಾಳು ಮತ್ತೆ ಜಸ್ಟಿಸ್ ನಾಗಮೋಹನ್ ದಾಸ್ ಅವರು ಬರೆದಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ, ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್. ಅದಾದ್ಮೇಲೆ ಒಂದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ರೀಸೆಂಟ್ ಆಗಿ ಬಂದಿದೆ ನೋಡಿ.
Please.
Order
ಲಾಸ್ಟ್ ಇಯರ್
ink page number 2 at WPL ink page exhibit P8, that is 82 nal order.
ಎಕ್ಸಿಬಿಟ್
P8, that WP 40943 of 1982. There, my lord, the demolition notice issued annexure D, the said order is provisional or made so and so so and so. The case of the petitioner is that the property under dispute along with some other property was earlier belonging to him. The same came to be acquired by BDA. He sought for reconveying the said land acquired, so including the portion put of constructions. Instead of considering the request, now provisional order annexure D came to be passed. In the 82 nalli that building existence ittu modle annodar ಬಗ್ಗೆ observation
ಸಾಕಾಗಲ್ಲ. Is there any objections filed to the notification? Have you filed any objections to the notification?
that I have sought at the tab before trial court, but
if there is no objections filed to the notification saying that there is already a building,
reconvey ಮಾಡ್ಕೊಡಿ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ ಹೇಳಿ
reconvey ಮಾಡಿ ಅದು ಒಂದು ಸ್ಕ್ರೀನಿಂಗ್
ಅವತ್ತು ಇರಲಿಲ್ಲ. ಅವತ್ತು
1991 ನಲ್ಲಿ there was a screening committee. So therefore people used to come to this court and say, please reconvey the property.
Trial court has said, my lord, that they have to procedurally pass orders.
But the law is, if it is a property which belongs to the BDA, you cannot file a suit for injunction. That is the law.
But there are 2 orders from this court, and they have got a title documents and all these things that we have placed, and my lord, that they have appeared, they have taken a contention.
Please get that.
I will get produced. Tuesday.
List on learn
21st or 27th.
so on date good.
27th or 21st, 3 days.
Take whatever date you want.
Tuesday, Friday month.
22nd.
23rd.
23rd ನಾನಿಲ್ಲ ಅದಕ್ಕೆ 27th ಹಾಕಿ 27th 28th ಏನಿದೆ
This is on Monday.
28 22nd ಇಂದ 24th ನಮ್
Any Thursday and Friday.
30ಕ್ಕೆ
24th,
30ಕ್ಕೆ ಲಾಸ್ಟ್ ಹಾಫ್ ಡೇ ಇರುತ್ತೆ.
24th,
24th ಇಲ್ಲ 25th
ಯಾವತ್ತು ಬೇಕು ಫೋಟೋ?
Saturday ಇದೆ sir. My lords would have it.
Saturday, 25th.
Great.
Great.
Number 24, B.R. Srinivas Gowda.
B.R. Srinivas. Rahul Reddy.
This case, allowed appellant is a
Suit is for what?
Swami.
Suit
No, it is for injunction.
Injunction.
And declaration and injunction to set aside the sale deed. The only one aspect this honorable court has to consider, my lord, is the sale deed executed in the year in the year 2006,
I
my lord.
admit call for records.
Your Lordship,
Yes,
my humble submission is
you are
claiming the title from a GPA
For
holder.
records, interim stay of the impugned order till the next date.
Lordship, there is no stay application, Lordship.
Huh?
There's no
Stay application ಇದೆಯಲ್ಲ?
No,
ಇಲ್ಲ. Admit call for records. Paper books to be filed within 8 weeks.
much obliged.
Number 25, H. Ramachandra.
H. Ramachandra. Going to pay up some of the amount for. ಏನು 5 ಲಕ್ಷದ ಏನದು?
Meanwhile, appellant number 2 is died. ಇವತ್ತೇ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಏನು 5 ಲಕ್ಷದ ಏನೋ ಇತ್ತಲ್ಲ ಪ್ರಕಾಶ್?
My lord, lordships insist, I will convince my client. My humble submission before this honorable court is this, whether the suit filed by the plaintiff before the trial court is maintainable,
Yes?
maintainable for seeking declaration instead of filing recovery of consideration amount.
ಏನಿದು?
Preliminary court fee ಬಗ್ಗೆ preliminary issues of payment manner. Even that was also not heard.
No, but how can the court reject the plaint?
Lord, the honorable trial court rejected the plaint on the ground that the non-payment of balance sale consideration amount, the plaintiff cannot file for declaration seeking to cancel the sale deed, which is said to have been executed. Instead of seeking declaration to
copy
cancel the sale deed, they would have gone for recovery of balance sale consideration amount. That is the precedents of Honorable Supreme Court as well as this Honorable Court.
What is the case of the plaintiff? Is he an agreement holder?
My lord, the plaintiff is one of the vendor, my lord. Plaintiff is one of the vendor. She sold property along with other 13
Total
vendors.
14 vendors, man.
There are 14 vendors. She is serial number 4. I placed that sale deed, my lord.
Now, in fact, appeal is filed by other appellant also. Now, about 7 persons have filed appeal, man.
My lord, there are.
Putting the same
there are-
payment.
Defense 1 to 3 claiming to reach.
My lord, page 14, my lord, page 14 of the sale deed.
7 crores 75 lakhs after lot. Oh, this is a balance sale consideration.
Balance sale consideration, my lord.
Hmm. Yes, what do you want? You want to pay this 5 lakhs?
My lord, in fact, the defendants number 1 to 3 have been already filed. If your honor insists, I can convince my client to pay this 5 lakhs again.
Don't
In fact,
convince
my lord,
my client
in
because
fact, in fact, he has
You are not
paid
doing
that,
it,
in
Mr.
fact, my lord, he has paid that entire
Not
consideration.
doing a favor.
Yes,
You're not doing a favor to the court.
yes. No, my lord.
You're not doing a favor to the court. If you want to buy peace, pay 5 lakhs and close it.
But appellant number 2 is died, man.
Ah.
And 10A.
5 ಲಕ್ಷ
Today
ತಗೊಂಡು
only
close ಮಾಡಿ
ಕೊಟ್ಟಿದ್ದು.
credit ಇದ್ದೀರಾ?
Sir?
5 ಲಕ್ಷ ತಗೊಂಡು ಕ್ಲೋಸ್ ಮಾಡಿ ಕ್ರೆಡಿಟ್ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ಅದು ಯಾಕೆಂದ್ರೆ ಇವ್ರು ಸತ್ತಿದ್ದಾರೆ ಮತ್ತೆ ಇವ್ರು ಎಲ್ಲಾರು ತರ್ಬೇಕಾದ ಪ್ರಶ್ನೆ.
ಅಲ್ರಿ
ಅಲ್ಲ ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ರೆಡಿ ಇಲ್ಲ.
ರೆಡಿ ಇಲ್ಲ
Ready.
ಬರ್ಕೊಳ್ಳಿ. The learned counsel for the appellants submit that the appellant number 2 has expired
Yeah, appel number 2 expired. On 8/1.
on 8/1/2026. Whether appellant number 1 is the legal heir,
ಇದು ಅದ್ರ ಬಗ್ಗೆ ನಂಗೆ ಕರೆಕ್ಟ್ ಗೊತ್ತಿಲ್ಲ ಸರ್. ಇವತ್ತೇ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಐ ಟು ಸೀಕ್ ದ
Akbar Pasha,
ಪಾರ್ಟೀಸ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್.
he seeks time to take steps to bring her legal representatives. The meanwhile, the appellants are not willing to receive rupees 5 lakhs from the respondents. Hence, list after applications are filed to bring the legal heirs of the deceased appellant number 2. Yes.
Number 26, Chandrasekhar P. Patil.
Chandrasekhar P. Patil.
27, my lord. The recovery suits, the suits have been decreed along with interest of 18%.
4,810 days. End reason. Delay.
Delay, the decree was passed in 2010. It is almost an ex parte decree.
So
The execution was filed in 2022. ಆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ದಲ್ಲಿ ನೋಟಿಸ್ ಬಂದ ನಮಗೆ ಗೊತ್ತಾಯ್ತು ಅಂತ. ಬಟ್ ಇದರಲ್ಲಿ ಈಗ ಆಲ್ರೆಡಿ ನಾವು 2 lakhs ಕೊಟ್ಟಿದೀವಿ. 18% ಇಂಟ್ರೆಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ಟನಪ್ಪ ಅಂತ ನೆಗೋಷಿಯೇಷನ್ ನಡೆದಿದೆ. ಆಫ್ಟರ್ ಅಪ್ಲಿಕೇಶನ್ ಇಫ್ ಇಟ್ ಇಸ್
ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ಲಿ?
ಇಲ್ಲ, ಸ್ಟೇ ಕೊಟ್ಟಿದ್ರು, ನೆಕ್ಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡಲಿಲ್ಲ.
ವಾಟ್ ಇಸ್ ದ ಟೋಟಲ್ ಅಮೌಂಟ್?
ಟೋಟಲ್ ಅಮೌಂಟ್ ಒಂದರಲ್ಲಿ 2 ಲಕ್ಷ, ಇನ್ನೊಂದರಲ್ಲಿ 2,20,000 ಇದೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
2 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀವಿ ಆಲ್ರೆಡಿ.
ಆಯ್ತು, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
ಅದೇ ಮಾಡ್ತಾ ಇದೆ.
Learned counsel for the appellant seeks time on the ground that the appellant is working out a settlement with the respondent. Hence list on first week of June.
ಸೆಕೆಂಡ್ ವೀಕ್ ಅಲ್ಲಿ,
Second week of June.
ಸೆಕೆಂಡ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವ್ದಾನ ಒಂದು
Yes. Nayak Ramchandra Rama.
ಮಚ್
10th, 11th June. Serial number 28, Nayak Jai.
For the appellant.
11th June.
Plaintiff suit, my lord, the plaintiff appeal.
Yeah.
Suit is a recovery of
11th June.
recovery of possession, my lord, suit is
Based
dismissed.
on title, I know.
It is not title, my lord, only the suit for possession. Only the observation made in the Palupatti of the executed by the father and this dependent plaintiff's husband, that proper, but there was no title regarding to the family, my lord, because the one originally one Lakshmamma has the one.
Possession ಅಂತಾರೆ ಇಲ್ಲಿ ನೋಡಿದ್ರೆ ಇದು ಬೇರೆ ಇದೆ ಇಲ್ಲಿ.
ಇಲ್ಲ, possession ಕೇಳಿದ್ರು.
ಇದು ಬೇರೆ ಕೊಟ್ಟಿದ್ರೆ ನೋಡ್ರಿ ಫೈಲು. ಚಂದ್ರಶೇಖರ್ 28 ಕೊಡಿ.
Suit for possession filed the appellant on the basis of the sale deed executed on 18/10/2012 by the one originally there's a suit property belongs to the
Emergent notice regarding admission. Call for records. Rajeshwari M.
9, Rajeshwari M.
K. Narayana.
File my counter, my lord, there is a delay, my lord, file counter, it's ready. I'll have it filed, my lord, should have it next week, my lord.
After vacation, Hakoba, please.
Yes, suit is for what?
His suit for recovery of money,
Recovery of money.
ex parte degree, please.
ಇಲ್ಲ, ex parte ಎಲ್ಲ appear ಆಗಿದ್ರು ಹಾಕ್ಲಿಲ್ಲ ಅವರು.
Allah, of course, sir.
Return statement
We have filed the
ಹಾಕಿಲ್ಲ,
wakalat but not contested the matter in view of 90 days elapsed in the return statement. ಹಂಗಾಗಿ
Yes, settlement ಮಾಡ್ಕೊಳ್ಳಿ 4
ಅದೇ
ಲಕ್ಷ.
ಮಾಡ್ಕೊಳ್ತೀವಿ. ಅಮೌಂಟ್ ಕಡಿಮೆ ಇರೋದ್ರಿಂದ 4 lakhs ಇದೆ.
4 ಲಕ್ಷ ಇದೆ.
After
settlement
vacation
ಮಾಡ್ಕೊಳ್ಳಿ.
ಹಾಕೊಂಡ್ರೆ ಮಾಡ್ಕೊಳ್ತೀವಿ. We'll file necessary joint.
Learned counsel for the appellant and seeks time to explore a settlement with the respondent.
Please.
List after vacation, summer vacation. Hari Krishna Pramod,
30, Hari Krishna Pramod.
Rajita. Oh, same thing.
Yes, sir.
Anything else to submit? You have anything else to say?
And nothing more.
Nothing else.
No more.
Nothing?
No, my lord.
Yes, Mr.
Specifically on just the one judgment that my learned friend relied upon on the last date. This is a decision of the Madras High Court, if I'm not wrong. One portion was relied upon by my friend. This is the decision of Singhai Lal Chand Jain, Your Lordships. In that, my learned friend read out one portion. That portion is in fact in my support because the portion that my learned friend read out was that was essentially to say that the decision passed against the association would be binding against its members, and therefore such members could not obstruct the execution of the decree.
Yes.
Therefore, by virtue of that argument, I am affected by the decision that is passed in this matter as well. It is, I am bound by it, and therefore I am before your lordship challenging the decree. So therefore, with respect to maintainability, I have satisfied the requirement that I am an aggrieved person.
Yes. List on date for decree. Don't date put. Sharat is Gowda.
Serial number 51. 51 Sharath is.
Sharat Gowda.
Millards, I appear for appellant, Millards, in this matter. Millards, suit for partition, Millard. Partly allowed, Millards.
Decreed.
Decreed, Millard, partly allowed and
Urgent
decreed.
notice regarding rule.
Millard, small submission, Millard. There is a oral partition which I took place and then.
Stay of drawing up of final decree. However, all proceedings up to final decree shall continue.
That's grateful.
Serial number 32. Nagaraj Shetty.
The
Nagaraj
last of respondent number 1 in this case. Number 6, my lord, I have my wakalat ready, my lord. I'll file it in the office.
Huh?
Respondent 6. I'll file my wakalat in the office. Can I request for next week, my lord, and petition appeal copy may also be directed.
So this matter was heard for some time.
Yes. Yes.
Whom do you represent?
Respondent 6, my lord.
Respondent number?
6.
Who has filed this application?
Respondent 7.
So therefore, why should we hear you?
Question of law, my lord.
Question of law, they have filed the, respondent number 7 has filed the application.
I just seek an opportunity to place my
No,
submission.
what opportunity? You did not file the application. It is their application, we'll hear them. Yes, pass over.
Seek an opportunity, just place my submissions on record.
No, sir. Dispute is between them and.
Yeah, correct. I'm also a family member. No? I'm
So,
also a family member.
Why, what prevented you from filing an application? It is not your application.
Correct.
It is their application. Next, pass over. Parameshwarappa.
Serial number 33. Parameshwarappa MV.
Suit for fair injunction. Trial court dismiss the suit, my lord.
Barkul. BBMP. Issue emergent notice to the respondents regarding rule, call for records.
Injunction application is filed, my lord.
Injunction application ಏನು?
Is interfering with.
Suit is dismissed already, injunction suit. Oh.
I-
Without hearing the other side, how can I grant injunction? Suit is dismissed after a trial. So how can I grant you ex parte order? RB Sadashivappa.
Number 34. RB Sadasivappa.
The caveat respondent.
Suit for bare injunction, my lord. The same is dismissed. As against that, my lord, the present appeal is filed.
Suit is dismissed.
My lord finds here, the suit is dismissed as not maintainable. Kindly see the order on page, my lord, ink page 50, internal page 42.
Page 50.
Ink page 50, 50. Suit filed by the plaintiff against the defendant is hereby dismissed as not maintainable. Solely on the ground they say, because the defendant disputes my title, therefore the suit for injunction is not maintainable. This
What is the
all-
suit property?
only- Sum and substance is only that.
What is the suit property?
Suit for injunction and if the
Vacant land.
Vacant land.
property sites, my lord.
Maintenance
And
status.
we have
for the-
purchased in 2013.
Lord, I'll
Since
have to
then,
satisfy your lordship. I'll try to persuade your lordships on the question.
Admission, this matter.
No,
is-
admission, I'll just satisfy your lordship.
Uh,
Admittedly, my lord, the property is a vacant land. They claim their rights through one Malleshwaram Tailoring Cooperative Society. Admittedly, my lord, this honorable court has held that it is not at all a housing society. I have placed reliance on the same judgment over the trial court. And secondly, my lord, they claim their right through GPA over a GPA. My lord, they have the sale deed of 2014.
Whom are you claiming under?
Lord, I am the absolute owner of the entire land. Survey number 113/1. There's already an injunction order passed by the trial court in my favor. That has attained finality. That was in the year 2002. Some of the representative, my lord, in the year 2002.
Your suit was filed against whom?
against the representative of the society.
Hmm.
They claim from the rights from the society.
Yes.
This court, my lord, has held that the Malleshwaram Tailoring Society is essentially not a cooperative society. If my lords could kindly permit me, my lord, I'll place reliance on that one also. And my lord, the Anantalu Buchirati case, my lord, is clear. Whenever there's a dispute over the title, my lord, the suit for bare injunction is certainly not maintainable. It's my respectful submission.
Now, in which judgment you obtained injunction against the society?
At exhibit D5, my lord, if my lords could see, stand corrected, it's, I'm sorry, my lord, exhibit D1, page 40, internal page 44.
Where is that? Do you have a copy?
My lord,
My lord, their claim is for survey number 113/1 for 3 acres. I am not for land at all. Mine is only small site, 40 by 45, 2 sites club.
No, but you're claiming to the society.
Yes,
Society gang bantu. How did the society get it?
my lord, society has formed a number of sites and sold to various persons.
No, but then it must have been either society, government must have acquired it, or society must have purchased it. How did the society get title? This suit is for injunction based on title. It is not based on mere.
Straight away, I have not purchased from society, my lord.
I think society in the claim ಮಾಡ್ತಿದಿರಲ್ವಾ?
ಅಲ್ಲಲ್ಲ, society ಇಂದಲ್ಲ, society ಇಂದ ಕೊಂಡ್ಕೊಂಡವರಿಂದ ಮತ್ತೊಬ್ಬರಿಗೆ ಮಾರಾಟ ಆಗಿ ನಾವು ಮೂರನೇ.
So ultimately trace your title to the society. How did the society get it?
That, my lord, details are not here. I may say straight away I may submit to the court.
No, then
I respectfully submit is since 2014 when I purchased, my lord, I am there and khata is made in my name in the records of the corporation. I have paid the taxes and everything. I have also fenced it.
Judgment, my lords could
Their claim is not for my sites but for the 3 acres of land.
Yes.
Para 15 of this judgment, my lord, which I just relied upon. Para 15.
You have filed a suit against one Annapurna ಅಥವಾ Nadagowda.
Alala, that judgment, my lord, is the citation which I'm trying to rely upon. Citation. Exhibit D1, my lord, I don't have the copy. I tried to pull out a copy. I don't have the
So
copy.
what is this you are relying upon?
To only show that the society does not exist.
I'm not on that. Where is the decree passed in that OS?
Lord, I don't have the copy today, my lord. I'll produce it tomorrow. If my lords could have it tomorrow.
Admit call for records.
Please.
Yes. Until the next date of hearing, the parties are directed to maintain status quo in respect to the suit real property. Neither the appellant nor the respondent number 1 shall change the nature of the suit real property, and they shall not encumber, alienate, transfer, or part with possession of the suit property in any manner whatsoever.
Please. My lords could fix a date, my lord. It's a short question.
Appeal 2026 appeal, Mr. Paper books to be filed within 8 weeks.
Serial number 35, Satish.
Satish,
suit for partition. Defendant's appeal. But the site in question, my lord, was.
Take out notice, Rangaramu.
Please, ma'am.
Obrena?
Obrene.
The property purchased by the mother, my lord.
Property was
Purchased by the mother.
ಅವ್ರು ಹೇಳ್ತಾರೆ.
Sorry, ma'am.
ಅವ್ರು ಹೇಳಿ.
ಆಯ್ತು ಸ್ವಾಮಿ, ಆಯ್ತು.
ಈ ದಿನ ಲಾಯರ್ಗಳಿಗೆ ಹೇಳ್ಕೊಡೋದೇ ಆಗೋಯ್ತು. ಅವ್ರು ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಮಾಡಿ. Yes, please.
Property was purchased by Lord my mother in the year 1979. My lord, it was allotted by a society. Lord, when my mother was alive, Lord, the sale deed was executed in her favor. Thereafter, my lord, the respondent herein has given her consent for transfer of kata, my lord. Lord, I was an employee working in, my lord, BL. After my retirement, my lord, I have out of my pensionary benefits, my lord, I have constructed the building, and my lord, we are residing there. After the demise of, my lord, my parents, partition was.
Seri settlement ಮಾಡ್ಕೋಬೇಕಲ್ವಾ ಸತೀಶ್? You know what are the strength of your case. Settlement ಮಾಡ್ಕೋಬೇಕು.
strength
ನಿಮ್ ಕೇಸಲ್ಲಿ ಏನು ಇಲ್ಲ ಅಂದ್ಮೇಲೆ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕಲ್ಲ, ನಾನು ಗುದ್ದಾಡ್ತೀನಿ ಅಂತಂದ್ರೆ
30-40 ಸೈಟ್ ಆಯ್ತು ಸ್ವಾಮಿ, ಆ ದಿನದ ಮಾರ್ಕೆಟ್ ಏನಾದ್ರು
ಆಯ್ತು, ಏನೋ ಒಂದು ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ. ನಿಮ್ ಸಿಸ್ಟರ್ ಹತ್ರ ನೋಡಿ, ದ ಮೊಮೆಂಟ್ ಯುವರ್ ಸಿಸ್ಟರ್ ಕಮ್ಸ್ ಅಂಡ್ ಸೇಸ್ ನನಗೆ ಭಾಗ ಕೊಡು ಅಂದ್ರೆ ಕೂತ್ಕೊಂಡು ಆಯ್ತಮ್ಮ ಇಷ್ಟ ತಗೋ ಅಂತ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕು.
I'm aware, my lord, the latest judgment is also, my lord, may go against me.
I hope this is not filed by me. RN ಅಂತ ಇದೇನೋ,
Please, my lord.
is it filed by me?
I request.
2009 ಅಲ್ಲಿ ಸೂಟ್ ಫೈಲ್ ಆಗಿರೋದು. SG ಅಂಜನಾ. I don't know if I am there. I was.
Lord, I have the plaint.
ನೋಡಿ ಯಾರದು RN ಅಂದ್ರೆ?
Ramavirendra N. Rama Virendra N.
He is my colleague, man. I filed the wakalat for them. Along with him, I filed.
ಏನ್ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಿಸ್ಕೋತೀರಾ?
Try ಮಾಡ್ತೀನಿ. But your lordship may give some protection, Lord, till then.
Till then, no, final decree proceedings, final decree not to be drawn ಅಷ್ಟೇ.
Lord, I am aware.
There's nothing to admit in this case. Mother died, leaving behind 2 children. Both of them are entitled to half share. Idರಲ್ಲಿ what is the rocket science involved in this?
Lord, ಮದುವೆ ಟೈಮ್ಗೆಲ್ಲ ಕೊಟ್ಟಿದೀವಿ ಅಂತ
ನೋಡ್ರಿ, ಅದೆಲ್ಲ ಮದುವೆ ಕೊಟ್ಟಿದ್ರೆ ನಾವೆಲ್ಲ ಬರ್ಸ್ಕೋಬೇಕಾಯ್ತು, ಏನೋ ಮಾಡಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ ಒಂದ್ ಏನಾದ್ರು
ಮದುವೆ ಟೈಮಲ್ಲಿ
ಅದು ಕರೆಕ್ಟ್ ಕೊಟ್ಟಿರ್ಬೋದು, ಇಲ್ಲ ಅಂತಲ್ಲ. ಅಣ್ಣ ತಂಗಿ ಕೊಡದೆ ಇನ್ಯಾರು ಕೊಡ್ತಾರೆ?
ಫಾದರ್ ಮದರ್
ಅಣ್ಣ ತಂಗಿ ಕೊಡದೆ, ಅಣ್ಣನೋ ಅಕ್ಕನೋ ವಾಟ್ ಎವರ್ ಅವ್ರು ಕೊಡದೆ
ಅಣ್ಣ
ಇನ್ಯಾರು ಕೊಡ್ತಾರೆ?
everything was given in her favor by means of, Lord.
Therefore, that is why I am saying, when you know the strength of your case, you should sit and settle. ಕೋರ್ಟ್ಗೆ ಬಂದ್ರೆ ಇನ್ನೇನಾಗುತ್ತೆ? ಅವ್ರು ಹೇಳ್ತಾರೆ ಕೋರ್ಟ್ಗೆ ಬಂದಿದ್ದಾರೆ, ಹೈಕೋರ್ಟ್ ಹೋಗಿದ್ರೆ ನಾವು ನೋಡ್ತೀವಿ ಬಿಡು ಹೈಕೋರ್ಟ್ಗೆ ಅಂತ. ಅದರ್ ದನ್ ದಟ್ ಯು ಶುಡ್ ಸಿಟ್ ಅಂಡ್ ಸೆಟಲ್ ಇಟ್. ನೋ, ಇಷ್ಟು ತಗೊಳಮ್ಮ, ಅಷ್ಟು ತಗೋ, ಇಷ್ಟು. ಎಸ್ ಕೀಪ್ ಯುವರ್ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್.
ಆಗ್ಬೋದು ಸರ್.
ಯಾವತ್ತು? 29th. ಅವ್ರ ಮನೆ ಕಟ್ಕೊಂಡಿದಾರಂತೆ, ಆ ಮನೆ ಒಡೆದ್ಬಿಟ್ಟು ನೀವೇನು ಮನೆ
ಮನೆ ಕಟ್ಟಿ ಗ್ರೌಂಡ್ ಫಸ್ಟ್ ಫ್ಲೋರ್ ಇದೆ. ವಾಟ್ ಇಟ್ ಮೇ ಬಿ, ದೇ ಡೋಂಟ್ ವಾಂಟ್ ಟು ಗಿವ್ ಎನಿಥಿಂಗ್ ಟು ಮೀ.
ಯಾವತ್ತು ಕರೆಸ್ತೀರ ಹೇಳಿ?
The problem is JPA order is her husband is there. I will call her.
ಯಾವತ್ತು?
29th ಸ್ವಾಮಿ. 29.
29 ತುಂಬಾ ದೂರ ಆಯ್ತು. 24th.
Try ಮಾಡ್ತೀನಿ.
24 list on 24th to explore a settlement between the parties.
She is not well. She is not in a position to move.
ಆಯ್ತು, ಗಂಡನ್ ಕರೆಸ್ರಿ. ಇದೆಲ್ಲ ಗಂಡ ನಡೆಸ್ತಿರೋದು ಕೇಸು.
ಹೌದು, ಗಂಡ.
ಅವ್ರ ತಂಗಿ ಏನ್ ನಡೆಸ್ತಾರಲ್ಲ, ಗಂಡ ನಡೆಸ್ತಿರ್ತಾನೆ.
She has not even, Lord, entered into a witness box.
That is why I told you. It is the husband who will be shadow boxing.
And Lord, one additional factor would be, Lord.
ಆಯ್ತು, ಬರ್ಲಿ, ಅವತ್ತು ಇಟ್ಕೊಳ್ಳಿ. Yes, next.
36 ರಾಮಮೂರ್ತಿ
BV ರಾಮಮೂರ್ತಿ.
ಅಲ್ಲಿವರೆಗೂ some protection.
24 ಫೈನಲ್ ಡಿಗ್ರಿ ಆಗುತ್ತಾ?
ಇಲ್ಲ.
Yes.
My lord, I prefer the applied, my lord. Suit filed by the plaintiff is dismissed now.
Not maintained. What is the preliminary issue?
Yes, my lord. Based upon the preliminary issue, my lord, there is. But the suit is, whether the suit is maintainable or not, the suit is not maintainable. My lord, that is, in fact, the learned judge has not considered the pleadings pleaded in the plaintiff, except based upon the pleadings defense taken by the defendant matter. But that's I have specifically stated in the plaint, the land was not a.
Take out notice, issue emergent notice to the
Meanwhile, interim order, my lord. I got a benefit in the trial court, my lord.
ಏನ್ entry ಮಾಡಿ, is it?
Not to demolish, not to demolish.
ಏನಿದೆ photo ತೋರ್ಸಿ.
That I have, my lord, that I got a marked.
ಏನಿದೆ ತೋರ್ಸಿ, ಪ್ರಾಪರ್ಟಿ, ಸೂಟ್ ಪ್ರಾಪರ್ಟಿಲಿ ಏನಿದೆ ತೋರ್ಸಿ.
Along with that, I have produced the photographs in the trial.
You produce the photographs and make a request.
Yes.
List on date ಕೊಡಿ. ಅಥವಾ ಬಿಡಿಯಾಗ ಯಾರ ಪೇರ್ ಆಗ್ತದೆ, ಯಾರು ತಗೊಳ್ಳಿ. ಮಿಸ್ಟರ್ ಯಾರಿಗೆ? Mr. K. Krishna is directed to accept notice for the respondent.
Please.
List on ಯಾವತ್ತು ಬೇಕು?
Any date, my next week.
30th ಅಲ್ಲ 30th 30th April.
Please. Much obliged.
For further
Yes.
dictation, serial 37, VB Shivakumar.
ಅದು ಹೇಳಿ, ಅದೇನು ಸ್ವಲ್ಪ ಚೇಂಜ್ ಇತ್ತಲ್ಲ, ಸ್ವಲ್ಪ ಹೇಳಿ ಅದೇನು. Yes, Mr. What is the consequence if you have not filed the suit in respect of the property which was the subject matter of the will?
Yes.
So, and you filed an application to insert that property later.
Yes, ma'am.
So what is the consequence?
Earlier it was left out because when the suit was filed, the defendant one was very much alive.
No, but you look at the suggestion made
Yes,
to the plaintiff,
yes,
sorry, to the defendant.
yes,
A suggestion contextual nodi, your conduct of not filing a suit
yes,
in respect of this property
yes.
and later filing an application to implement or to include this property
Yes.
gives an impression that you knew about the will executed by your father.
No. In fact, in the year 2015, when they filed the additional written statement, they speak
The
about.
first item number
Item 2,
item number 2 ನ ಯಾವಾಗ include ಮಾಡಿದ್ದು ಕೊಡಿ, LCR
interlocutory application is filed.
ಕೊಡಿ. The trial court has commented upon that.
Yes. No. ಅಯ್ಯೇ ಅದೊಂದು film ಮಾಡಿದ್ರು. Art, judgment and decree. For including, adding the. IA number 3 was filed.
When?
IA number 3 was filed on 23/7/2013.
23?
23/7/2013.
At what stage of the suit was this application filed?
It was, no, evidence was not yet commenced.
Evidence?
Was not yet commenced.
Evidence was commenced on 17/3/21.
17/8?
17/3/21.
17/3/21.
3/21.
See, thereafter, my lords, after I implemented this property, on subsequently on 5/10/2015, they filed additional written statement wherein they say that on the very same day, another will was executed by the father, bequeathing property to the mother. But the trial court has made a categorical observation that how can there be two wills on the very same day? The will they have officialized is the will made and executed jointly by the defendant number 1 and the father Linganna.
Yes.
See here, that observation is made, additional written statement, my lords would get in the file. Anyway, I am giving this.
there is a clear observation in this. So readily available.
Third is
Third
good.
Kindly turn to the page 2, my lords. Page 2, first line. During the lifetime, the residing in scheduled property, along with the defendants and made and executed a will dated 25/1/2026 to 2006, bequeathing the same to the defendant number 1, and after the demise of Linganna on 25/1/2011, item number 2 scheduled property had been was the absolute property of the defendant number 1, and who got the Khata tax transferred to the Khata to their name on the basis of the said will. This is what they say in 2000.
Will produce Madilla.
Willu produce Madlilla, Khatanu produce Madlilla. That is the observation made. My respectful submission is to show that these wills are created dated 25/1/2006. This first defendant was defendants were very well aware that there is a will executed by Linganna in favor of Lingamma, but they don't produce this will. Later, they introduce another will in the year 2021, as if on the very same date, both Lingamma and Linganna executed the will, because this perhaps they created because to show that the gift deed executed by the first defendant in their favor is correct, because by virtue of this will, she became absolute owner of the property. Therefore, my respectful submission is the whole story viewed by them that there is a will in respect of item 2 property is falsified. My lords may kindly see in the impugned order, the learned judge has picturized all these things. They create 2 wills, and the evidence of the defendant number 2 and 3, that is attesting witnesses that this will was with me till 2021, and I gave the will only in the year 2021. Kindly see how sequentially they have created this story, only to deny me share in item 2 property, nothing else. This is the absolute property of Linganna, allotted by housing board, and he died intestate, and all the legal heirs succeeded to the property. This is way back in 2015, this statement. At paragraph 29, the learned judge has discussed about this, 29 of the judgment.
He gifted 5/3/2012 is in respect of item number 1, is it?
Item 2.
Item number 2.
Item number 2.
The consequence is Lingamma at the time when she filed the returns. She said that there is a will. She died. There could not be produced a will so far as earlier will is concerned. It is that later will that was produced as E1.
This is the additional statement filed by all the defendants, not only Lingamma, in the year 2015.
Exhibit E1.
The will which they have officialized is signed by both Lingamma and Linganna. This additional statement is perhaps because they claim that the Lingamma has executed gift deed in their favor. They must have thought, how can Lingamma execute gift deed when she is not the owner, because Linganna alone purchased that property. Therefore, they have created will of 25/1/2000. two wills on the same day. Therefore, they have claimed here in 2015 that the will was executed by only Linganna in favor of Lingamma.
Yes.
That is a clear case of creation.
I think if you take only that will, 25/1/2006 executed by Linganna
Yes,
in favor of these defendants 2 and 3.
yes,
One suggestion you have made in the cross-examination
yes,
of the attesting witnesses,
yes.
saying, entado,
She was. ಅವರನ್ನ ಹೇಳ್ದೆ ಅಂತ ಕೇಳೋದು.
ಅಲ್ಲ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗೋ ಏನೋ ತದೇಕಚಿತ್ತವಾಗಿ ಏನೋ ಅಂತ ಅಂದ್ರಲ್ಲ ಏನೋ ಒಂದು ಸೆಂಟೆನ್ಸ್.
Suggestion is wrong, my lords. That suggestion should not have been made. But nevertheless, my lords may kindly say.
ತಟಸ್ಥರಾಗಿದ್ರು ಅಂತ ಏನೋ ಅಂದ್ರಲ್ಲ.
ಅದಲ್ಲ.
ಹಾ?
It's a question that was.
ಹಾ.
The trial court has.
ಲಿಂಗಮ್ಮ ಹೇಳ್ದಂಗೆ ಅವ್ರಿಗೆ.
The trial court has categorically explained the suspicious circumstance under which this will has come into existence.
Suspicious circumstance ಏನು?
Suspicious circumstance ಅಂತಂದ್ರೆ 2006 will 2011 ನಲ್ಲಿ ಸತ್ತೋಗ್ತಾನೆ. 2020 ವರೆಗೂ where was it? Nobody knows. And here in 2015 they say that there was another will executed by Linganna. Where is it? Where is it?
15 ಅಲ್ಲ.
15 ನಲ್ಲಿ ಹೇಳಿರೋದು. 2020 additional written statement was filed in 2015. ಅದರೊಳಗೆ ಹೇಳ್ತಾರೆ 25/1/2006 ಅಲ್ಲೇ ಲಿಂಗಣ್ಣ ವಿಲ್ ಮಾಡಿದ್ರು ಅಂತ. ಅದು ಎಲ್ಲಿ ಅಫಿಷಿಯಲೈಸ್ ಮಾಡ್ಲಿಲ್ಲ. ಆಮೇಲಿಂದ ಬೇಸ್ಡ್ ಆನ್ ವಿಚ್ ಖಾತಾ ವಾಸ್ ಟ್ರಾನ್ಸ್ಫರ್ ಟು ದಿ ನೇಮ್ ಆಫ್ ಲಿಂಗಮ್ಮ ಅಂತಾರೆ. ಆ ಖಾತಾನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿಲ್ಲ. ವಾಟ್ ಇಸ್ ದಟ್ ದೇ ಹ್ಯಾವ್ ಸೆಡ್? ವೇರ್ ಇಸ್ ದ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಅಂಡ್ ಆಲ್ ದಟ್. ಲೇಟರ್ ಇನ್ 2021 ದೇ ಫೀಲ್ಡ್ ಅನದರ್ ವಿಲ್ which is signed by Lingamma and Linganna. Therefore, the gift deed executed by Lingamma has no value because Lingamma was nobody to the property. It is the absolute property of Lingam. Therefore, that.
What about the will 25/6/2001? ಲಿಂಗಮ್ಮರವರು ಆ ಸಮಯದಲ್ಲಿ ಗಂಡನ ಮಾತನ್ನು ಕೇಳಿಕೊಂಡು ತಟಸ್ಥರಾಗಿದ್ದರು ಎಂದರೆ ನಿಜ.
ಹೇಳ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳಿದ್ದಾರೆ. My lords are very well aware. Sometimes a suggestion.
ಲಿಂಗಣ್ಣವರು ಮೃತ್ಯುಪತ್ರವನ್ನು ಟೈಪ್ ಮಾಡಿಸಿಕೊಂಡು ಬಂದಿದ್ದರು. ಅದನ್ನು ಅವರು ನನಗೆ ಓದಿ ಕೇಳಿದ್ರಿಂದ ನಾನು ಅದನ್ನು ಓದಿ ಲಿಂಗಣ್ಣವರಿಗೆ ತಿಳಿಸಿದ್ದೆ. ಲಿಂಗಮ್ಮರವರು ಆ ಸಮಯದಲ್ಲಿ ಗಂಡನ ಮಾತನ್ನು ಕೇಳಿಕೊಂಡು ತಟಸ್ಥರಾಗಿದ್ದರು ಎಂದರೆ ನಿಜ. ವಿಲ್ ಪತ್ರವನ್ನು ಯಾರು ತಯಾರು ಮಾಡ್ತಾರೆ? ಎಸ್.
ಇದೇನಂದ್ರೆ ಡಿನೇ ಮಾಡ್ಲಿಕ್ಕೆ ಈ ವಿಲ್ ನ ಸ್ಟೋರಿ ವ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇನೆ.
Allah, but his suggestion is not a simple suggestion.
Correct, correct.
See, the fact that Lingamma was there along with the father is admitted.
Yes.
The fact that both of them had gone to execute a will is also admitted by this suggestion.
By this
is not a innocuous suggestion, Allah.
It's an isolated suggestion.
Isolated, but not an innocuous suggestion. This gives so many insights into how the family conducted itself.
Yes.
ಲಿಂಗಮ್ಮರವರು ಆ ಸಮಯದಲ್ಲಿ ಗಂಡನ ಮಾತನ್ನು ಕೇಳಿಕೊಂಡು ತಟಸ್ಥರಾಗಿದ್ದರಿಂದ ನಿಜ. ಸೊ ಆ ಸಮಯದಲ್ಲಿ ಅಂದ್ರೆ ವಿಲ್ ಆಗೋ ಸಮಯದಲ್ಲಿ ತಾಯಿ ಗಂಡನ ಮಾತು ಕೇಳ್ತಿದ್ರು ಅಂತ ನೀವು ಹೇಳ್ತೀರಿ. ಆ ಸಮಯ ಅಂದ್ರೆ ಏನು? ವಿಲ್ ಮಾಡುವ ಸಮಯದಲ್ಲಿ ದೇರ್ ಆರ್ ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸಸ್ ಹೂ ಸೇ ಹೌದು ವಿಲ್ ಮಾಡಿದ್ ನಿಜ, ನನಗೆ ಗೊತ್ತಿರೋರವರು ಕರ್ಕೊಂಡು ಹೋದ್ರು, ಮಾಡಿಸಿದ್ರು ಎಲ್ಲ ಹೇಳ್ತಾರೆ. So what is the suspicious? The only suspicious circumstance that I can see is that this will was not in the custody of the defendants 2 and 3.
Yes.
It was in the custody of one of the witnesses to the will. So the Lingappa died. Lingappa thane, what's his name?
Linganna.
2011. 2011 ತೀರೋಗಿದ್ದು. But ಇವರು
22 years they could not produce it, is the observation.
Observation. ಆಮೇಲೆ ಇನ್ನೊಂದೇನಂದ್ರೆ their own conduct in filing this written statement shows that this will is suggestions are wrong. I have no second word about it. Kindly see their conduct in the additional written statement also, my lord.
And it is also, please consider, it is not unnatural for a father to say, let my sons live in my house. It is not unnatural for a father to say.
That is what we are also saying. Father used to tell, let them live. That is the reason why we suggested that you give that property, we are going to leave this property to you. That
ಸರಿ ಅದು ಪ್ರಾಪರ್ಟಿ ಅದು ಅದ್ರಲ್ಲಿ ಭಾಗ ಆಗುತ್ತೆ,
ಹೌದು.
ಅದರಲ್ಲಿ ಭಾಗ ಮಾಡ್ಕೊಳ್ಳಿ. ಇನ್ನೊಂದು ಐಟಮ್ ನಂಬರ್ 1 ನಲ್ಲಿ, ಐಟಮ್ ನಂಬರ್ 2 ನಲ್ಲಿ ಲೆಟ್ ಇಟ್ ಗೋ ಟು ದ 2 sons.
Oh my lords, because they have done all these things only to deceive their share.
Yes.
3 ಜನಕ್ಕೆ ಆ ಸೈಟ್ ಇದಾಯ್ತು ಅಂತಂದ್ರೆ ಇದು ಇಬ್ರು ತಗೋಬಹುದು. My learned friend also.
That is a via media.
My learned friend also
If
suggested.
it's a, that is a via media.
Yes.
ಅಷ್ಟು ಬಿಟ್ರೆ ಇನ್ನೇನಿಲ್ಲ.
ಅದು ಏನಂತಂದ್ರೆ to put an end to this ಇದು, my learned friend told me on that day, yes, we are ready to part with the other side, we will stay here ಅಂತ ಹೇಳಿದ್ರು ನನ್ಗೆ.
What he said was,
Yes.
we'll take a share in the other property also. We'll
No,
pay
no.
additional 5 lakhs. I told you correctly.
No. What he told me was, ಅದ್ರೊಳಗೆ ಒಂದ್ ಸಣ್ಣ ಪೀಸ್ ಬಿಡ್ಲಿಕ್ಕೆ ಆತ ಇಲ್ಲ, ಅವ್ರು 3 ಜನ ಭಾಗ ಮಾಡ್ಕೊಂಡು ಅವ್ರು ಇರ್ತಾರೆ ಅದ್ರೊಳಗೆ ಅಂತ ಹೇಳಿದ್ರು.
ಅದು 50/80 ಸೈಟ್ ಅಲ್ವಾ?
ಹೌದು, 50/80 3 ಶೇರ್ ಆಗ್ಬೇಕು ಅದ್ರೊಳಗೆ. ಸೊ ದಟ್ 3 persons ಕ್ಯಾನ್ ಶೇರ್ ಅಂತ ಹೇಳಿದ್ರು. ಆಮೇಲಿಂದ ಹೇಳಿದ್ರು ಓವರ್ ಅಂಡ್ ಅಬೌವ್ ಏನಾದ್ರು ದುಡ್ಡು ಕೊಡಿಸ್ಲಿಕ್ಕೆ ಆತ ಅಂತ ಕೇಳಿದ್ರು. ಇನ್ ಲಿeu ಆಫ್ ದಿಸ್, ದುಡ್ಡಿನ ವಿಚಾರ ನಾನು ಕೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೆ ಅಷ್ಟೇನೆ. ಅದು ದೇ ಮೇ ನಾಟ್.
ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಎಷ್ಟು ಇರೋದು?
ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ 30-40 ಪ್ಲಸ್ ಬಿಲ್ಟ್ ಹೌಸ್, and it is in a good
The will
location.
says ground floor and the first floor for 2 sons. They wanted the sons to live.
Yes, let them continue to live. We are not standing in their way. ಅತ್ಲಾಗ ಮುಗಿದು ಹೋಗುತ್ತೆ, ಒಂದು ಲಿಟಿಗೇಷನ್ನೇ ಮುಗಿದು ಹೋಗುತ್ತೆ. ನಾವು ಮೊದ್ಲಿಂದನೂ ಅದೇ ಹೇಳ್ತಾರೆ, ನಮ್ಮ ಪಾಡಕ್ಕೆ ನಾವು ಅಲ್ಲಿರ್ತೀವಿ, ನೀವಿರ್ರಪ್ಪ.
ಇನ್ನೊಂದಿರೋದು ಗರ್ವೆ ಬಾವಿ ಪಾಳ್ಯ. ಕಮರ್ಷಿಯಲ್ ರೆಸಿಡೆನ್ಷಿಯಲ್ ಅಲ್ಲೊಂದು 20,000 ಇರ್ಬೋದು ಅಲ್ಲಿ.
ಎಲ್ಲಿ ಎಲ್ಲಿ? ಇಲ್ಲ ಇಲ್ಲ
ಇಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ. ನೋ ಇವನ್ ಗೈಡೆನ್ಸ್ ವ್ಯಾಲ್ಯೂನೇ ಇನ್ನು
ಗವರ್ಮೆಂಟ್ ರೇಟ್ ಅಲ್ಲಮ್ಮ. ಆಯ್ತಾಯ್ತು. ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಎಷ್ಟಿದೆ ಗವರ್ಮೆಂಟ್ ರೇಟು? 6,000.
ಸ್ವಲ್ಪ ಹೆಚ್ಚು ಕಡಿಮೆ ಅಷ್ಟು ಬರುತ್ತೆ.
ಗವರ್ಮೆಂಟ್ ರೇಟ್ 6,000 ಇದೆಯಾ ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಅಲ್ಲಿ?
ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಅಲ್ಲಿ
6,000 ಇಂಟು 600 ಅಡಿ ಅಂದ್ರೆ ಎಷ್ಟಾಯ್ತು? 36 ಲಕ್ಷ ಆಯ್ತು.
600 ಅಡಿ
1200 ಅಲ್ಲ? ಇಬ್ರು ಮಕ್ಳಿಗೆ ಒಂದು ಶೇರ್ ಅಂದ್ರೆ ಆಯ್ತಲ್ಲ. ಇಬ್ರು ಮಕ್ಳು ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡ್ರು 36 ಲಕ್ಷ ಆಯ್ತು.
ಬಿಲ್ಟ್ ಹೌಸ್ ಇದೆ
ಅಲ್ಲಿ ಎಷ್ಟು ಹೇಳಿದ್ರು? 36 ಪ್ಲಸ್ 72
3,450
ಇಂಟು 4,000 1,38,00,000. 3 ಶೇರ್ ಆಗಲಿ.
ಇವರು ಹೆಣ್ಮಕ್ಳು 3 ಜನ
ಡಿವೈಡೆಡ್ ಬೈ 3 46 ಲಕ್ಷ ಆಯ್ತು ಒಬ್ಬೊಬ್ಬರಿಗೆ. ಇನ್ನು 10 ಲಕ್ಷ ನೀವೇ ಕೊಡ್ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಬಿಲ್ಟ್ ಹೌಸ್ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ. ಬಿಲ್ಟ್ ಹೌಸ್ ಇದೆಯಲ್ಲ.
ಬಿಲ್ಟ್ ಹೌಸ್ ಯಾವ ಲೆಕ್ಕ ಇದೆ?
ಆಗ್ಲಿ, ದೇ ಆರ್ ಲಿವಿಂಗ್ ದೇರ್ ರೆಂಟ್. ಸುಮಾರು ನಾವು ಮೀನ್ ಪ್ರಾಫಿಟ್ ಏನು ಇದು ಮಾಡಿಲ್ಲ.
ಆ ಸೈಟ್ ಬಿಟ್ಕೊಡ್ತಾರೆ, ಒಂದು 10 ಲಕ್ಷ ಇಬ್ರು ಕೊಟ್ಬಿಡಿ ಹೋಗ್ಲಿ. ಇಬ್ರು ಸೇರಿ 3 ಜನ ಸೇರಿ 10 ಲಕ್ಷ ಇವ್ರು ಕೊಡಿ. ಆಯ್ತು. ನೀವೇನು ನಿಮಗೆ ಕರೆಕ್ಟ್ ಭಾಗ ಬೇಕಾ? ನಿಮಗೆ ಕರೆಕ್ಟ್ ಭಾಗ ಬೇಕು ಅಂದ್ರೆ ನಾವು ಕರೆಕ್ಟಾಗಿ ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ, ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಕರೆಕ್ಟಾಗಿ ನೀವು ಚಾಕು ಹಾಕಿ ಮಚ್ಚಲ್ಲಿ ಕಡ್ದಂಗೆ ಭಾಗ ಬೇಕು ಅಂದ್ರೆ ಮಚ್ಚಲ್ಲಿ ಕಡ್ದಂಗೆ ತೀರ್ಮಾನ ಮಾಡ್ತೀವಿ, ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್ ತಗೊಳ್ತೀರ ನೋಡಿ. ಆ ದೊಡ್ಡ ಸೈಟ್ ನೀವು ತಗೊಳ್ಳಿ, 5-5 ಲಕ್ಷ ನಿಮ್ಮ ಅಣ್ಣಂದ್ರಿಗೆ 5-5 ಲಕ್ಷ ಕೊಟ್ಬಿಡಿ. ದೊಡ್ಡ ಸೈಟ್ ನೀವು 3 ಜನ ಇಟ್ಕೊಳ್ಳಿ. ಏನ್ ಸರ್? 5 ಲಕ್ಷ 5-5 ಲಕ್ಷನ 10 ಲಕ್ಷ ಕೊಟ್ಬಿಡೋದು. ಅಂತ ಇಬ್ಬರಿಗೂ 5 ಲಕ್ಷ ಅಂತ ಅವ್ರ ಅಣ್ಣಂದರಿಗೆ. ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಅವ್ರು ಇಟ್ಕೊಳ್ಳಿ, 50/80 ಅವ್ರು ಇಟ್ಕೊಳ್ಳಿ. ಎಸ್ ಮೇಡಮ್, ಆಗುತ್ತಾ ಇಲ್ವಾ? ಆಗಲ್ವಾ?
ಆಯ್ತು. ಎಸ್
ಮಾಡ್ಬೋದಾ? ಆರ್ ಯು ಕ್ಲೈಂಟ್ಸ್ ಹಿಯರ್? ಕೇಳಿಸ್ಕೊಂಡ್ರ ನೀವು? ನಿಮ್ದು ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ನೀವು ಇಟ್ಕೊಳ್ಳೋದು, ನೀವು ನಿಮ್ ತಮ್ಮ. ಗರ್ವೆ ಬಾವಿ ಪಳ್ಳಿದ್ದು 3 ಜನ ಅವ್ರು ಇಟ್ಕೊಳ್ಳೋದು, ನಿಮ್ಗೆ 5 ಲಕ್ಷ ಕೊಡ್ತಾರೆ.
ಲಕ್ಷ ಆದ್ರೆ ಅವ್ರಿಗೆ 5 ಲಕ್ಷ, ಅಣ್ಣ ಅವ್ರಿಗೆ 5 ಲಕ್ಷ, ನನ್ಗೆ 5 ಲಕ್ಷ.
ನಿಮ್ಮ ಅಣ್ಣಂಗೆ 5 ಲಕ್ಷ, ನಿಮ್ಗೆ 5 ಲಕ್ಷ.
ತೀರಾ ಕಡಿಮೆ ಆಗೋಗುತ್ತೆ.
ಹಾ,
ತೀರಾ ಕಡಿಮೆ ಆಗಿದೆ. ಯಾಕೆಂದ್ರೆ ನಮ್ಗೆ ಬೇರೆ ಇನ್ಯಾವುದೂ ಸೋರ್ಸ್ ಇಲ್ಲ ಸರ್. ನಮ್ಗೆ ಇರೋದು ನಾವು ಇಟ್ಟಿದ್ದೀವಿ, ಅದೊಂದು ಮನೆ ಇರೋದು ಅಷ್ಟೇನೆ.
ಇವ್ರು ಯಾರು?
ಬ್ರದರ್, ನಮ್ಮ ಅಣ್ಣ. ಅವರು ಏಜ್ ಆಗಿದೆ 69 ವರ್ಷ. ಅವ್ರಿಗೂ ಯಾವ ಇನ್ಕಮ್ ಇಲ್ಲ, ನನ್ಗೂ ಯಾವ ಇನ್ಕಮ್ ಇಲ್ಲ. ಮಕ್ಳಿಗೆ ಮದುವೆ ಮಾಡ್ಬೇಕು ನಾನು. ಈಗ ಇರೋ ಮನೆ ಮಾರ್ಬಿಟ್ಟು ಮಕ್ಳಿಗೆ ಮದುವೆ ಮಾಡ್ಬೇಕಾ, ಓದಿಸ್ತಾ ಇದ್ದೀನಿ ಇನ್ನ. ಈಗ ಅವ್ರಿಗೂ ಬೇರೆ ಯಾವ್ದು ಸೋರ್ಸ್ ಇಲ್ಲ, ಅವ್ರಿಗೂ ಹೇಳ್ತೀವಿ.
ನೋಡ್ರಿ, ಇದು ನೀವು ದುಡ್ದಿದ್ದಲ್ಲ, ನೀವು ಅಪ್ಪ ದುಡ್ದಿರೋದು. ಸೊ ಅವ್ರಿಗೆ ನೀವ್ ಹೆಂಗ್ ಗಂಡ್ ಮಕ್ಳು ಹೆಣ್ಮಕ್ಳಿಗೂ ಹಂಗೆ ಭಾಗ ಇದೆ. ನಾನು ಇದನ್ನೆಲ್ಲ ನನ್ನ ಮಕ್ಳಿದಾರೆ, ನಾನು ಆಸ್ತಿನೇ ಮಾರಾಟ ಮಾಡಿ ನಾನು ಮದುವೆ ಮಾಡ್ಬೇಕು ಅನ್ನೋದೆಲ್ಲ ಇಟ್ಕೋಬೇಡಿ. ನೀವು ಮಕ್ಳು ಮಾಡ್ಕೊಂಡಿದ್ರೆ ಮದುವೆ ಮಾಡೋದು ಅದು ಹೆಂಗ್ ಮಾಡ್ಬೇಕು ನೀವ್ ಯೋಚನೆ ಮಾಡಿ. ಅವ್ರ ಆಸ್ತಿ ನಿಮ್ಗೆ ಯಾಕೆ ಕೊಡ್ಬೇಕು ಅವ್ರು? ಇದು ದುರಾಸೆ. ಇದು
ದುರಾಸೆ ಅಂತಲ್ಲ ಸರ್. ಈಗ ನಮ್ ತಂದೆ ತಾಯಿನ ನಾವು ನೋಡ್ಕೊಂಡವ್ರು 15 ವರ್ಷದಿಂದ. ಅವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತಂದಾಗೆಲ್ಲ ನಾವೇ ತಾನೇ ಕಾರಣ, ನಾವೇ ಮಾಡ್ಕೋಬೇಕಲ್ಲ ಅದೆಲ್ಲ. ಮಾಡ್ತಾರೆ ಅವ್ರೇ ಅವ್ರ ಮನೇಲಿ ಅವ್ರ ಗಂಡ ಮಕ್ಳು ಜೊತೆ ಚೆನ್ನಾಗಿದ್ದಾರೆ.
ನೋಡ್ರಿ, ಅದಕ್ಕೆಲ್ಲ ಕಾನೂನಲ್ಲಿ ಅವಕಾಶ ಇಲ್ಲ. ಕಾನೂನಲ್ಲಿ
ಗಂಡ್ ಮಕ್ಳು ಬಲಿಪಶುಗಳಷ್ಟೇ.
ಮುಂದಿನ ಜನದಲ್ಲಿ ಗಂಡ್ ಮಗ ಹುಟ್ಟಬೇಡಿ.
ಖಂಡಿತವಾಗ್ಲೂ ಹೆಣ್ಮಕ್ಳ ಜೊತೆ
ಹುಟ್ಲೇಬೇಡಿ ನೀವು. ಒಂದು ಕಲ್ಲಾಗೋ ಯಾವಾಗೋ ನರಿಯಾಗೋ ಹುಟ್ಟಿ ಸುಮ್ನೆ ಆಗೋದನ್ನ ಮಾತಾಡ್ರಿ. ವಾಟ್ ಇಸ್ ದಿಸ್? ಆಗೋದನ್ನ ಮಾತಾಡಿ.
ನಾವು ಏನೋ ಒಂದು ಅದಕ್ಕೆ ಒಂದ್ ಸ್ವಲ್ಪ ಇನ್ವೆಸ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ವಿ, ಏನೋ ಒಂದು ಅದ್ರಲ್ಲಿ ಒಂದಷ್ಟು ಸಿಗುತ್ತೆ ಅಂತ ನಾವು ಅಷ್ಟೇ. ನಾವೇನ್ ಪೂರ್ತಿ ನಮ್ಗೆ ಬೇಕು ಅಂತ ನಾವ್ ಯಾವತ್ತೂ
ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದೀರಾ?
ನಾವೇನೂ ಇಲ್ಲ ಸರ್. ಆ ಸೈಟ್ ಅಲ್ಲಿ ಒಂದ್ ಭಾಗ ನಮ್ಗೆ ಕೊಡ್ಲಿ, 4 ಶೇರ್ ಮಾಡ್ಕೊಳ್ಳಿ, 3 ಶೇರ್ ಅವ್ರು ಇಟ್ಕೊಳ್ಳಿ, 1 ಶೇರ್ ನಮ್ಗೆ ಕೊಡ್ಲಿ ಅಂತ ನಾವ್ ಕೇಳಿದ್ವಿ.
ಆಯ್ತು. ಅಷ್ಟೇನಾ? ಸೊ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್. ಸಸ್ಪಿಷಿಯಸ್ ಸರ್ಕಮ್ಸ್ಟಾನ್ಸಸ್ ನಿಮ್ಮ ಮನೇಲೂ ಭಾಗ ಕೊಡಿ, ಸೈಟಲ್ಲೂ ಭಾಗ ಕೊಡಿ. ಹಂಗೆ ಮಾಡ್ಕೊ. ಹಂಗೆ ಮಾಡೋದಾ?
ಮಾಡಿ ಸರ್, ಹಂಗೆ ಆಗ್ಲಿ. ಯಾಕಂದ್ರೆ ಅವ್ರ ನಮ್ಮ ತಂದೆ ತಾಯಿಗೆ ಶಾಂತ ಸಿಗ್ಬೇಕಾದ್ರೆ ಅದಾಗ್ಬೇಕು. ಆ ಹೆಣ್ಮಕ್ಳಿಂದ ಮನೆ ಆಕ್ಷನ್ ಹಾಕ್ಸ್ಬೇಕು, ಸೇಲ್ ಮಾಡ್ಬೇಕು. ಮಾಡ್ಲಿ.
ಏನ್ ಬುದ್ಧಿ ಇದೆಯೋ ಬುದ್ಧಿ ಇಲ್ವೋ? ಯಾಕ್ರಿ
ಸರ್, 1 ನಿಮಿಷ. ನಮ್ಮ ತಂದೆದು 3 ಸೈಟ್ ಇತ್ತು. ನಮಗೆ ಗೊತ್ತಿದ್ದಾಗ ಎಲ್ಲ ಸೈಟ್ ಮಾಡಿಸಿ ಅವ್ರ ಸೈಟ್ ತಗೊಂಡ್ರು, ಮನೆ ಮಾಡ್ಕೊಂಡ್ರು. ಅದು ನಮಗೆ ಗೊತ್ತಿಲ್ಲ. ಅದಕ್ಕೆ ನಾವು ಪ್ರೂಫ್ ಕೊಡೋಕೆ ಸಾಧ್ಯ ಇಲ್ಲ.
ಎಲ್ಲರ ಹೆಸರು ಮನೆಗಳಿದೆ ಸರ್. ಅವ್ರ ಹೆಸರು ಎಲ್ಲರ ಹೆಸರು ಮನೆ ಇದೆ. ಯಾರ ಹೆಸರಿದೆ ಸೈಟ್ ತಗೊಂಡು ಮನೆ ಇರೋದು? ಅದನ್ನ ಕೇಳಿ. ನಿಮ್ಮ ಹತ್ರ ಮಾತಾಡ್ತಿಲ್ಲ, ನಾನು
ಅಲ್ರಿ. ಪ್ರೂಫ್ ಪ್ರಮಾಣಕ್ಕೆಲ್ಲ ಹೋಯ್ತು, ಅದೆಲ್ಲ ಪ್ರಮಾಣದ ಬೆಲೆ ಎಲ್ಲ ಹೋಯ್ತು. ಪ್ರೂಫ್ ಎಲ್ಲಿಂದ ಹುಡ್ಕೊಂಡ್? ಪ್ರೂಫ್ ತೋರ್ಸುತ್ತ ನಂಬಕ್ಕಾಗೋದು? ನೀವು ತೋರ್ಸಿದ್ರೆ ನಾವು ನಂಬೋದು. ನಮ್ದು ಇಲ್ಲ, ನಮ್ಮ ಅಪ್ಪ ಒಂದ್ ಸೈಟ್ ತೆಗ್ದಿದ್ರು, ಎಲ್ಲ ಒಂದ್ ಕಡೆ ಇತ್ತು ಅಂತ ಅಂದ್ರೆ ಎಲ್ಲಿತ್ತು, ಯಾರಿತ್ತು, ಹೆಂಗಿತ್ತು?
ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ನಮ್ಮ ಹತ್ರ. 3 ಸೈಟ್ ಇದ್ದಿದ್ದು ಎಲ್ಲ ಮಾಡಿಸಿ ಎಲ್ಲ 3 ಜನ ಕಿತ್ಕೊಂಡಿದ್ದಾರೆ. ನಮ್ಮ ಮೇಲೆ ಇದ್ದಿದ್ದೆಲ್ಲ ಕಥೆ ಹೇಳಿ ಕಿತ್ಕೊಂಡಿದ್ದಾರೆ.
ಎಲ್ಲಿತ್ತ ಸೈಟು?
ಸೈಟ್ ಇತ್ತು ಸರ್, ತಂದು ಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ. ಪ್ರಾಪರ್ಟಿ ಡಾಕ್ಯುಮೆಂಟ್.
ಅಲ್ರಿ, ಭೂಮಿ ಮೇಲೆ ಎಲ್ಲಿತ್ತು ಅಂತ ಹೇಳಕ್ಕಾಗಲ್ವಾ?
ಅವರು ಕನಕಲೆ ಒಟ್ಟು ಪದ್ಮನಗರ ಒಂದ್ ಸೈಟ್ ಇತ್ತು ಸರ್. ಇನ್ನೊಂದು ಅಬ್ಬಾಯಿ ನಾಯ್ಡು ಚೌಟ್ರಿ ಇದ್ದಿತ್ತು ಸ್ಟುಡಿಯೋ, ಅಲ್ಲೊಂದಿತ್ತು.
4 ಸೈಟ್ ಆಯ್ತು ಇವಾಗ. 4 ಸೈಟ್ ಆಯ್ತು
ಸರ್. ನಮ್ಮ ತಂದೆ ಸೈಟ್ ತಗೋತಾ ಇದ್ರು, ತಗೊಂಡು ಒಂದ್ ಸ್ವಲ್ಪ ಬೆಲೆ ಬಂದು ಮಾರ್ಬಿಡೋರು. ಆ ಬಂದಿದ್ ದುಡ್ಡು ಒಂದು ನಮ್ಮ ಹತ್ರ ಉಳಿತಾ ಇರಲಿಲ್ಲ. ಎಲ್ಲ ಇವ್ರ ಸೈಟ್ಗಳು ಬೇಕು, ಮನೆಗಳು ಕಟ್ಸ್ಕೋಬೇಕು. 3 ಜನದ ಹೆಸರಲ್ಲೂ ಮನೆ ಇದೆ, ಅವ್ರ ಹೆಸರಲ್ಲಿ ಮನೆಗಳು. ಅವ್ರ ಗಂಡಂದ್ರು ಬಿಡಿ, ಅದನ್ನ ನಾವು ಕೇಳಕ್ ಬರೋದಿಲ್ಲ. ಇವ್ರ ಹೆಸರಲ್ಲಿ ಇರೋದು ಹೆಂಗೆ ಸರ್ ಅದು? ನಮ್ಮ ಹೆಸರಲ್ಲಿ 1 ಅಡಿ ಜಾಗ ಬೇರೆ, ಈ ಮನೆ ಬಿಟ್ಟು 1 ಅಡಿ ಜಾಗ ಅಂತ ಪ್ರೂಫ್ ಮಾಡ್ಬಿಟ್ರೆ ನಾವ್ 2 ಬಿಟ್ಟು.
ನೀವೇ ಮತ್ತೆ ಏನ್ ಮಾಡ್ತಿದ್ರಿ? ಮತ್ತೆ ದುಡಿದೆ
ನಮ್ಮ ಹತ್ರ ಇರೋ ಮಕ್ಳು ಓದ್ಸೋದೇ ಆಯ್ತು ನಮ್ಮ ಕಥೆಗಳು.
ಅದು ನಿಮ್ ಕರ್ಮ, ಅದೇನ್ ಮಾಡಕ್?
ಅದೇ ಬಂದಿದೆ ಅಷ್ಟೇ. ಯಾಕಂದ್ರೆ ನಮ್ಗೆ ಇನ್ನೇನ್ ಬೇರೆ ಏನಿಲ್ಲ. ಇವ್ರುಗಳಿಗಾದ್ರೆ ಈ ಕಡೆ ಅಪ್ಪನ ಮನೆಗೂ ಕಳ್ಸ್ಬಿಡೋರು. ಮಕ್ಳು ಸ್ಕೂಲ್ ಸ್ಟಾರ್ಟ್ ಆಯ್ತು ಅಂದ್ರೆ ಅಪ್ಪನ ಮನೆಗೆ ಬಂದು ಸೂಟ್ ಕೇಸ್ ಎತ್ಕೊಂಡು ಅಡ್ಮಿಷನ್ ದುಡ್ಡು ಬೇಕು. ಮನೆ ಕಟ್ತಾ ಇದೀವಿ ದುಡ್ಡು ಬೇಕು, ಸೈಟ್ ತಗೋತಾ ಇದೀವಿ ದುಡ್ಡು ಬೇಕು. ಎಲ್ಲ ನಾಟಕ ಸರ್. ಬರೀ ನಾಟಕ ಸುಳ್ಳು. ಏನೇನು ಇಲ್ಲ ನಾವು ಈ ಮಟ್ಟಕ್ಕೆ ಬರಬಾರ್ದಾಗಿತ್ತು ನಾವು ನಿಜವಾಗ್ಲು. ನಾವು ಈ ತರ ಎಕ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿಲ್ಲ ನಾವು ಕೋರ್ಟ್ ಬರ್ತೀವಿ ಅಂತ ಅನ್ಬಿಟ್ಟು. ಸರ್ ಅದಕ್ಕೆ ನಾವು ಮೋಸ ಮಾಡಬೇಕು ಅಂತಿದ್ರೆ ಸೈಟ್ ನನ್ನ ಹೆಸರು ಮಾಡಿಸ್ಕೋಬಹುದಾಗಿತ್ತು, ನೀವು ಮಾಡಿಸ್ಕೋಬಹುದಾಗಿತ್ತು.
ಅದೆಲ್ಲ ಮಾಡ್ಬೋದಾಗಿತ್ತು, ಆಗ್ಬೋದಿತ್ತು, ಹೋಗ್ಬೋದಿತ್ತು, ಬರ್ಬೋದಾಗಿತ್ತು. ನಿಮ್ಗೆ ಏನ್ ಎಲ್ಲಿತ್ತು ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಸೈಟು, ಯಾವ ಮಾರಾಟ ಮಾಡಿದ್ರು ಗೊತ್ತಿಲ್ಲ, ಸುಮ್ನೆ ಹೇಳ್ತಿದ್ರ ನೀವು.
ಸರ್ ಅದು ತಂದು ಕೊಡ್ತೀನಿ ಸರ್, ಡಾಕ್ಯುಮೆಂಟ್ ತಂದು ಕೊಡ್ತೀನಿ.
ತಂದ್ಕೊ ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಇವಾಗೆಲ್ಲ ಕೊನೆ
ಪ್ರಯೋಜನ ಇಲ್ಲ ಅಂತ ಗೊತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ತಂದಿದ್ದಿಲ್ಲ, ಬೇರೆ ವಿಚಾರ.
ಏನ್ ಮಾಡ್ತೀರಮ್ಮ? ಒಂದ್ ಮನೆ ಮುರಿಯಕ್ ಹೋಗ್ಬೇಡ್ರಮ್ಮ. ಹೆಣ್ಮಕ್ಳಾಗಿ ದಯವಿಟ್ಟು ಮನೆ ಮುರಿಯಕ್ ಹೋಗ್ಬೇಡಿ. ಏನೋ ಒಂದ್ ಕುತ್ಕೊಂಡು ರಾಜಿ ಮಾಡ್ಕೊಳ್ಳಿ. ಇನ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಮಾಡಿ, 20 ಮಾಡಿ. ಆಯ್ತು ಬಿಡಿ, 3 ಜನ ಸೇರಿ. ಹಾ 20 ಲಕ್ಷ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಅಲ್ಲ ಅವ್ರು ಒಪ್ತಾ ಇಲ್ಲಲ್ಲ ಅವರು. ಆಯ್ತು 20 ಲಕ್ಷ ಕೊಡಿ, ಒಂದು ಸ್ವಲ್ಪ ಟೈಮ್ ತಗೊಳ್ಳಿ. ಓ ಥ್ಯಾಂಕ್ ಯು ಫಾರ್ ಅಡ್ವೈಸಿಂಗ್. ಏನಾಯ್ತು ಬರ್ಕೊಳ್ಳಿ. ನೋಡಿ ಆಮೇಲೆ ನೋಡಿ ಹೇಳ್ತೀನಿ ಕೇಳಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದ್ಮೇಲೆ ಬಂದು ಅಳಬೇಡಿ, ಗೊಳೋ ಅಂತ ಬಂದು ಅಳಬೇಡಿ. ಆ 20 ಕ್ಲೋಸ್ ಮಾಡಿ ತಗೋತೀರಾ? ಜಡ್ಜ್ಮೆಂಟ್ ಬರೆದ್ಮೇಲೆ ದಯವಿಟ್ಟು ನೀವು ಶಾಪ್ ಹಾಕ್ಬೇಡಿ, ಹೌದಾಯ್ತಾ? 20 ಲಕ್ಷ ಕೊಡ್ತೀರಾ, ಸೈಟ್ ತಕೊಳ್ಳಿ. 3 ಜನ ಸೇರಿ 20 ಲಕ್ಷ ಕೊಡಿ, ಸೈಟ್ ತಗೊಂಡು ಕ್ಲೋಸ್ ಮಾಡಿ. ಎಸ್ ಬರ್ಕೊಳ್ಳಿ. Insofar as the first point for consideration is concerned, the defendants 2 and 3 have propounded a will dated 25/6/2000, 25/1/2006. Exhibit
15 ಮಾಡ್ಬಿಡಿ,
20 ಮಾಡಂಗಿರ್ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ
ಒಂದು 5 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ಟು
ಇಬ್ಬರಿಗೂ 10 ಲಕ್ಷ ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡಂಗಿರ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಬೇಡ. ಎಕ್ಸಿಬಿಟ್
15 ಲಕ್ಷ ಮಾಡ್ತೀನಿ.
ಬೇಡ. The exhibit D1, in terms of which, the suit item number 2 was bequeathed by the parents of the defendants 2 and 3. Full stop. It is necessary to extract a few recitals made in exhibit D1, which explains why the defendant number 1 was also a party, was also one of the executants of the will. The exhibit D1 ಅಲ್ಲಿ ಏನು ದಾರ ಹೊಲ್ದು ಬಿಟ್ಟಿದಾರಲ್ರಿ, ಕ್ಲಾಸ್ ನಂಬರ್ ಇದೆಯಾ ಕೊಡಿ. ಕ್ಲಾಸ್ ನಂಬರ್ ಪೇಜ್ ನಂಬರ್ 3 ನಲ್ಲಿ ಪೆನ್ಸಿಲ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. In proof of the execution, lawful execution of the will, the defendants examined TW1, who purportedly was a junior engineer in the engineering department at BMTC, where the deceased father of the defendants 2 and 3 was working. Full stop. He has deposed about the execution of the will, and also that the father of the defendants 2 and 3 had requested him to attest the will dated 25/1/2006. In his cross-examination, a suggestion was put to DW1, which reads as follows. Page number 7, bold pencil mark. This suggestion is not a suggestion which is made out of context or innocuously. This suggestion establishes the fact that the defendant number 1 was present along with the Linganna as on 25/1/2006 at the time of execution of the will. It also discloses that the instructions to execute the will was given by Linganna, and that the defendant number 1 did not raise any objection over including her name in the will.
I beg your pardon, lords. They are agreeable to pay 20 lakh.
20 lakhs.
Close it.
ತಗೊಂಡು ಕ್ಲೋಸ್ ಮಾಡ್ರಿ. ಯಾವಾಗ ಆಗ್ತದೆ?
They may need some time to pay.
ಯಾವಾಗ?
ದುಡ್ಡು ಕೊಡ್ಲಿಕ್ಕೆ
ಅದನ್ನ ಮಾರಾಟ ಮಾಡಿ ಅದು ಮಾರಾಟದಲ್ಲಿ 20 ಲಕ್ಷ ನಿಮ್ಗೆ ಕೊಡ್ತಾರೆ ಅವ್ರು. ಈ ಮನೆ ನೀವು ಇಟ್ಕೊಳ್ಳೋದು, ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಮನೆ ನೀವಿಬ್ರು ಇಟ್ಕೊಳ್ಳೋದು.
ಗೌರ್ಮೆಂಟ್ ರೇಟ್ ಬೇರೆ ಇರ್ಬೋದು, ಮಾರ್ಕೆಟ್ ರೇಟ್ ಬೇರೆ ಇರ್ಬೋದು.
ನೋಡ್ರಿ 20 ಲಕ್ಷ ನಿಮಗೆ ಕೊಡ್ತಾರೆ. ಅವ್ರು 20 ಲಕ್ಷ ಮಾರಾಟ ಮಾಡಿ ತಂದು ಕೊಡ್ತಾರೋ ಮನೆಯಿಂದ ತಂದು ಕೊಡ್ತಾರೋ ಅದು ನಿಮಗ್ ಬಿಟ್ರಿ. 20 ಲಕ್ಷ ನಿಮಗ್ ಕೊಡೋದು, ಆ ಗರ್ವೆ ಬಾವಿ ಪಾಳ್ಯ ಪ್ರಾಪರ್ಟಿ ಅವ್ರು 3 ಜನ ಇಟ್ಕೊಳ್ಳೋದು, ವಿಲ್ಸನ್ ಗಾರ್ಡನ್ ಪ್ರಾಪರ್ಟಿ ನೀವಿಬ್ರು ಇಟ್ಕೊಳ್ಳೋದು. ಆಗುತ್ತಾ ಬೇಡವಾ?
20 ಲಕ್ಷ ನಮಗೂ ಇಬ್ರಿಗೂ ಸೇರಾ ಅಥವಾ
ಇಬ್ರಿಗೂ ಸೇರಿ ಬೇಡ ಅಲ್ಲ? ಬೇಡ.
ಹಿಂದಿನ ಕೋರ್ಟ್ ಏನಿತ್ತು ಅದೇ ರೀತಿ ಇರ್ಲಿ, ನಾವು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀವಿ.
ಆಯ್ತು, ಹಂಗೆ ಮಾಡಿ. Yes, and the suit appeal is dismissed. Yes. ಬೇಡ ಅಲ್ಲ? ಬೇಡ. Appeal is dismissed. Wait ಮಾಡ್ಕೊಳ್ಳಿ. ಅಂತ ಮಾಡ್ಬೇಕು ಅಂತಿದ್ರೆ ಗೊತ್ತಿಲ್ಲ. ಹಾ? ಹಾ. Yes, list tomorrow.
Please.
Your Lordships, kindly, my lord, I may be pardoned, my lord, for troubling your Lordships. My lord, in serial number 13, where your Lordships directed. May I, my lord, with your Lordships leave? I'm sorry to
Yes,
trouble.
Mr. Anantram.
My lord, serial number 13, your Lordships directed will be listed on 23rd, next Thursday. My lord, that is the day my niece's wedding, my lord, I'll be away. Have it on 22nd or 24th, my lord, I may be pardoned, I'll inform my lord.
25th. We'll take it up on 25th.
Much obliged, my lord, I may be pardoned, my lord.
Please intimate the other side also.
I undertake, my lord, I undertake to inform. Please, my lord. Grateful.
Sir, serial number 30, sir, for dictating judgment, it will come on 25th, sir.
ನಮ್ದು 13 ಸರ್ 13 ಕೋರ್ಟ್ ಆಫೀಸರ್
ಮೊನ್ನೆ ಅದು
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಯಾವತ್ತು ಸರ್?
25 ಹೇಳಿದ್ರು ಸಾಹೇಬ್ರು, ಶನಿವಾರ 25.
ಸರ್ ಇದು ಸರ್ ಸಮ್ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ ಸಾಹೇಬ್, ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ಸೇಮ್ ಇಸ್ ಡನ್ ಅಂತ ಆಗಿರೋದು, ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಇದಕ್ಕೆ.
ಹೌದಾ? ಹಾಗಿದ್ರೆ ಸರಿ, ಡೇಟ್ ಇಲ್ಲದೆ ಅಕಸ್ಮಾತ್ ಹೇಳಿದ್ರು.
Undertake to comply the office objection, and as he has ready to file some applications, list after same is done.
ಅದ ಕೇಳಿದ್ರು ಅವರು, ಇವರು ನವದ್ಗಿ ಅವರು 13 ಸೋಮವಾರ ಅಂದ್ರು, ಆಗಲ್ಲ ಥರ್ಸ್ಡೇ ಅಂದ್ರು. ಥರ್ಸ್ಡೇ
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ಸೇಮ್ ಇಸ್ ಡನ್ ಆಗಿದೆ ಸರ್, ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ ಪ್ಲೀಸ್.
ಆಯ್ತು ಸಾಹೇಬ್ರು ಅಕಸ್ಮಾತ್ ಬಂದ್ರೆ ನಾನು ಇರೋಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಪ್ಲೀಸ್. ಥ್ಯಾಂಕ್ ಯು.
sir. Huh? 39. Legal counsel for the respondent 6 times. Respondent 6 and 7 6 times. Discount sounds. ಯಾವತ್ ಬೇಕೋ ತಗೊಳ್ಳಿ ಯಾವತ್ ಮದುವೆ ಆಯ್ತು ಯಾವತ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಆಯ್ತು ಆಯ್ತು Milan counsel for the appellant submits that he has paid the cost as per the order directs counsel. Yes. 38. An objection is the adjournment again. Yes, Ramesh, the non-compliance model officer. Learn counsel for the appellant seeks discount so and so. I thought Bandang no. Yes. After vacation, but correct, but ಏನು ಮಾಡ್ತೀರಾ partition suit ಇದು. Yes, yes, after vacation. Yes, next. After vacation, judges change ಆಗ್ತಾರೆ, roster change ಆಗುತ್ತೆ. How can I fix the roster for the judge? Next week ಅಲ್ಲಿ ಏನಾಗಲ್ಲ, 2026 appeal. Yes, next. Correct. Four, 2, sir. Ramesha. Why next week? ಏನು offense ಏನು? NDPS. ಏನು ಎಷ್ಟು ಕೇಸ್ ಇದೆ ಫಾಸ್ಟ್? ಒಂದೇ ಕೇಸು. ಕ್ವಾಂಟಿಟಿ ಎಷ್ಟು? 45 ಗ್ರಾಮ್ ಗಾಂಜಾ. ಈಸ್ ಗೌರ್ಮೆಂಟ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದಿರಿ? And the CGP seeks time to file objections. List on so and so. Yavat? After vacation? List after vacation.
List number 1, passed over matter, serial number 6. RB Sadasivappa.
It's a judgment of JM. Yes, sir. So appointment, how is a preliminary issue? How can this be treated as a preliminary issue? Hey, look into it. You already looked into it. I have looked into it. He has looked into it. This order is not. No. ಇವತ್ತು ಮಾಡಿ ಇವತ್ತು ಹೆಂಗೆಲ್ಲ ಕನ್ವಿನ್ಸ್ ಎಲ್ಲ ಏನು ತಪ್ಪಿದು. ವಾಟ್ ಇಸ್ ಅ ಮಿಸ್ಟೇಕ್ ಇಸ್ ಅ ಮಿಸ್ಟೇಕ್, ಮಿಸ್ಟರ್. How can the court treat it as a preliminary issue? Whether the suit in the present form is maintainable in view of the bar contemplated under section 41J of the Specific Relief Act. Whether the suit is maintainable in view of bar contemplated 41H. They are residing in the house. If they are residing in the house, are they not entitled to claim challenge?
Let out the premises to the respondents here.
The gifted deed, one of the condition is delivery of possession. Possession deliver ಮಾಡಿದ ಹೆಂಗಾಗುತ್ತೆ? ಗಿಫ್ಟ್ ಹೆಂಗ್ ಕಂಪ್ಲೀಟ್ ಆಗುತ್ತೆ?
It is the property of the respondent number 1. Wherein the respondent number 1 has gifted the property with, to the respondent number 2.
What is the
And
requirements of a valid gift? What are the requirements of valid gift?
after obtaining the gift deed, I have executed the rent agreement in favor of respondent number 1. And they were paying the rent to me. Thereafter, their differences of opinion among the husband and wife, I am the sufferer. Agagi, I will look into it and kindly, a date may be given in the next date, I will convince this honorable court.
Lata and Rudra Kumar are brother and sister.
But the facts in nutshell is that
Correct.
duly executed the registered the gift deed and it has been
He is an estranged husband. To deprive the wife and the children, he has executed the gift deed.
so far as other disputes are concerned, it is running in between the husband and wife, and he is, as far as I learned, he is paying the maintenance, and there is a divorce proceedings that has been granted.
But how can the suit be dismissed on a preliminary issue, which doesn't go to the root of the matter, jurisdiction in law? There's no issue regarding jurisdiction. How can the court decide the case on preliminary issue?
Next week, I will date for it. I will convince.
ನಾನೇ ಡೇಟ್ ಕೊಡ್ಬೇಕು ಇನ್ಯಾರು ಕೊಡ್ಬೇಕು
ಅಂದ್ರೆ ನನ್ನ ಒಪಿನಿಯನ್ ಏನಿಲ್ಲ ಡೇಟ್ಗೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ.
Interior model.
List on 23rd. Also for the respondent number 2 seeks time. List on 23rd.
Interior model may kindly be.
Interior model granted as an extension to the next.
Great.
Serial number 9. Serial number 9, H.J. Sangvi.
Sangvi.
We have carried out the amendment and copy we are furnishing.
Please come on, merit.
Senior, copy, sir. Senior has requested your lordship to have it on Monday.
I will not adjourn the matter.
No, I request your lordship.
I will not adjourn the matter.
No, I am in the midst, my lord.
Either you argue or I will take the judgment and decide.
Your lordship, I am in the midst. They have appointed senior, according amended copy.
All right.
Kindly, your lordship by Tuesday, he has personally requested
Argue
your
it or
lordship.
I'll ask him to
He has
comment.
personally requested your lordship. They have engaged senior and he said that you filed amended, personally request. Mangalvara hakbidi morning.
On the last day.
Illa tabu cost, whatever I request your lordship. Kindly accommodate on Tuesday, Mangalvara, your lordship.
But cost katti.
Agbodu.
ಎಷ್ಟು 5,000.
ಇಲ್ಲ ಸಾಹೇಬ್. Whatever nominal your lordship.
ಏನು ವಸಂತ್ ಅವರೇ?
Nominal.
24th.
ಇಲ್ಲ Monday, ಮಂಗಳವಾರ.
24th. ಮಂಗಳವಾರ ಇಲ್ಲ. ಮಂಗಳವಾರ it is only for criminal petition. 24th. Check to payment of cost of rupees 2,000 to the
ಅದು amended copy furnished.
Clerks Association.
Maybe listed in admission, my lord. ಕೊಡಿ.
Counsel for the appellant has filed a amended cost title. The same is taken on record. ಅದಾದ್ಮೇಲೆ ಇದು ಮಾಡಿ. List on 24th as a last chance.
Serial number 11, Vinod Kumar M.
M. Vinod Kumar.
It is not maintainable.
Which
I
is
will
the
file.
law? Which is the law?
Section 19 subclause 1 of City Civil Code Act.
City Civil Codes Act. City Civil Codes Act. Have you seen the act?
Yes.
Both
Here, 10 lakhs ಕಿನ್ನ above ಇದು ಮಾಡಿ.
ಯಾವ್ದು ಓದಪ್ಪ ತೆಗಿಯಪ್ಪ ಅದು ಯಾವ ಆಕ್ಟ್ ನೋಡಿ. ಯಾವ ಆಕ್ಟ್ ಅದು?
Sorry, civil code. Civil code.
Full act.
Karnataka Civil Code Act 1964.
What does it say?
It says above 10 lakhs, High Court has jurisdiction, and
Below 10 lakhs, adre?
RA, we need to file a RA
Before?
District Court.
Then what will you do with this?
So we'll withdraw the case.
Cool. File a memo.
Yes.
The memo is filed by the Learned Counsel for the appellant to withdraw the appeal and represent the same before the appropriate appellate court. In view of the memo, the appeal is dismissed. Liberty is reserved to the appellant to file the appeal present the appeal before the appropriate appellate court. The time consumed in pursuing this appeal shall be deducted while calculating limitation before the appropriate appellate court. Office is directed to return the certified copy of the impugned order after retaining a photocopy.
Much obliged.
That is the way you learn.
Yes.
Kaliyad hange. Kaliyad ninge ishtane illa. When you get something, try to get to the bottom of it.
Yes.
That is how you learn.
Yes. Thank you.
Serial number 32, Nagaraj Shetty.
Nimde.
32, sir.
Nagaraj Shetty.
The rejection of claim, suit is for specific performance based on the agreement dated 15/4/1997.
I remember the fact, how held.
The court feels, that matter requires admission, it can be admitted. They did not have the benefit of any interim order.
Order 7 Rule 11 admit ಮಾಡಕ್ಕಾಗುತ್ತಾ? No.
Lord, there is an issue which your lordships may have to consider as to whether an agreement which ex facie is time barred in the teeth of what we have said, by making a subsequent endorsement, whether it would come within the purview of section 18 for the purpose of extension of the limitation period.
You
Therefore, their judgments.
You quoted section 18.
ಅದಕ್ಕೆ ಅದ್ರ ಮಾತು ಅದಕ್ಕೆ ನಾನು
time ತಗೊಂಡಿದ್ದು.
Consideration of section 18 is concerned, there also is because 18 condition precedent to apply 18 is that acknowledgement has to be endorsed. There the limitation is substantial.
Yes.
The limitation is not a question of.
No, the question is whether 18 applies to an agreement.
It applies is the view taken.
Of
There is either one. There are judgments which has taken the view. There is one Kerala High Court judgment, which of course referring to the, it says that it's applicable even in relation to an agreement of sale. Okay.
These questions ultimately requires to be argued. The length only it appears. Because that question requires consideration accordingly. It's a later judgment of the Supreme Court. There is an acknowledgement, whether that acknowledgement is valid or not is a question. If it is not a valid acknowledgement, then section 18 has no application.
No, but the.
Admittedly, 1997 agreement, 11 months is
2000.
stipulated, 3 years expired. After 5 years, expiry after 5 years, there is an endorsement. Endorsement does not refer to requirement under section 63 of the Indian contract. Indian contract section 63 says an extension, express extension is very much required. It is not that it is only a receipt of money, it does not amount to an extension of the right. All these questions will not require consideration according to us.
Detail here, fine layering anta ಹಾಕ್ಕೊಂಡು we will argue.
But you're giving. No, the way you are hesitating to argue, it gives me an impression that you are trying to avoid.
ಏನಿಲ್ಲ ಮುಂದಿನ ವಾರನೇ ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಆಯ್ತು. ಕೇಳಲೇ ಇಲ್ಲ ನಾವು. ಅಲ್ಲ ನಾವು ಕೂತ್ಕೊಂಡು ಒಂದಷ್ಟು ಓದ್ತಾ ಇದೀವಿ.
ಅದು ಅವಾಗಿಂದ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಹುಲಿ ಬಂತು
ಅವ್ರಿಗೂ ಓದ್ತಾ ಇದೀವಿ ನಾವು. ಅದೇ ನಾವು ಬಂತು ನಾವು ನೋಡ್ತಾ ಇದೀವಿ ಒಂದ್ ಸ್ವಲ್ಪ ಇದೆ ಇಲ್ವೇ ಇಲ್ಲ ಅಂತಲ್ಲ. we have also done substantial progress in our ನಾವು
ಈಗ ಯಾರ ಮುಂದಾದ್ರೂ Bowler is inconsequential. How to bat is only the question.
ಓದಿಲ್ಲ.
Only thing is, the admission
ಸ್ಟೇಜ್ ನೊಳಗೆ ನಾವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಕ್ಕೂ
ಅಲ್ಲ,
ಫೈನಲ್
ನಾನು 7 ರೂಲ್ 11 ಎಲ್ಲಾನು ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಕ್ಲೋಸ್ ಮಾಡ್ತಿರೋದು. ಈಗ ನಿಮ್ದು ಒಂದೇ ಅಲ್ಲ, ಮೊನ್ನೆ ಯಾವ್ದೋ ಒಂದು ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಯಾವ್ದೋ ಒಂದು ಮಾಡಿದ್ರು, ಅದನ್ನು ಕ್ಲೋಸಿಂಗ್
ಆಯ್ತು ಅಡ್ಮಿಷನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿ ಗುರುವಾರ
ಯಾವತ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಬಟ್ ಡೋಂಟ್ ಗಿವ್ ಮಿ ದಿ ಇಂಪ್ರೆಷನ್ ದಟ್
ಇಲ್ಲ ಅದಕ್ಕೆ
we do not want to carry the stigma going out from the court. I'm sorry, we are not going. It is not our practice also since from the inception. ನೀವು ತಪ್ಪು ತಿಳ್ಕೊಳ್ಬಾರ್ದು, ರಾಜಗೋಪಾಲ್ ಹೆದರ್ಬಿಟ್ಟು ಮಾಡಿದ್ರು ಅಂತ.
ನೀವ್ ಯಾರಿಗೆ ಹೆದರ್ತೀರ? ನಾವು ನಿಮ್ಮ
ನಮಗೆ ಅನ್ನಿಸ್ತು ಅಂದ್ರೆ ಸೀರಿಯಸ್ ಕ್ವಶನ್ಸ್ ಆಫ್ ಲಾ ಇದೆ ಎಲ್ಲ ಕಾಪಿ ಕೊಟ್ಕೊಂಡು
ಎಂತ ಸೀರಿಯಸ್ ಇಲ್ಲ. ಯು ಆರ್ ಮೇಕಿಂಗ್ ಇಟ್ ಸೀರಿಯಸ್ ಅಷ್ಟೇ.
ಗುರುವಾರ 24
ಇಬ್ರು ಯಾರು? ರಾಜಗೋಪಾಲ್ ಅವ್ರ ಜೂನಿಯರ್, ರಾಜಗೋಪಾಲ್ ಜೂನಿಯರ್, ಇಬ್ರಿಗಿಂತ ಇನ್ನೇನ್ ಬೇಕು?
ಶಿಪ್ ಆಫ್ ದ ಓಲ್ಡ್ ಬ್ಲಾಕ್. ಆಯ್ತು, ನೀವು ಯಾವತ್ ಬೇಕಾದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. But I've indicated my mind that the question whether the subsequent receipt of consideration even after the time prescribed in the agreement, can that be disbelieved by the court while exercising power under Order 7 Rule 11A?
No, this is not disbelieved by the court. The court says even if that date is taken into consideration.
11 ading madak barutte.
But now
the court says our renewal date ತಕೊಂಡ್ರು 11 months ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅಂತ. How can you say?
The reason
ಏನ್ ಹೇಳಿದ್ರು ಅಂದ್ರೆ ಆ ಪೀರಿಯಡ್ ತಗೊಂಡು ಆ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಡೇಟ್ ಇದೆಯಲ್ಲ, ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಡೇಟ್ 11 months ಪ್ಲಸ್ ಡೇಟ್ ಆಫ್ ಫೈಲಿಂಗ್ ಆಫ್ ದಿ ಸೂಟ್ ಎಲ್ಲಾದನ್ನು ಒಟ್ಟಿಗೆ ಕ್ರೋಢೀಕರಿಸಿ ಕೂಡಿ ಗುಣಾಕಾರ ಮಾಡಿದ್ರು ಕೂಡ ಇಂತಾವ 3 ವರ್ಷಕ್ಕಿಂತ ಮೇಲಿದೆ ಅಂತ ಹೇಳಿದ್ರು.
ಹೆಂಗಾಗುತ್ತೆ?
Milords, I put it this way, Milords.
No, he wanted to convey that meaning in the judgment.
In fact, I had suffered one order at the hands of Justice Harinath Tillari, where on similar lines, on similar grounds, the court said that once the time that is agreed upon, if you have extended the time by receiving consideration, then the time being the essence of contract goes.
No difficulty, Milords.
It goes.
No difficulty.
One thing I would like to put it this way. In a normal common sense of this kind of transactions, if a receipt of payment is sought to be entered after the agreement period has been expired, prudent person could have been insisted to write a recital so far as primarily for the extension of time, secondly for the payment is concerned. Therefore, payment and extension of time simultaneously must be the recital in the document. On perusal of the contents of the endorsement, it only refers to the payment of the amount. It does not amount to the extension of time.
List on ಯಾವತ್ತು ಬೇಕು? 23rd, 24th ಯಾವತ್ತು ಬೇಕು?
ಗುರುವಾರ
23rd? 24th is Friday. ಬುಧವಾರ ಇಲ್ಲ, ಗುರುವಾರ ಶುಕ್ರವಾರ.
ಗುರುವಾರನೇ ಇರ್ಲಿ ಸರ್. 23rd ಗುರುವಾರ ಇರ್ಲಿ ಸರ್.
23.
That is the only reason, Milord. We are not, no escaping.
We also tried to find out, Milords, as to whether section 18 could be equated for agreements. That's one.
And arguing before your lordship is a prejudice for us.
ಎಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಹಂಗೆ ಹೇಳ್ತೀರಾ ನೀವು?
Senior ಎಲ್ಲ ಕೋರ್ಟಲ್ಲಿ ಹಾಗೆ ಹೇಳಲ್ಲ. ನಾವು ನೋಡಿದಾಗ ಹೇಳಿಲ್ಲ ಅಂತ.
But unfortunately, I can't go to other courts to say what he says.
First door matter, list number 2, serial number 2.
So, N. Radhakrishna.
N. Radhakrishna. First door matters, list number 2, serial number 2. N. Radhakrishna.
There is no appearance for the petitioner, even though it is called twice in the day. Hence, list after vacation.
Serial number 3, Papi Gowda.
Same order.
List number 1 for final hearing matters. Serial number 38 and 39 are urgent. Serial number 40, Abdul Razak.
Abdul Razak. Satish Chandra. Yeah, settlement.
now ready to take.
ಎಲ್ಲಿ ಸತೀಶ್ ಚಂದ್ರ ಏನ್ ನೀವು ಸೆಟ್ಲ್ಮೆಂಟ್ ಏನ್ ರೆಡಿ ಇದೀರಾ? Mr. Satish Chandra, there is no representation for the respondent number 1 to 3 and 6 to 7. List after vacation.
Serial number 41.
Stay idea. Stay idea. 41.
Nanda Kishore.
The appellant comes.
Hmm.
Sole appellant has passed away. They filed an IA for bringing a last. Same is not being put up.
Office is there put any pending. ತರಿಸ್ಬಿಡ್ರಿ ಅಪ್ಲಿಕೇಶನ್ ತಿರುಗಿನ ಪಾಸ್ ಓವರ್. So V Prabhakar.
Serial number 42. V Prabhakar.
Respondent.
ರೆಡಿನಾ? ಹಾ ಹೇಳಿ. ನೀವು ರೆಡಿ ಅಮ್ಮ? ಬರ್ತಾರಾ? ಹೇಳಿ.
Declaration, permanent injunction and mandate. I have filed a detailed Thursday stating that the schedule is totally different from what the first respondent purchased from Nanjundappa. First appellant's sister sold.
ನೋಡಿ ಫಸ್ಟ್
Exhibit P5.
ಮಿಸ್ಟರ್ ಪ್ರಭಾಕರ್ ಫಸ್ಟ್ ಪ್ಲೈಂಟ್ ಹೋದ್ರಿ, ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಕೇಸ್ ಏನು ಅಂತ. Plaintiff purchased a property from Nanjundappa.
The plaintiff is the owner of the property bearing number 59/1, situated Kadirenapalya, Indira Nagar, Bangalore, bounded on east by 23 feet and north to south 25 feet, and 5 feet common passage. The common passage 23 to 5 feet, east to west 23 and north to south 5 feet is the disputed passage, and the same will be called hereinafter and here before the suit should be brought. But my lord, he has stated he purchased when the plaintiff purchased the said property from his vendor Mr. Nanjundappa as per the agreement of sale dated 27/1/1980, and after that sale deed executed on 8/8/1980 and registered on 12/8/1988, the copies of the said deeds are produced. My lord, here they have misrepresented, and the sale deed dated 12/8/1988, that is exhibit P5. Kindly,
ಏನ್ ದಿಸ್ ಇಸ್ ದ ವೇ ಟು ಆರ್ಗ್ಯೂ ಅನ್ ಆರ್ ಎಫ್ ಎ.
then I will read.
ಪ್ಲೈಂಟ್ ನೋಡಿ, ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಡಿ, ದಟ್ ಇಸ್ ಹೌ ಯು ಡೂ ಆರ್ಗ್ಯೂ ಅನ್ ಆರ್ ಎಫ್ ಎ.
Next page. The plaintiff submits that the father of the defendant number 1 and 2 was purchased the property from his vendor in the year 1958 through registered sale deed. The certified copy of the sale deed is produced for kind produce of the sum report and marked as document number 2. Now the same is Khata number 59/1. The measurements of the property was east to west 46 feet and north to 30 feet. On west to east, more or less 5 feet is for to enter into the property. The father of the defendant number 1, and 2 purchase the property starting from east to west. This the father of the defendants was purchased the property in Khata number 59, and 2 years later, because there is no road or access to Khata number 59,
Then the plaintiff submit that the father of the defendants died, leaving behind his legal heirs 3 sons and 2 daughters. The brothers and sisters of the defendant amendment divided their property in Kata number 59 and the release deed dated 16/8/1984. Said release deed registered in Shivajina sub-register as document number 1449, book number 1. The certificate of the release deed is produced from trade period of the Sarn as document. He submitted that Kata number 59/1 was spelled in the name of the sister of the defendant number 1, Velliamma and Vakyu. The plaintiff submitted that the sisters of the first defendant, among them divided the property through registered partition dated 17/8/1984. The Kata number 59/1 admeasuring east-west 46 feet and north 25 feet and 5 feet common passage from north to south and east-west 46 feet as per the site plan registered number 1480/8485 dated 27 in volume 29 page 6 sub-register. The copy of the site plan is produced for claim period of the Sarn and document number 4. At the eastern side of the Kata number, at the eastern side of the Kata number 15 was spelled in the name of Bhagyavati and the western side of the property was spelled in the name of the Villiamma, the second defendant case. The property divided as per the registered partition as document number 1480, volume 2350, book number 1, before Shivaji Nagar sub-register planning. The certificate copy of same is produced for 8 people of this honorable court as document number 5. The plaintiff has no idea about the Kata number 59 and their exact measurement of their partition. The plaintiff know the Natarajan and Ganeshan are acquired the property through partition in Kata number 59. It is submitted that as per the partition deed and the release deed, site plan agreement of sale in Kata number 59/1 as per the scheduled property was east to west 46 feet and north 25 feet and 5 feet common passage. Then it was divided also east to west 23 feet and north to south 25 feet and 5 length common passage. The plaintiff submitted that as per the release deed and partition deed, the common passage was left to the sisters of the defendant only up to their exact their mission. It is submitted that the sister of the defendant, para 6, it is submitted that the sister of the defendant, Vakyavati, sold her property to Mr. Manjundappa through registered sale deed as document number 1090, volume 2624, number dated 16/7/1987. The said sale deed certified copy is produced herewith and marked as document number 6. Then the plaintiff submits that the boundary mentioned in the sale deed is correct. The plaintiff submits that the boundary mentioned in the sale deed is correct, but to the common passage is concerned, the boundaries are wrong. It was reduced 5 feet to 3 feet on eastern side and on western side 5 feet to 1 and 1.5 feet. The plaintiff submitted that the common passage east to west 5 into 46 feet. The plaintiff submitted that remaining portion of common passage was encroached by the first defendant by constructing the building on the suit schedule property. The plaintiff submitted that as per the above deed, the plaintiff vendor and plaintiff, there was 2 common passage on east to west and north to south. The north to south common passage was encroached by P. Ganeshan and Saliamma by collusion with first defendant. By that time, the second defendant has not taken any steps against them because there are brothers. The common passage was them in the defendant number 2 to the suit sale date 1958 from west to west or less 5 feet, and from north to south it starts from Janardana's building up to the main road. It is submitted that defendant number 1 deliberately put up construction on common passage and door. There are 10 houses are situated in Kata number 59 and 59 and 58, and there is a main road in existing there. Except the first defendant, nobody are put up door on south side. The defendant number 1 unauthorized the put up construction. The plaintiff had given complaint to the commissioner BCC, that is third defendant here, and copy of the division police and 2/1/1991. The copy of the endorsement is produced here with and marked as document 7. The plaintiff submitted that Mr. Janardhan already constructed the building by leaving off-feet setback in his property on his south side, admitting 46 feet east to it. The same is north side of the plaintiff and second defendant property. If the plaintiff measures his property from north south by leaving off-feet, the suit schedule property will come less than 1.5 feet. Admittedly, the plaintiff cannot claim or write the off-feet, which is the setback area of Mr. Janardhan. It is submitted that when the plaintiff purchased the property from Ninjunappa, again the property came on the same measurement. There are all with the collusion bring out a new common passage which is not existing from their vendor. The plaintiff and second defendant property in Kata number 59/1 is existing behind the first defendant's property, and P. Ganeshan, the first defendant of the second defendant in Kata number 59, and the suit property comes in the middle of the plaintiff and the defendant 1 and P. Ganeshan. The plaintiff submits that there was a 6 feet and north-south drainage is existing on east side of the plaintiff's property, but here also the first defendant put up one toilet on the place of the drainage. Therefore, only 2.5 feet is left for the plaintiff to get into his property on his eastern side. The suit schedule property is left only the use of the second defendant and the plaintiff not for the defendant 1 as per the partition deed, release deed and site plan and other documents. Admittedly, the plaintiff property comes in the middle of the defendant and Mr. Janardhan and east by drainage. For this reason, there was no access to the plaintiff when the common passage encroached by the defendant number 1 by 3 feet on eastern side and 1 feet 1.5 on western side. The first defendant is put up to Sajja and door in and remaining place of common passage. Therefore, the suit schedule property completely encroached by the defendant. The plaintiff submits that when there is no common passage to the plaintiff and the third defendant has no granted kata in the name of the plaintiff, the plaintiff filed appropriate application to the third defendant. The copies of the application is produced as documents. After the several attempts were made for getting kata, but when the third defendant comes to the spot for inspection, the first defendant made their objections. Therefore, kata is still not granted. The BCC is asking the plaintiff that there is no east-west passage on earlier deeds and records. As per the earlier deeds, there was a common passage from north-south. Without the permission of the corporation, 2 feet passage was showing in the present sale deed. Therefore, the sale cannot be accepted as per the rules of the city corporation. Therefore, the kata is not granted in the name of the plaintiff since from 1980. The second defendant has not put up any construction on her property. Therefore, the plaintiff is using that property to walk around the plaintiff's property. He submits that if the second defendant constructs the house in her property, without any 5 feet passage from east to west and east to west. The plaintiff has no access way to enter to his property either from eastern side or from western side. He submitted that the first defendant filed a suit in OS number 5243 of 2001, CCH number 15, against the plaintiff without making his sister as a party to the said suit. He submitted that the defendant claiming the easements against the plaintiff, the said suit is still pending for consideration. It is submitted that as per the above pleadings, the entire common passage was encroached by the defendant one, and he is asking the easements from the defendant when it is come up for final argument. The Honorable Court has appointed the court commissioner to take measurements of the common passage. The court commissioner was filed his report, and his report has shown encroachment and remaining portion of the passage. There is a sajja and door of feet of jar. The certified copies of the suit documents are produced and marked as documented. The plaintiff issued notice and an apology to the third defendant, and the same was served on the defendant number 3 to effect the kata in his name. As on the date of filing of the suit, the plaintiff has not received any reply from the defendant number 3 to the notice. The office copy of the notice posted to the acknowledgements are produced as document number 10. The plaintiff has made out a prima facie case against the defendant, and the balance of evidence lies in favor of the plaintiff. Hence, prejudice will be caused to the plaintiff if the suit is not defeated. It is submitted that the cause of action suit is arose, and when the plaintiff filed his counterclaim on the passage, the Honorable Court is permitted to file a suit on his claim on the property on 33/2000. The said order copy applied at 12/4/2005 and ready on 5/2/2005, received on 9/10/2005. The second defendant came on the property to construct without leaving passage on 5/10/2005 and has sent notice to the plaintiff on 39/2005. The plaintiff replied to the said notice dated on 19/10/2000. The plaintiff issued notice to third defendant on 26/10, served on 29/10/2000. Therefore, the suit has been filed. The suit is in time, and the plaintiff has not filed any other suit against the defendant. It is submitted that the suit is valued as per the Karnataka suit valuation separate, then amended portion. The plaintiff submitted during the pendency of the suit, the defendant number 1, with the collusion of other defendants and with the help of the police, has constructed the wall on the eastern side of the suitable property. Here, eastern side, there is a separate property. Boundary is separate. But he has said, I have constructed, there is no other. Eastern side of the suitable property, the said wall is constructed on the covered lineage of 6 feet. It was constructed during the pendency of the suit in OS number 2014 filed by the defendant to take advantage of the passage at its length from east to west to cover up the mistake of defendant one. The suit in OS number 2014 of 2000 was dismissed, and the counterclaim of this plaintiff and his brothers are allowed, restraining the defendant one and his agents from interfering in the written statement scheduled property. When the plaintiff opposed the construction of the compound wall by the defendant one was filed the police complaint and lodged the FIR against the plaintiff and his brothers. The police were keep the plaintiff and his brothers in the police station. At that point in time, the defendant number 1, by taking law in his hand, has completed the construction of the compound wall illegally. The defendant 1 is nothing to do with suitable property. The defendant plaintiff has purchased the eastern side, the plaintiff has purchased the eastern side of property in Kada number 59/1. The defendant one has admitted that his construction in Kada number 59 is not as per his site measurements. Hence, he want to take undue advantage of all the authority to struck the plaintiff in the middle of the road. The defendant number one was encroached east side of the drainage and north side of the common passage, which was existing in Khata number 15 and put up construction on it. The way of entry to the plaintiff is blocked by the defendant number one. The other defendants have not taken any steps against the defendant one, even though there were several letters issued by the plaintiff to the PBMP. The plaintiff is not in position to handle the defendant number one as he was ex-Veda. The rights of the defendant one is restricted to his property at Khata number 59. The eastern side of the drainage to take serious steps against the defendant one. There is toilet constructed by the defendant one on the 6 feet covered drainage. The way of entry to the plaintiff is only on the covered passage of 6 feet from south to north. The judgment in OS number 2014 of 2006, OS number 5247, and the commission report in OS number 5247 will be supported the above facts. Therefore, in the light of the facts and circumstances of the matter mentioned above, this honorable court may be pleased to direct the defendant to remove the wall, sajja and door on the suit schedule property, common passage as per site plan document number 4. Declare, ratify that the passage as per the document 4 is the common passage as per its measurements to the plaintiff and defendant. Permanent injunction against the defendants number 1 or his successor, restraining them from interfering with the common passage. Direct the third defendant to effect Khata in the plaintiff as per sale rate. Award costs, additional price. Direct the defendant number 1 to remove the obstruction, that is compound wall 25 feet from north to south to the southern side main road constructed by the defendant 1 on the eastern side of the suit. It is constructed during the pendency of the suit. If the defendant 1 failed to do so, Director BBMP defendant number 3 to take the necessary steps to remove the compound wall with the sole costs from the defendant. This is the suit and scheduled. You are kindly scheduled.
Yes.
Here, the schedule is not existing as per their sale. Kindly, all the piece and parcel of the common passage, measuring east to west 23 feet and north to south 8 feet, situated at 59/1, Kadirappa, Kadirenapalya, Indira Port, Bangalore 5600. Bounded on. Your Honor, kindly, bounded, there is no drainage on eastern side. That is what it has purchased. Sale rate. Under sale rate, boundaries are totally different from what boundaries they have given in time. Your Honor, kindly exhibit, they have produced exhibit P5, Your Honor, kindly. Exhibit P5.
Yes.
Sale rate.
Yeah, 92 feet.
Your Honor, kindly, exhibit P5 under which he purchased. What he has purchased, Your Honor, may kindly one. Your Honor, may kindly see exhibit P5, page number. Page number 247. 247, exhibit P5. The first respondent purchased the property from one Nanjundappa. My appellant sister sold to Nanjundappa. This is the boundaries. Your Honor, my kindly exhibit P5 is the sale deed dated 8 August 1988. Sale. Here, kindly.
Exhibit P31 first. Exhibit P31.
Exhibit P3. P3.
Check ಬಂದು ಏನು ಓದಿ.
Exhibit P3 same.
Schedule ಓದಿ sir.
Same exhibit P3 is the Nanjundappa's property.
Schedule ಓದಿ. Schedule ಓದ್ರಿ. Schedule.
Your Honor, may kindly 238 schedule. East by Kanta's property. Here in Plain, they have given drainage. Then west by Vimalamma's property.
Villiyamma's property.
Villiyamma's property, their sister's property. Then north by Janardana's property. South by Common Place.
2 feet into 3.5 feet.
That there is no dispute. We never disputed, and also we have blocked, and the court has ordered mandatory.
So, ivaga decree ಇದೆ.
He has claiming on eastern side the drainage passage 5 feet into Sambam, but we have no
decree ಅದು ಓದ್ರಿ. Decree ಅದೇನಕ್ಕೆ 2 feet by 3.5 feet ಕೊಟ್ಟರು decree.
ಆಗಿದೆ. ಅದರ ನಮ್ದೇನು ಉಳಿದಿಲ್ಲ. 3 feet, whatever passage is there, measuring east to west 2 feet, 2 feet, west 3.5 feet, length 23 feet. This passage alongside the scheduled property is common passage both for the purchasers and the house of Sri Nanjundappa number 59, and passage beyond the scheduled property is also common for ingress and out.
Please.
This is there is no degree has also passed.
Alva.
I never interfered for this.
Yeah.
Only a court has directed to remove the 2 feet construction, but I never constructed in drainage.
ನೋಡ್ರಿ ದಕ್ಷಿಣಕ್ಕೆ ಕಾಮನ್ ಪ್ಯಾಸೇಜ್ measuring east side 2 feet, west side 3.5 feet. Length is 23 feet.
That there is no dispute.
Alva.
I have also.
ಸ್ವಲ್ಪ ತಡೀರಿ. Come to the decree. Decree ಬನ್ನಿ. Come to the decree. the decree order.
Suit of the plaintiff is decreed in part. The passage measuring east to west 23 feet and north south towards eastern side 2 feet and towards western side 3.5 feet. Running east to west in between the property, the plaintiff and defendant 1 is declared as a common passage private to be used by the plaintiff and defendant 1.
What is the mistake?
I have no dispute.
So order portion paragraph number 1.
I have no dispute.
You go to the next paragraph.
Next. The defendant 1 is hereby directed by way of mandate injunction to remove the sajja. Here, my lord, this is the defendant number 1 is hereby directed by way of mandatory injunction to remove the sajja projection formed by way of Kadapa block tiles and cement sheets on the doors and windows situated in the northern side wall of the defendant 1, causing obstructions to the enjoyment of the passage situated towards the southern side of the property of the line within 1 month on or before 28. The building constructed in the year 88-89. It is not constructed by the respondent. They were constructed long back. Even though I have advised my party to remove all obstructions, whatever the small passage. Then the next one, further dependent, but here the mandatory injunction is not normally in 88 matter. They have filed a suit in 2020. Already in evidence has clearly stated that in 87, 88 we have constructed of the first respondent's building and also the second respondent also. While constructing, they leave, that is the land belongs to them, they leave little. And by tripartite agreement was also entered between them at the time of purchasing the suitable property by the Nanjundappa. Only they have to claim this passage, not more than that. That is also agreed. Then we have no, only here, Your Honor, the dependent, further dependent one is hereby directed by way of mandate to remove the compound wall. I never constructed, my evidence is also clear.
If you are not constructed, then why do you worry about the decree?
This evidence is also very clear.
ನೋಡಿ ಶೂಟ್ ಡಿಕ್ರಿ ಮಾಡೋದು 2 ಅಡಿ ಪೂರ್ವಕ್ಕೆ ಪಶ್ಚಿಮಕ್ಕೆ 3.25 ಅಡಿ ಉದ್ದ 23 ಅಡಿ ಶೂಟ್ ಡಿಕ್ರಿ ಮಾಡೋದು ಅದು ಸೇಲ್ ಡೀಡಲ್ಲೂ ಹಂಗೆ ಇದೆ. ಸೊ ಸೇಲ್ ಡೀಡಲ್ಲಿ ಇರೋದಕ್ಕೆ ನಿಮ್ಗೇನು ಅಭ್ಯಂತರ ಇಲ್ಲ, ನೀವೇನು ಕಟ್ಟಿಲ್ಲ ಅಲ್ಲಿ. Therefore, how is it affecting the decree? How is it affecting you? How does the decree affect you?
But here they have
ಆ 2 ಅಡಿ ಇಂಟು 3 ಅಡಿನಲ್ಲಿ ಮೇಲ್ಗಡೆ ಸಜ್ಜ ಏನೋ ಕಟ್ಟಿದಿರಂತೆ, ಅದು ತೆಗಿರಿ ಅಂತ ಹೇಳ್ತಾರೆ.
ಎವಿಡೆನ್ಸ್ ಏನೋ ನಮ್ಮ 88 ನಾವು ಕಟ್ಟಿರೋದು ನನ್ನೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ. ಅವ್ರು ಏನ್ ಹೇಳಿದಾರೆ, ಹೈಟ್ ನಲ್ಲಿ ಇದಿದೆ ಅಂತ ಇವ್ರು ಕಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಎವಿಡೆನ್ಸ್ ನಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಾನೇನು ಕಟ್ಟಲಿಲ್ಲ, ನಾನು ಕಟ್ಟಿರೋ ಹಳೆ ಮನೆಯಲ್ಲಿ ಇದ್ದೀನಿ, ತೊಂದರೆ ಆದ್ರೆ ನಾನು ಬೇಗ ಚೇಂಜ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದೀನಿ. ತೊಂದರೆ ಏನನ್ನ ತೊಂದರೆ ನನ್ನ ತಲೆಗೆ ಇದಾದ್ರೆ ಅದು ತಂದ್ಬಿಟ್ಟು ಇದು ಮಾಡೋದು.
ಅಂದ್ರೆ ತಲೆಗಾದ್ರೆ ತೆಗಿತೀನಿ ಅಂತ ಅಲ್ಲ, ತಲೆ ಹೊಡ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ತೆಗಿತೀನಿ ಅಂತ ಹಿಂಗ.
3 ಕೇಸ್ ಮುಂದೆ ಹಾಕಿದ್ದಾರೆ, 3 ಕೇಸ್ ಡಿಗ್ರಿ ಆಗಿದೆ, 4ನೇ ಕೇಸ್.
If it's a common passage, if it is a common passage, you cannot construct, he cannot construct. If you have constructed, remove it. ಅಷ್ಟೇ ಹೇಳ್ರು. So how are you affected by the judgment?
ಇದು ಅವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ನನ್ನ ಪ್ರಾಪರ್ಟಿ ನಾನೊಂದು ಇದೆ ಬಾತ್ರೂಮ್, ಅದು ಇದು ತಗೊಂಡು ಅದು ಹೊಡಿಬೇಕು ಅಂತ ಅವರೇ ಹೇಳಿದ್ರು. ಇದು ತಗೊಂಡ್ ಬಂದ್ರೆ ಆ ಟೈಮ್ನಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅದು ಹೊಡಿಬಿಡೋದು. ಈಗ ನಾನು ಇದು ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಅವ್ರು ಬಂದ್ಮೇಲೆ ಹೊಡೆದ್ಬಿಟ್ಟು ತೊಂದರೆ ಆಗ್ತದೆ, ನಾನು ಹಾಕ್ದೆ. ಇನ್ನೇನು ಅವ್ರಿಗೆ ಹೇಳಿದೆ ನಾವು, ಇಟ್ ಈಸ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ಕೂತ್ಕೊಂಡು ಸೆಟಲ್ ಮಾಡ್ಕೊಂಡು ಕೋರ್ಟ್ರು ಹೇಳಿದೆ, ಏನಾನ ಇದೆ ಅವ್ರಿಗೆ ಇಲ್ಲಿ ಕಡಬಾಕಲ್ಲಿ ಇದೆ, ಅದು ಬೇಕಾಗಿದೆ ಆರ್ಡರ್ ಮಾಡ್ಕೊಳ್ಳೋಣ, ಚಿಕ್ಕದ ಹಾಕ್ಸ್ಬೋದು.
ಎಸ್ ಮೇಡಮ್.
ಬಟ್ ಇದನ್ನಲ್ಲಿ ನಾನು ಕಟ್ಟಲಿಲ್ಲ. ಡ್ರೈನೇಜ್ ಅವ್ರಿಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
ಡ್ರೈನೇಜ್ ಬಗ್ಗೆ ಡಿಕ್ರಿನೇ ಇಲ್ಲ ಸರ್. ಯಾಕೆ ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋದು? ಡ್ರೈನೇಜ್ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ ಡಿಕ್ರಿ? ಡಿಕ್ರಿ ಇದೆಯಾ? ಮತ್ತೆ ಸುಮ್ಮನೆ ಯಾಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಿ? ಅದೇ ನೀವು ಫೈಲ್ ನೋಡ್ಕೊಂಬರಲ್ವೋ? ಸುಮ್ಮನೆ ಇದೆ ಅಂದಾಜ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರೋ? ಡಿಕ್ರಿ ಇಸ್ ಓನ್ಲಿ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದ ಪ್ಯಾಸೇಜ್ ಸರ್.
ನೆಕ್ಸ್ಟ್
ಎಲ್ಲಾದ್ರೂ ತೋರಿಸಿ, ಓದಿ ಎಲ್ಲಿ ಬೇಕಾದ್ರೂ.
Directed by a mandate to remove the compound wall measuring 2 feet situate toward the eastern side of the passage. ನನಗೂ ಅದು ಸಂಬಂಧ ಇದೆ.
ಡೋಂಟ್ ವರಿ,
ನಾನು ಕಟ್ಟಲೇ ಇಲ್ಲ, ನನಗೆ ಸಂಬಂಧ ಇಲ್ಲ.
ಅವ್ರು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೋತಾರೆ. ಇದ್ರೆ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತಾರೆ, ಇಲ್ದಿರೋದನ್ನ ಎಲ್ಲಿ ಹೊಡಿತಾರೆ?
ರಿಮೈನಿಂಗ್ ಇಷ್ಟು
ಇಲ್ದಿರೋದನ್ನ ಎಲ್ಲಿ ಹೊಡಿತಾರೆ? ಕಟ್ಬಿಟ್ಟು ಹೊಡಿಬೇಕಷ್ಟೇ.
ಇದಕ್ಕೆ ಎವಿಡೆನ್ಸ್ ಇದೆ, ಪ್ರೂವ್ ಮಾಡಲಿಲ್ಲ. ನಾನು ಓದ್ತೀನಿ.
ಆಯ್ತು, ಓದಿ.
ನಾನು ಈ ಪೋರ್ಷನ್ ನನಗೆ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡೋದು, ಮಿಕ್ಕಿದ ಯಾವ್ದು ಇದು ಈ ಪೋರ್ಷನ್ ಪೇಜ್ ನಂಬರ್ ಇವರ ಕೈಂಡ್ ಆ ಪೋರ್ಷನ್ ಮಾತ್ರ ನಾನು ಹೇಳಿದ್ದೆ, ಟ್ರಯಲ್ ಕೊಟ್ಟು ಹೇಳಿದ್ದೆ. ಪೇಜ್ ನಂಬರ್ 93 ಜಡ್ಜ್ಮೆಂಟ್ ಫೈಂಡಿಂಗ್. ನೈಂಟಿ ಒನ್ನಿಂದ ಕ್ಲಿಯರ್ ಆಗಿದೆ ನೋಡಿ. 91 ತಗೊಳ್ಳಿ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 91.
Yes, please come to the commissioner's report. Please come to the commissioner's report.
ಕಮಿಷನ್ ರಿಪೋರ್ಟ್ ನಮ್ಮ ಕೇಸಲ್ಲಿ ಅಲ್ಲ ಅಪಾಯಿಂಟ್ಮೆಂಟ್. ಯಾವ್ದೋ ಕಮಿಷನರ್ ಯಾರ್ದೋ ಕೇಸಲ್ಲಿ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿ ನಮ್ಗೆ ಹಾಕಿದ್ದಾರೆ. ಅದು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿ ಅವ್ರು ಬರಲ್ಲ ಅಂತ ಇದು ಮಾಡಿದ್ದಾರೆ. ಇದರಲ್ಲಿ 91 ನಲ್ಲಿ ಒಂದೆರಡು ಪೇಜ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 91.
Hmm.
91 judgment.
Yes, please.
It is true to suggest that since 1988, from the date of my purchase till filing of this suit in the year 2000, I have not filed any suit claiming the passage to be measuring as 5 feet. Witness volunteered that since all the sites were vacant sites, no one had raised any objection. When the defendant has raised the objections, I have filed this suit. Then I do not possess any document to show that passage situated towards southern side of the property, bearing number 59/1, measuring 5 feet. After my purchase in the year 1999, witness volunteered that prior to my purchase, one Nanjundappa had agreed to sell the present property to me. In the said agreement, he had stated that the said passage measuring 5 feet. I have not produced the said agreement executed by Nanjundappa. As for PW1, plaintiff contends that he is not having any document to show that the passage situated in between his property, eastern side of the property. ನಾನು ಕಾಂಪೌಂಡ್ ಕಟ್ಟಿದ್ದೀನಿ, ನಾನು ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಅಂತ ಹೊಡಿಬೇಕು ಅಂತ. ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ and the property of the defendant property measures 5 feet, but he is having an agreement executed with vendor Nanjundappa in his favor to show that the said passage measures 5 feet, but he has not produced the same. Further, the plaintiff contends that right from his purchase till filing of will has not claimed that the said passage measuring 5 feet. Further, as per the cross-examination of PDO at page number 18, para number 3, line numbers 1 to 3, which reads as, it is true to suggest that boundaries shown in Exhibit P5, said dated 8/8/19, and the boundaries of the suitable property do not tally with each other. These boundaries not tally the plain sheet.
Yes.
Then as per PD1, plaintiff admit that the boundaries of the suit schedule passage shown in the suit do not tally with the boundaries shown in the sale deed dated 8/8/1980, by virtue of which has purchased eastern half portion of property number 59/1 along with passage situated towards its southern side. Coming to this is the evidence. This evidence page environment 98 denied by my 98. That is the evidence. ಸರಿ ಸುಮಾರು 81-82ರಲ್ಲಿ ಕಟ್ಟಿದ್ದೀವಿ. ಆ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿರೋದು ಇವರು ಡೆಮಾಲಿಷ್ ಮಾಡಿ ಆರ್ಡರ್ ಮಾಡಿರೋದು. 81-82 ಅಲ್ಲಿ ಕಟ್ಟಿದ್ದೀವಿ. ಆ ಸಂದರ್ಭದಲ್ಲಿ ನಮ್ಮ ತಂದೆ ಜೀವಂತವಿರಲಿಲ್ಲ. ಸದರಿ ಸ್ವತ್ತಿನ ನಂಬರ್ 50-90ರಲ್ಲಿ ಹಿಂಭಾಗದ ಕಟ್ಟಡವನ್ನು ನಂಜುಂಡಪ್ಪ ಮತ್ತು ಈ ದಾವೆಯ ವಾದಿ ಖರೀದಿಸಿದ ನಂತರ ಕಟ್ಟಲಾಗಿದೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ.
Yes, madam, why don't you bring a colleague? You ask a colleague to come. ದಯವಿಟ್ಟು please exhibit P. Come to exhibit P10, P11, P12, P13 ಬನ್ನಿ. ಬನ್ನಿ ಅಲ್ಲಿಗೆ ಹೇಳ್ತೀನಿ. Please come to the P10. It's an admitted document. Photograph ಬನ್ನಿ.
ಈ ಫೋಟೋಗ್ರಾಫ್ಸ್ಗೂ ನಮ್ಮ ಸಂಬಂಧನೇ ಇಲ್ಲ. ಈ ಫೋಟೋಗ್ರಾಫ್ಸ್
ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ಇದನ್ನ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ನೀವು?
ಈ ಕೇಸ್ನಲ್ಲಿ ನಾವು ಆಗಿರೋದಲ್ಲ, ಬೇರೆ ಕೇಸ್ನಲ್ಲಿ ಆಗಿರೋದು.
Please come to page 140 of the judgment. You accepted this photographs. ನೀವೆಲ್ಲ ಸರಿಯಾಗಿ ಓದ್ಕೊಂಬನ್ನಿ ಪ್ರಭಾಕರ್ ಅವರೇ, ದಯವಿಟ್ಟು ಓದ್ಕೊಂಬನ್ನಿ. ಎಲ್ಲ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತಾನೆ ಇದ್ದೀನಿ, ಬಟ್ ನೀವು ರೆಡಿಯಾಗಿ ಬರ್ತಾ ಇಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಎಲ್ಲೆಲ್ಲಿದೆ ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ, ಬಟ್
ನೀವು ಎಕ್ಸಿಬಿಟ್ P10, 11, 12, 13 ಓದ್ಬಿಟ್ರೆ ನಿಮ್ ಕೇಸ್ ಏನು ಅಂತ ಕ್ಲೀನ್ ಆಗಿ ಅರ್ಥ ಆಗುತ್ತೆ.
ಅದ್ರ ಬಗ್ಗೆ ಎವಿಡೆನ್ಸ್ ಇದೆ, ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದ್ರ ಬಗ್ಗೆ
ಪೇಜ್ 140 ಆಫ್ ದಿ ಪೇಪರ್ ಬುಕ್ ಬನ್ನಿ.
140.
As per this
144.
140.
Further, as per exhibit P10 and exhibit P13, positive photos, it can be seen that sajja portion on the said door and the window is put with Kadapa block stone tiles, which is coming on the said passage, which amounts to encroachment by the defendant one on the said passage. Thus, apprehension of injury or belief on the part of the plaintiff, coupled with the intention of the defendants to do certain act, which harm the plaintiff, amounts to interference by the defendants. Since the act apprehended by the plaintiff and intended by the defendant is such that if completed, give a ground for action, there is a foundation for the existence of jurisdiction. Thus, it amounts to interference. Hence, I am of firm opinion of the plaintiff has to prove that to prospect or apprehension and belief coupled with the intention of the defendant.
Para 43 ಬನ್ನಿ ಇವಾಗ. Para 43, page 138.
43.
138 ಪೇಜು.
Coming to the ocular evidence of the defendant number 1, more specifically cross-examination of DW1 at page number 8, para 15, line number 1-7, which reads as ಈಗ ತೋರಿಸಿದ 4 ಫೋಟೋಗಳಲ್ಲಿ ಪಿಂಕ್ ಬಣ್ಣದಿಂದ ತೋರಿಸಿದ ಸೊತ್ತು ನಮ್ಮ ಸೊತ್ತಾಗಿರುತ್ತದೆ. ನಮ್ಮ ಸೊತ್ತಾಗಿರುತ್ತದೆ.
ಆಯ್ತು, ಮುಂದೆ ಓದಿ.
ಮತ್ತು ಶೆಡ್ ನೊಂದಿಗೆ ಗಿಡಗಳಿರುವ ಸೊತ್ತು ಈ ದಾವೆಯ ವಾದಿಯವರ ಸೊತ್ತು ಎನ್ನುವುದು ನಿಜ. ಸದರಿಯವುಗಳಲ್ಲಿನ ವಸ್ತು ಸ್ಥಿತಿಯನ್ನು ಸಾಕ್ಷಿದಾರರು ಒಪ್ಪುಕೊಂಡಿದ್ದರಿಂದ ಅವುಗಳನ್ನು ಕ್ರಮವಾಗಿ ನಿಶಾನೆಪಿ 10 ರಿಂದ 13 ಎಂದು ಗುರುತಿಸಲಾಯಿತು.
ಮತ್ತೆ ಈ ಫೋಟೋಸ್ ನೀವೇ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ಸರ್? ಈ ಫೋಟೋಸ್ ನೀವೇ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ?
ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಇದೆ ತೋರಿಸಿರೋದು.
ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಮತ್ತೆ ಇವರ ಪ್ರಾಪರ್ಟಿ ಅದ್ಲು ಬದ್ಲಿದೆ, ಅಕ್ಕಪಕ್ಕ ಇದೆ, ಮಧ್ಯ ಪ್ಯಾಸೇಜ್ ಇದೆ. ಆ ಪ್ಯಾಸೇಜ್ ಫೋಟೋಸ್ ಅಲ್ಲಿ ಇದೆ. ಆ ಪ್ಯಾಸೇಜ್ ಇರೋದು 2 ಅಡಿ ಇಂಟು 3.5 ಅಡಿ, 23 ಅಡಿ ಉದ್ದ ಇದೆ. ಸೊ ಜಡ್ಜ್ ಕೊಟ್ಟರು, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ ಕೊಟ್ಟರು ಡಿಗ್ರಿ ಬರೀ 2 ಅಡಿ ಇಂಟು 3.5 ಅಡಿ ಮಾತ್ರ. ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಹಾಕಿದ್ರಲ್ಲ ಅದನ್ನ ತೆಗೀರಿ ಅಂತ ಹೇಳ್ತಿರೋದು ಅಷ್ಟೇ. ಅದನ್ನ ತೆಗೆದು ಬಿಡಿ, ಸೂಟ್ ಇದಾಗುತ್ತೆ
ಅದು ಅವ್ರು ಹೇಳಿದ್ದಾರೆ ತೆಗ್ದಿರಿ
ಅಷ್ಟೇ ಇರೋದು ಕೇಸು.
ಅಷ್ಟು ನಾನು ತೆಗಿಯೋದಕ್ಕೆ ನಾನು ಅಯ್ಯೋ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ತೆಗ್ದಿದ್ದಾರೆ ಸೂತ್ರ ಬೇಡ ನೋಡ್ಕೊಂಡು
ಸ್ವಾಮಿ 42 ವರ್ಷದಿಂದ ತಗೊಂಡು ಇವ್ರ ಹತ್ರನೇ ತಗೊಂಡಿದ್ದು ಸ್ವಾಮಿ. ಮನೆ ಕಟ್ಟಿಲ್ಲ, ಗುಡಿಸಲು ಹಾಕೊಂಡೇ ಇದಾರೆ ಸ್ವಾಮಿ. ಆಯ್ಪ ರಿಟೈರ್ಡ್ ಸಿಂಡಿಕೇಟ್ ಬ್ಯಾಂಕ್. ಮತ್ತೆ ಇನ್ನೊಂದು ಸ್ವಾಮಿ, ಅದು ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಮೆಲಾಟ್ಸ್ ಪರ್ಮಿಟ್ಸ್ ಪೆಂಡೆನ್ಸ್ ಆಫ್ ದಿ ಸೂಟ್ ಅಲ್ಲಿ ಅದೊಂದು 6 ಅಡಿ ಓಡಾಡೋ ಜಾಗ ಇತ್ತಲ್ಲ ಸ್ವಾಮಿ, ಅದು 3 ಅಡಿ ಕಟ್ಕೊಂಡ್ಬಿಟ್ಟಿದಾರ. ದಯವಿಟ್ಟು ನೋಡಿ ಸ್ವಾಮಿ.
ಆಯ್ತಪ್ಪ, ಈ ಸಜ್ಜ ಹಾಕಿದಾರೆ ಅಷ್ಟೇನೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಕಿಟಕಿಗೆ ಒಂದು ಸಜ್ಜ ಹಾಕಿದ್ದಾರೆ, ಮಳೆಗಳೇ ಬಂದ್ರೆ ನೀರು ಒಳಗೆ ಬರ್ತದೆ.
ಅದು ಏನಾಯ್ತು ಸ್ವಾಮಿ ಅಂತಂದ್ರೆ, ಫಸ್ಟ್ 2.5 ಅಡಿ ಹಾಕೊಂಡ್ರಲ್ಲ ಸ್ವಾಮಿ, ಮತ್ತೆ ಅವ್ರು ಡೋರ್ ತೆಗೆದ್ರೆ ಅವ್ರು ಒಳಗಡೆ ಬರಲ್ಲ, ಅದು ಹಿಂಗ್ ಆಚೆ ಬರುತ್ತೆ. ಅದನ್ನೇ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದ್ದು. ಅಲ್ಲಿ ಫುಲ್ ಬ್ಲಾಕ್ ಆಗ್ಬಿಡುತ್ತೆ. ಅದನ್ನ ಪ್ಯಾಟರ್ನ್ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಒಂದು ಮಾಡಿದ್ದಾರೆ. ಪೆಂಡೆನ್ಸಿ ಆಫ್ ದ ಸೂಟ್ 6 ಅಡಿ ನನಗೆ ನನ್ನ ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಇಬ್ರಿಗೂ ಓಡಾಡ್ಲಿಕ್ಕೆ ಜಾಗ ಇತ್ತು ಸ್ವಾಮಿ, ಅದನ್ನು ಮುಚ್ಚಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ದಯವಿಟ್ಟು ಅಮೆಂಡೆಡ್ ಪ್ಲೈನ್ಸ್ ಒಂದು ಸ್ವಲ್ಪ ಸ್ವಾಮಿ
ರೆಡಿ ಮಾಡ್ತೀರಾ?
ಈಸ್ಟರ್ನ್ ಸೈಡ್ ಅವರು ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಏನಿದೆ ಈಗ
ಅಲ್ಲಲ್ಲ,
ಬಟ್ ಆ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ 2 ಅಡಿ ಇಂಟು 3.5 ಅಡಿ ಪ್ಯಾಸೇಜ್ ಇದೆ. ಮತ್ತೆ ನಾವು ಹೇಳ್ತೀವಿ
ಅಷ್ಟೇ. ಯಾಕಂತಂದ್ರೆ 42 ವರ್ಷದಿಂದ ನಾನು ಕನಿಷ್ಠ 2.5 ಅಡಿಲಿ ಒಂದು ಇಟ್ಟಿಗೆ ಎತ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ ಸರ್.
2 ಅಡಿ ಮತ್ತೆ 3.5 ಅಡಿ
ಪ್ಲೀಸ್ ಅಷ್ಟೇ ಸರ್. ದಟ್ಸ್ ಆಲ್ ಮೈ
ರೆಡಿ ಮಾಡಿ ತೆಗಿಸ್ತೀನಿ ಅಂತ
ಪ್ಲೀಸ್.
ಹೇಳ್ತೀವಿ.
ಅಗ್ರೀಡ್.
ತೆಗಿಸ್ಬಿಟ್ಟು ಆಮೇಲೆ ಒಂದು ಪ್ಲೇಟ್ ಇದೆ. ಆ ಮಿಕ್ಕಿದ್ದು ನನಗೊಂದು ಸಂಬಂಧ ಇಲ್ಲ, ನನಗೊಂದು ಸಂಬಂಧ.
ಮಿಕ್ಕಿದ್ ಯಾವ್ದು
ಇಲ್ಲ ಸ್ವಾಮಿ. ಮಿಕ್ಕಿದ್ದು ಓಡಾಡ್ಲಿಕ್ಕೆ ಅದಷ್ಟೇ ಸ್ವಾಮಿ ಜಾಗ ಕೇಳ್ತಾರೆ. ಅವರೇ ಮಾರಾಟ ಮಾಡಿ ನಮ್ಗೆ ತೊಂದರೆ ಕೊಡ್ತಾರೆ.
ಅದ್ ಹೆಂಗೆ ನೀವು ಇದು ಮಾಡ್ತೀರಾ? ನೀವು ಅರ್ಥ ಆಗಲ್ಲ. Learned counsel for the appellant, after arguing for some time, submitted that you would ensure that the obstruction laid in the passage as per the decree of the trial court shall be removed. Full stop. Hence list on yavat ಬೇಕು. 10 days time ilvalla.
ನಾಳೆ
23rd.
ಆಗಬಹುದು.
23rd, 24th.
ಇವತ್ತು ಹೇಳಿ ಮಾಡಿದ್ದಾರೆ ಏನೋ ಅದು ಹೇಳುದು ಮಾಡಿದ್ರೆ
Right note. Yes.
Number 43, TN Vishwanath.
TN Vishwanath, Kemparaju, Raksha Kirtana. Yes, ready?
Hello, sir. Appellant, sir. Please for short accommodation.
No good, man. ಈ ಕೇಸಿಂದ ಇದು Yes, TN Vishwanath. What is the suit for?
That's partition.
Partition. Filed by?
For the appellant.
Granted.
Obviously.
For the trial purpose. I was
Filed by the daughter or son or?
daughter.
Daughter.
Daughter of the first response.
What is the decree then?
Plus, there were 5 suit schedule properties, out of which item number 4 and 5 I was given 1/4 share. And with respect to item 1, 2, and 3, set aside. So the same challenge before this one.
No, I will not grant adjournment just like that. You will have to argue.
Due to certain inconvenience, senior had to leave.
Let him pay cost. You can't simply list the matters, mister. You should be thankful to the High Court. We are taking up 2023 final hearing matters.
Next week.
When counsel for the appellant seeks time, cost of rupees 2,000 payable to the association. Distance on Timmegowda. 44th.
Serial number 44, Timmegowda and
Reds or whoever wants time, you pay 2,000 and come back. You ready? Ready. Yes, please.
Well, this is a suit for permanent injunction. The suit property is the site property, my lord. My lord, the suit was decreed by the plaintiff, suit was decreed, and counterclaim filed by the defendant was also decreed. I have challenged the counterclaim, decree of the counterclaim passed by the trial court, my lord. My lord, the counterclaim is in an entirely different property, no way concerned with the suit schedule property, my lord. My lord, the facts of the case in plaint, my lord, I have narrated in my facts of the case, my lord. The plaintiff is the owner, absolute owner, and in possession of the property bearing site number 153, farmed out of survey number 46/3. This is a converted land. The measuring east to west 60 feet, north south 40 feet, situated at Royal Enclave Layout, Srirampura village, Yelankobali, Bengaluru North Taluk, my lord. My lord, the said property was acquired by the plaintiff, the suit schedule property on 7/9/1998, my lord. My lord, thereafter, my lord, I have paid the betterment charges to the concerned authorities, and Khata and other records are transferred in the name of plaintiff, my lord. My lord, originally the layout was farmed as per para 4 of my plaint, my lord. Royal Property Developers 1 K. Gangappa and K. N. Rao, who are the partners, they are farmed the gated residential layout at Royal Enclave Layout in survey number 46/2 and other various submitting survey numbers, Srirampura village. Then the suit schedule property is site number 153 is farmed out of survey number 46/2. 46/2 was belongs to one Chinnatayappa, son of Jingerappa and others. The said Chinnatayappa and others have jointly executed the registered agreement of sale general power of attorney on 18/7/1996. And K. Gangappa and K. N. Rao paid the entire sale consideration amount to landlords. And said Chinnatayappa and others have executed the receipt and declaration for receipt of the entire sale consideration amount. Then delivered the physical possession of the said property in favor of K. N. Rao and K. Gangappa, etc. That is plaint averments, my lord. My lord, then other averments in the plaint in 46/2 was converted from agriculture to line agricultural in the year 1996, my lord. Then, my lord, the betterment charges was paid in the year 1997 before execution of the sale deed, my lord. My lord, para 8 of my pleadings, my lord, in plaint, it is submitted that land bearing survey number 46/3 measuring 11 guntas. That is a counterclaim, my lord. In my plaint itself, I contended that 46/3 measuring 11 guntas and 45/1 measuring 30 guntas and adjacent to the survey number 46/2. That one S.M. Munraju was the owner of survey number 46/3, and he had also executed the registered general power of attorney and notarized the GPA agreement of sale and received the entire sale consideration amount and delivered the physical possession of the said property 46/3, my lord, in favor of K. N. Rao and K. Gangappa, and also executed the separate receipts and deed of declaration in respect of receipt of the entire sale consideration amount and delivery of possession. The survey number 46/3 and 45/1 have also converted from agriculture to non-agricultural purpose in the year 1997 itself. Apart from the above said survey number 46/2, 45/1 and 46/3 and other various survey numbers abutting to the above said survey numbers have been farmed a gated residential layout under the name and style of Royal Enclave. It is submitted that the Royal Enclave being a gated residential layout, the ingress and egress out of the residential layout is restricted to the residents and their visitors only. There are approximately 300 residential sites in the Royal Enclave layout. Many persons have constructed houses on their sites over past many years since formation of the layout The plain schedule property is one of the residential site in the Royal Enclave layout.
ನಿಮ್ಮ ಸೈಟ್ ಇರೋದು 46/2 ನಲ್ಲಿ.
46/2 malad.
ಅವ್ರು ಕೇಳ್ತಿದ್ರು 46/3
46/3. In 46/3 also, the owner SM Muniraju has executed the sale documents in the year 1996 itself, malad.
ಯಾರಿಗೆ?
K. Rao and K. Gangappa, developers. Developers.
Not on that. ನಿಮ್ಮ ಸೂಟು is in respect of a site formed in survey number 46/2.
Correct.
ಕರೆಕ್ಟಾ?
Correct.
ನಿಮಗೆ 46/3 ನಲ್ಲಿ ನಿಮ್ಗೆ ಏನು ಟೈಟ್ಲ್ ಇಲ್ಲ.
46/2, my case is malad. This is adjacent property. Adjacent property.
46/3 ನಲ್ಲಿ ನಿಮ್ಗೆ ಏನಿದೆ?
46/3 is my portion of the site is also comes within the 46/3. At the time of execution of the sale deed, the survey number only mentioned 46/2. Now, in view of the decree passed and the counterclaim, they are interfere with my position and demolished the structures
Then
also.
should you not get the sale deed rectified?
No, what happened, malad? He has farmed the layout in respect of entire survey numbers. The developers have farmed the layout in the year 97 in respect of 46/3 also.
Yes.
That is already, they have approached this honorable court in one of the MFA. In MFA also, this honorable court already given a definite finding stating that the previous owners have nothing to do, they have not subsisting rights to create any transaction.
Have you placed on record the layout plan?
Layout plan not placed record before the trial
not
court.
produced.
I have produced the documentary MFA passed by this honorable court, that is exhibit D12 malad, P12 malad. In MFA, this honorable court already come to the conclusion that the vendors of the defendant number 1 have no subsisting rights to execute any document in favor of defendant number 1 or his vendor.
You're going out of context. ನಿಮ್ದು ಬರೀ ಇಂಜಂಕ್ಷನ್ ಸೂಟು.
Yes, ma'am.
ಹೌದಾ?
Yes, ma'am.
ನಿಮ್ದು ಬರೀ ಇಂಜಂಕ್ಷನ್ ಸೂಟು. In respect of a site measuring 40/60 in survey number 46/2. That is your specific case.
Yes, ma'am.
It is based on a sale deed.
Yes, ma'am.
Suit is based on a sale deed.
Sale deed.
ಅವ್ರು ಹೇಳ್ತಿರೋದು 46/3 ನಂದು. ಅವ್ರದ್ದು 46/2 ಅವ್ರದ್ದು.
ಅಲ್ಲ, ಅದನ್ನೇ ನಾನು ಈಗ 46/3 ಅವ್ರದಲ್ಲ ಅಂತ ನನ್ನ
ಅದನ್ನ ನೀವು ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಹೆಂಗ್ ತೀರ್ಮಾನ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲ, ಇಂಜೆಕ್ಷನ್ ಸೂಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ, ಮೈ ಸೂಟ್ ವಾಸ್ ಡಿಕ್ರೀಡ್
46/2.
46/2 decreed. In 46/3 also decreed against me. Against me.
Yes.
Therefore, my approach to this honorable.
Yes, Mr. How can you file a counter claim in respect of 46/3?
I have just one submission to make, Manoj. Your Lordship may kindly have their schedule, Manoj. I just have one submission to make. Your Lordship may kindly have their schedule. I don't have the complete appeal memo, Manoj. I have a separate certified copy, so I'll just read from that.
Yes, please.
All that piece and parcel of the property bearing site number so and so, found in converted land bearing so and so, measuring so and so, so and so. This is our schedule. Now there is one important document and even a fact that has been suppressed before this honorable court. I would just like to pass on this judgment. In fact, they've pleaded regarding a temporary injunction in this suit, but they have not pleaded that this suit came to be dismissed by the very same vendor, the very same schedule, against my vendor. I am the purchaser. The suit was against my vendor. My lords may kindly have this judgment. And in this very judgment, the honorable trial court dismissed it for with cause.
No, let it be.
Please.
He has filed a suit for 46/2.
Please.
If you have any counter claim in respect of 46/2, you can raise a counter claim.
Please.
Can you raise a counter claim in respect of 46/3 in the suit filed by him?
We have raised the claim solely because of the fact that they, using their schedule, were interfering in our schedule.
You're not getting it.
I understand your lordship.
46/2.
Please.
If you have any claim against the plaintiff in respect of 46/2, you can make a counter claim.
Please.
Can you file a counter claim in respect of 46/3 in his suit?
That I bow down to that, Manoj. That may not be correct. The submission that I have, your lordship, in that regard is the entire reason we filed that is taking advantage of the injunction order that they had in respect of this very same scheduled property. They were interfering.
Please convince me on that. How can you raise a counter claim? You may have a right to file a separate suit.
Please.
You may have a right to file a separate suit. But how can you seek for a counterclaim in respect of a property which is not the suit property?
Please, I may not have that right, Manoj, but what I have to
Allow
submit
this
before,
appeal.
what I have is, if I may be permitted a day's time to place certain documents, because they have suppressed the fact that they have already been held, not to be held. They're not even
My
in possession
dear
of their own
friend, we are
scheduled
not
property.
concerned with 46/3.
Please.
We are concerned with 46/2.
Please.
You are not concerned with 46/2. You are concerned with 46/3.
Please.
So when in is suit for 46/2, how can you seek for injunction in respect of 46/3? That is a cause of action for a separate suit.
Please.
Counterclaim should always be in respect of the same property.
Please.
Suppose if he files a suit for injunction in Chikbalapura, can you get an injunction?
I completely
in respect of
understand
the
what your
property
lordship.
in Bangalore?
I completely bow down and understand what
Then?
your lordship is saying. But
Then?
the entire reason the counterclaim came to be decreed, in fact, is because they deposed that they have no.
We'll allow this appeal and say that counterclaim will dismiss it.
My
And we'll
request is,
reserve
Manoj,
liberty to you to work out your counterclaim in an appropriate suit.
in that regard, may I seek instructions and just submit, Manoj?
Release tomorrow.
Please, brief.
Serial number 45, Ramchandra Naik.
Extend the interim order.
Interim order is extended. Extended.
Serial number 45.
Appellants in both the cases. Appellant in the both the cases, not two.
Appellant in
both the cases.
The lordship has heard the matter in part in the last occasion. On site Moriಗೆ ಹೋಗಿದೆ 10 feet. In their site itself, it has been gone to the channel. And thereafter, they have left out the 10 feet again they have constructed. Which clearly shows the commissioner report is also established.
ಆಯ್ತು ರೆಡಿ ಇದ್ರೆ ಮಾಡಿ.
ಅದ ಮಾಡಿದ್ದಾರೆ ಸುಮಾರು.
Already I have
ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಬಂದಿದ್ಯಾ?
ಅದರಲ್ಲಿ ಹಳೇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿರೋದು.
ಅಲ್ಲ ಇಲ್ಲೇನ ಮಾಡಿದ್ರ?
ಇಲ್ಲೇನು ಮಾಡಿ.
ಇಲ್ಲ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಎವ್ರಿಥಿಂಗ್ ಹ್ಯಾಸ್ ಬೀನ್ ಕವರ್ಡ್ ಮೇಲೆ.
ಅದೇ ಇದು ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಡ್ರೈನ್.
Yes, please.
ಅದರಲ್ಲಿ ಡ್ರೈನೇಜಿಗಾಗಿ ಬಿಟ್ಟಿದ್ದು ಅಂತೇಳಿ 10 ಫೀಟ್ ಬಿಟ್ಟಿದ್ದು. It is leaving the 10 feet of the dimension for the leaving the drainage. But the commissioner report is given that this appellant is encroached 10 into 40 of the site of this respondent.
Yes.
This respondent is purchasing the site in the year 2014 by executive. Earlier to that, the adjacent to the eastern side of the appellant site, 2190. There is a 220 is there. You only executing the sale deed, the site number is changed as the 2020A.
Sir, nim check bundi heli sir. What is the boundaries of your property?
My lord, 3 deed of conveyance is executed in ಮೂರು ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ. ಎಲ್ಲಾ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಒಂದೇ ಬೌಂಡ್ರಿ ಇದೆ. ಅದ್ರ ಬೌಂಡ್ರಿ ಏನ್ ಹೇಳ್ತಂದ್ರೆ ಪೂರ್ವಕ್ಕೆ 21, 20 ನಂಬರ್ ನಿವೇಶನ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಟೇಕನ್ ದ ರೆಕಾರ್ಡ್ಸ್ ಆಫ್ ದ ಎಕ್ಸಿಬಿಟ್ಸ್ ವೇರ್ ಇನ್ ದ ಡಿ ಸೀರೀಸ್
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ.
ಲಾರ್ಡ್ ಎಕ್ಸಿಬಿಟ್ P1 ಡಿ ಸೀರೀಸ್ ಲಾರ್ಡ್ ದಿಸ್ ದ ಸ್ವಾಧೀನ ಪತ್ರ ಇದೆ.
It is a
suit of 19.
You are ready to argue?
Yes.
Suit of 1920 of 24. The D series of the. It is my suit for bare injection.
Exhibit?
E1, exhibit P1 or D1 anta idu ಮಾಡಿದ್ದಾರೆ.
Exhibit P1 ನಾ?
P1 ಆಗಿದೆ. ಇದು suit number OS number 1920 of 20. Both are clubbed, my lord, in this case. ಇದರಲ್ಲಿ ಸ್ವಾಧೀನ ಪತ್ರ ಅಂತ ಹೇಳಿದ್ರೆ ಶೆಡ್ಯೂಲ್ ಹೇಳಿದ್ದಾರೆ. ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇಟ್ ಇಸ್ ಅಲಾಟೆಡ್ ಟು ದ ಒನ್ ಲಕ್ಷ್ಮಮ್ಮ ವೈಫ್ ಆಫ್ ಸಿದ್ದಯ್ಯ. ಇದು ಪೂರ್ವಕ್ಕೆ ಸೈಟ್ ನಂಬರ್ 2120 2120, ಪಶ್ಚಿಮಕ್ಕೆ SWD ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂಡ್ ಉತ್ತರಕ್ಕೆ ರೋಡ್, ದಕ್ಷಿಣಕ್ಕೆ ಸೈಟ್ ನಂಬರ್ 2149 ಸರ್. Thereafter, she executed the sale deed in favor of the one Savitramam, my lord.
Lakshmama.
Lakshmama executed the sale deed in the dated 7/4/2007. Idrolo the same There is a schedule is the same, my lord, in this case, in this sale deed also. Thereafter, my lord, another sale deed is came to by the purchased by the Ravi. These are also, my lord, in the year 2012, my lord.
Yes.
Is also same schedule is incorporated in the measurement also, my lord. It is only 20 into 40, my lord. 20 into 40. Earlier it's granted 30 into 40. After reducing of the 10 feet for leaving for the drainage, this is the reducible on 20 into 40, my lord. There are no disputable. Thereafter, this appellant is purchased in the year 2013, my lord. He is also very same schedule is
yes
incorporated in the there are
Only measurement has been changed.
schedule. East by site number 2120, west by SWD, north by road, and south by site number 214. Well, till the executing of the system, there was no regarding the survey, site number 2120 is not existing. After executing the sale deed in favor of this respondent, my lord, the 2120 site number is mentioned as the 2120A. That is the thereafter in the year 2004, it is a sale deed is executed in favor of that respondent number 1, my lord. Thereafter, immediately in the year February 2000, sale deed is executed to 20th to February 2014. Sale deed is executed in favor of the dependent number 1, my lord. Respondent number 1. Immediately after, my lord, in the on the same, my lord, came to the spot of the site and marked the boundaries, the wall of this constructed the shed. There is this property is encroached by another 10, including the dependent number 2, respondent number 2 herein, and mark the wall of the this is encroached by 10 feet of the site to the rear. But ultimately,
ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿಗೂ ಮತ್ತು ಸ್ಟಾಮ್ ವಾಟರ್ ಡ್ರೈನ್ಗೂ ಎಷ್ಟಿದೆ ವ್ಯತ್ಯಾಸ?
ಕಾಲ್ ವಾಟರ್ ಡ್ರೈನೇಜ್ಗೆ ಇದ್ರ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ಗೆ ಹೋದ್ರೆ ಅಲ್ಲಿ ಜಾಸ್ತಿ ತೋರಿಸಿದ್ದಾರೆ.
ಎಷ್ಟಿದೆ?
Commissioner report, my lord, there is a commissioner report is there.
ಏನಂತ ಹೇಳಿ ಎಷ್ಟಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ?
ಅದರಲ್ಲಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ got it, my lord, it is marked as commissioner report in the records of the from the eastern side, my lord, this is shown as the respondent number site, my lord. Measurement of the including encroaching by your lordships may kindly take out by the right side commissioner report. Last time. ಅದ್ರಲ್ಲಿ ಮ್ಯಾಪ್ ಇದೆ, ಸ್ಕೆಚ್ ಇಲ್ಲ, ಅದರಲ್ಲಿ ಇದೆ, ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ ಇದೆ.
ಬುಕ್ ಅಲ್ಲ?
ಬುಕ್ ಅಲ್ಲ, ಸ್ಕೆಚ್ ಇಲ್ಲ, ಅದ್ರಲ್ಲಿ ಸ್ಕೆಚ್ ಇಲ್ಲ. ಲಾಸ್ಟ್ ಟೈಮ್ ಫ್ಲಾಗ್ ಹಾಕಿದೆ.
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಇದೆ, ಬಟ್ ಸ್ಕೆಚ್ ಇಲ್ಲ. ಇದ್ರಲ್ಲಿ ಸ್ಕೆಚ್ ಇದೆ.
ತೆಗಿರಿ, ಪ್ಲಾನ್ ತೆಗಿರಿ.
ನಾನು ನೋಡ್ಕೊಡ್ತೀನಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡ್ಕೊಟ್ಟಿದ್ದೆ. Lots of God.
ಪ್ಲಾನ್ ತೆಗಿರಿ, ಕಟ್ ಮಾಡಿ. ಎಸ್ ಪ್ಲೀಸ್. ಪೇಪರ್ ಗುಡ್ಸಿರ ಚಾಕು ಇಲ್ವಾ? ಓದ್
ಎಲ್ಲ get the commissioner report with the sketch.
ಡ್ರೈನೇಜ್ ಇಂದ ನಿಮ್ ಪ್ರಾಪರ್ಟಿಗೆ 20 ಅಡಿ ಒಂದ್ ಕಡೆ ಇದೆ, 16 ಅಡಿ 16 ಮುಕ್ಕಾಲ್ ಅಡಿ ಒಂದ್ ಕಡೆ ಇದೆ.
ಒಂದ್ ಕಡೆ ಇದೆ.
ಲಾಸ್ಟ್ ಗೆ 9 ಅಡಿ.
ಇದರಲ್ಲಿ your lordship may kindly from the right side, my lord. There is a commissioner is my era marker, my lord. U and V, my lord. Your lordship may kindly starting point of the U and V in the right side, my lord. UV in the top of the U, my lord. Thereafter, my lord, the QRTST, my lord. It is marked. Q by the left side, your lordship, after V from the bottom side, your lordship. Q R and again S and T last end point is the T, my lord.
QR ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಇಲ್ಲಿ ಮಧ್ಯೆ ಇದೆ ಇದರಲ್ಲಿ.
QR
ST ಅಂತ ಲಾಸ್ಟ್ ಮಾಡಿದ. This is the site position of the respondent, my lord. Thereafter, my lord, again he is marked PON. Your lordship got it. PON. This is the dimension of the site of the belongs to the this respondent as the commissioner sketch, my lord. Thereafter he marked, my lord, P, N, M and G. Get this. P is by the right side P and the end of the top level N and M and G. This is the site of the present condition of the site of this appellant. Thereafter, another small bit of the Madhya L, K, J, I and G. That is the square, the thing, but by the width of the 5 feet and the 3 feet, D, E and F. This is the site is the diamond, total dimension of the my site, my lord. It's the appellant site. But my lord, this is the only the restricted this M, L, K, J, I and G is the as on the present status of the site of this appellant.
But what should happen to this C, M, A, G? C, M or CAGM? CAGM ಯಾರಿಗೆ ಸೇರಿದ್ದು?
CAGM, it is a open space ಅಂತ ಹೇಳ್ತಾರೆ.
ಯಾರಿಗೆ ಸೇರಿದ್ದು ಅದು?
ಅದರಲ್ಲಿ ಈಗ ಅದು it is a leaving the open space part that it not belongs to me ಅಂತ ಹೇಳಿದ್ದಾರೆ.
How can you, your site begins from the stormwater drain?
ಅಲ್ಲ, check on this, it is not on the north, south side,
ವೆಸ್ಟ್ ಸೈಡ್ಗೆ
west side it is mentioned as the storm.
ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರಕಾರ ವೆಸ್ಟ್ ಸೈಡ್ಗೆ ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಡ್ರೈನ್ ಇದೆ. ಇಲ್ಲಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ ನಿಮ್ಮ ಸೈಟ್ಗೂ ಮತ್ತೆ ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಡ್ರೈನ್ 20 ಅಡಿ ಇದೆ. 20 ಅಡಿ ಯಾರಿಗೆ ಸೇರಿದ್ದು?
20 ಅಡಿ ಇದರಲ್ಲಿ ಈ ಪ್ರಕಾರ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಪ್ರಕಾರ 20 ಅಡಿ ನಮಗೆ ಸೇರಿದಲ್ಲ ಅಂತ ಅವ್ರು ಬರೀತಾರೆ.
ನಿಮಗೆ ಸೇರಿದಲ್ಲ, ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ ಕಟ್ಕೊಂಡಿದ್ರಲ್ಲ ಒತ್ತುವರಿ ಮಾಡಿ.
ಅದರಲ್ಲಿ ಒಂದು ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ವಾಟ್ಸ್ಆಪ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಟೇಕ್ ಔಟ್ ಪೇಪರ್ ಬುಕ್ ಆಫ್ ದ ಕಮಿಷನರ್ ಮೇಲೆ.
ಎಸ್, ಈ ಪ್ಲಾನ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ನಿಮ್ಮ ಸೈಟು?
ಅಲ್ಲಿದೆ ಡೆಡ್ ಎಂಡ್ ಅಲ್ಲಿ ಇದೆ. ಐ ಮೀನ್ adjacent to the
ನೋಡಿ, in the plan ಇದೆ 21-20 in the after road it is shown, sir.
ಪ್ಲಾನ್ ಅಲ್ಲಿ ತೋರಿಸಿ ಎಲ್ಲಿದೆ ಅಂತ.
ರೋಡ್ ಅಲ್ಲ,
ಎಲ್ಲಿದೆ ತೋರಿಸಿ. ಈ ಕಡೆ ಬನ್ನಿ, ಈ ಕಡೆ ಬನ್ನಿ ಪ್ಲೀಸ್. ಪಾಯಿಂಟ್ ಔಟ್ ಎಲ್ಲಿದೆ?
ಗಿಡದ ಕೋನೇನಹಳ್ಳಿ ವಿಲೇಜ್ ಅಂತ ಇದೆಯಲ್ಲ ಸ್ವಾಮಿ, ಅದ್ರ ಪಕ್ಕದಲ್ಲಿ ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಡ್ರೈನ್ ಪಕ್ಕದ ಅಡ್ಜಸೆಂಟ್ ಸೈಟ್. ಕ್ಯಾಪಿಟಲ್ ಲೆಟರ್ಸ್ ಅಲ್ಲಿ ಗಿಡದ ಕೋನೇನಹಳ್ಳಿ ವಿಲೇಜ್ ಅಂತ ಬರೆದಿದೆ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಅಲ್ಲಿ.
ಎಲ್ಲಿ ತೋರಿಸಿ?
ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ 2119A.
ಇದು ನಿಮ್ದು ಅದು 21
2119A 2120A.
ಅಲ್ಲ, ನಿಮ್ ದಾಖಲೆ ಪ್ರಕಾರ ಎಲ್ಲಿದೆ ಪ್ರಾಪರ್ಟಿ?
ಇದು ಇಲ್ಲಿ ತೋರಿಸಿಲ್ಲ. ದಾಖಲೆ ಪ್ರಕಾರ ಇಲ್ಲಿಗೆ ಬರಬೇಕು.
ಅಲ್ರಿ, ಇಲ್ಲಿಗೆ ಹೆಂಗ್ರಿ ಬರುತ್ತೆ? ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಇದಲ್ವಾ? ಇದೇನಿದು? ಇದೇ ಡ್ರೈನೇಜ್. ಸೊ ಪಶ್ಚಿಮ ಇದು ನಿಮ್ದು, ಇದು ನಿಮ್ದು.
ಪೂರ್ವಕ್ಕೆ 21, 20A ಬಟ್ ನಮ್ಮ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲ. ಪೂರ್ವಕ್ಕೆ 21, 20
ಆಯ್ತು, 20 ಇರ್ಲಿ. ಬಟ್ ಇದು ನಿಮಗೆ ಈ ಸ್ಟಾರ್ಮ್ ವಾಟರ್ ಡ್ರೈನ್ಗೆ ಲಗತ್ತಾಗಿದೆ. ಇದು ಲಗತ್ತಾಗಿದೆ. ಲಗತ್ತಾಗಿದ್ರೆ 20 ಅಡಿ ಹೆಂಗ್ ಬಿಡ್ತೀರಾ ನೀವು? ನೀವು ಬಿಟ್ಟು ಕಟ್ಟಿದ್ದೀರಾ ಅಂತ ಹೇಳ್ತಿರೋದು. ವೇಕೆಂಟ್ ಇದೆ ಅಂದ್ರೆ ನೀವು ಅದನ್ನ ಬಿಟ್ಟು ಕಟ್ಕೊಂಡಿದ್ದೀರಾ, ಅದನ್ನ ನೀವು ಉಪಯೋಗಿಸ್ಕೊಂಡು ಬಿಟ್ಟೋದ್ರೆ ನಿಮ್ದು. ನೀವು ಈಗ ಶಿಫ್ಟ್ ಆಗ್ಬೇಕಷ್ಟೇ. ಅದು ನಿಮ್ಮ ಹಣೆ ಬರೋದು, ನೀವ್ ಯಾಕೆ ಬಿಟ್ರಿ? ನಿಮ್ಮ ಇಲ್ಲಿ ನೀವು ಇಲ್ಲಿ ಬಿಟ್ಟು ಯಾಕೆ ಕಟ್ಟಿದ್ರಿ? ನೀವು ಬೇರೆ ಬಂದು ಕೂತ್ಕೊಂಡಿದ್ದಾರೆ ಅಂದ್ರೆ ನೀವ್ ಬಿಟ್ಟಿದ್ರಿ. ನೀವು ಈಗ ಅವ್ರ ಸೇವಿಂಗ್ ಎಲ್ಲ ಕೂತಿದ್ರ, ಇವಾಗ ಅವ್ರು ಹಾಕೊಂಡಿದ್ರು ಅಷ್ಟೇನಾ? 2 ಅಪೀಲ್ ಹಾಕಿದ್ರಲ್ಲ, ಅದೇನು ನಿಮ್ದು ಇಂಜಂಕ್ಷನ್ ಸೂಟಾ? ಮತ್ತೆ ಅವ್ರದ್ದು
to demolish the encroached area ಅಂತ ಕೇಳಿದ್ವಿ. That has been decreed and their suit has been dismissed. Even on the admission side, please my lord, the DW on cross examination ಅಲ್ಲಿ clearly admits in his cross examination that ನೀವು ಎಷ್ಟು ಕಟ್ಟಿದ್ದೀರಿ ಅಂದ್ರೆ 25-40 ಕಟ್ಕೊಂಡಿದ್ದೀನಿ ಅಂತ clear admission ಇದೆ. He is admitting. And even their sale deeds, first sale deed ಅಲ್ಲಿ 30-40 ಇದೆ ಅಲಾಟ್ ಆಗಿರೋದ್ರಲ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಅಬರ್ಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ರಿಸೈಟ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ, ಪಶ್ಚಿಮದ ಕಡೆಗೆ ಮೋರಿಗೆ ಹೋಗಿರೋದ್ರಿಂದ ಉಳಿಕೆ ಜಾಗ ಹಾಲಿ ವಿಸ್ತೀರ್ಣ ಅನ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ 25ಕ್ಕೆ 42 ಮಾಡಿ. ಅಲ್ಲಿಗೆ ಅವ್ರ ಸೈಟ್ ಅಲ್ಲಿ ಒಂದ್ ಪೋರ್ಷನ್ ಹೋಗಿದ್ಮೇಲೆ ಇಟ್ ಶುಡ್ ಬಿ ಸ್ಟಾರ್ಟ್ ಫ್ರಮ್ ದಿ ರೈನ್ ವಾಟರ್ ಡ್ರೈನ್. There is no question of leaving that passage. They have left out the passage and they have encroached in my side. That is what the commissioner has submitted the clear report with sketch based on the memo of instructions filed with. Clear cut point to point ಹೇಳಿದ್ದಾರೆ.
ಇನ್ನ ಇದು ಹೇಳೋದು
ಇನ್ನೊಂದು ಏನಂದ್ರೆ ಇವ್ರ ಅಡ್ಮಿಷನ್ ಇರ್ಲಿ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಪ್ಲೀಡಿಂಗ್ಸ್ ನಲ್ಲಿ
ವೆರಿ ಕ್ಲಿಯರ್.
ನೋ ಕಾಂಪೌಂಡ್ ವಾಲ್ ಇನ್ ದ ಅಡ್ಜಸ್ಟೆಂಟ್ ಟು ದ ದಿಸ್ ಡ್ರೈನೇಜ್ waste water, sewerage water drainage.
And they have cross-examined the commissioner during the trial court.
Commissioner report.
Everything has been elicited.
Lordship may kindly taken the paper book commissioner report.
ಸ್ಟಿಚ್ ಮಾಡ್ರಿ.
Page number 342, my lord. Page number.
ಅಲ್ಲಿಗೆ ಯಾಕೆ ಸ್ಟಿಚ್ ಮಾಡಿ.
Paper. Lordship may kindly bottom in the ವಾದಿಯ ಮೆಮೊ ಆಫ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಾರ್ಯಸೂಚಿ ಪ್ರಶ್ನೆಗಳಿಗೆ ಖಂಡಿಕೆವಾರ ಉತ್ತರ ಈ ಕೆಳಕಂಡಿದೆ. ಏನ್ ವಾಟರ್ ಡ್ರೈನೇಜ್ ಇಂದ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಸತ್ತಿರುವವರೆಗೆ ಖಾಲಿ ಇರುವ ಪ್ರದೇಶವನ್ನು ಅಳತೆ ಮಾಡಲಾಗಿ ಅಳತೆಯಾದ ಈ ಪ್ರದೇಶವನ್ನು ನಕ್ಷೆಯಲ್ಲಿ ABCDMLKJIHGF ಮಾರ್ಕ್ ಇಂದ ಗಮನಿಸಿ ಗುರುತಿಸುವ ಪ್ರದೇಶವಾಗಿರುತ್ತದೆ. ಸದರಿ ಪ್ರದೇಶದಲ್ಲಿ ನಕ್ಷೆಯಲ್ಲಿ ಗುರುತಿಸಿದಂತೆ ABCDHGF ಮಾರ್ಕ್ ಇಂದ ಗುರುತಿಸುವ
ಸೆಲ್ ದ ಪ್ರಾಪರ್ಟಿ ಟು ಹಿಮ್. ಮನೆಗೇನೆ ಕಟ್ಕೊಂಡಿದಾರಂತ.
ಇಲ್ಲ ಕಟ್ಟಿಲ್ಲ. ಈ ಫೋಟೋಸ್ ಆಗಿ ಕಾಂಪೌಂಡ್ ಹಾಕೊಂಡಿದ್ದಾರೆ. ಆಮೇಲೆ ಒನ್ ಮೋರ್ ಥಿಂಗ್ ಮೈ ಲಾರ್ಡ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಹ್ಯಾಸ್ ಟು ಕನ್ಸಿಡರ್ ದ ಫ್ಯಾಕ್ಟ್ ದಟ್ ಈ ಸೀನಿಯರ್ ಸಿಟಿಜನ್ ಲೇಡಿಗೆ ಕೇಸ್ ಹಾಕಿದಾಗ ಶಿ ವಾಸ್ ಬೆಡ್ ರಿಡನ್. ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಗೆ GPI ಕೊಟ್ಟು ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಮಾಡ್ತಾರೆ. ನಾವು ಈ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಯಾರು ತಂದೆ, ಈವನ್ ನೌ ಶಿ ಇಸ್ ಬೆಡ್ ರಿಡನ್. ಹರ್ ಸನ್ ಈಸ್ ಸ್ಟಡಿಂಗ್, ಓನ್ಲಿ ಸನ್ ಸ್ಟಡಿಂಗ್ ಇನ್ IIT ಚೆನ್ನೈಯಲ್ಲಿ. ಅವ್ರಿಗೆ ಪಾಪ ಓದಕ್ ಕೂಡ ದುಡ್ಡಿಲ್ಲ. ಈ ಮನೆ ಕಟ್ಕೊಳಕ್ 20 ಅಡಿ 40 ಅಡಿಗೆ ಇಷ್ಟು ವರ್ಷದಿಂದ ಇದು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿರೋದನ್ನ ಇವನ್ ದೇ ಕಾಂಟ್ ಬಿಲ್ಟ್ ಇಟ್. That is the problem. Now execution is pending, that has been stayed by this honorable court because during the pendency of this. The very clear cut.
Yes.
ಸೀಟ್ ಮನೆ ಇರುವ ಪ್ರದೇಶವಾದ ಈ ಮೇಲ್ಕಂಡ ಖಾಲಿ ಪ್ರದೇಶದ DFGHIJKLM ಮಾರ್ಕಿನ ಗುರುತು ಪ್ರದೇಶ ಅಳತೆ ವೇಳೆ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಹಾಕಿಪಡಿಸುವ ಕ್ರಯಪತ್ರ ದಾಖಲೆಗಳ ಪ್ರಕಾರ ಒಂದನೇ ಪ್ರತಿವಾದಿ ಸೊತ್ತಾದ ನಿವೇಶನ ನಂಬರ್ 2119 ಸೇರಿಯ ಸತ್ವವಾಗಿದೆ. Adjacent to this, it is the series that belongs to this appellant, my lord. Thereafter, ನಿವೇಶನ ನಂಬರ್ 2 ನಕ್ಷೆಯಲ್ಲಿ DFGN ಮಾರ್ಕಿಂದ ಗುರುತಿಸಿದೆ. ಈ ನಿವೇಶನ ವಿಸ್ತರಣಾ ಕ್ರಯಪತ್ರ ಸುಳಿಲು ನಮೂದಿಸಿದಂತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 20 ಅಡಿ ಉದ್ದ, ಉತ್ತರ ದಕ್ಷಿಣ 40 ಅಡಿ, ಒಟ್ಟು ವಿಸ್ತರಣೆ 8 ಚದುರು ಅಡಿ ಇರುತ್ತದೆ. ಈ ಎಲ್ಲೆಯಲ್ಲಿ ತಾತ್ಕಾಲಿಕ ಸ್ಟ್ರಕ್ಚರ್ಗಳನ್ನು ಕೆಳಕಂಡ ನಕ್ಷತೆಯಲ್ಲಿ ಗುರುತಿಸಿದ್ದಾರೆ. ಅಲ್ಲಿ ಗುರುತಿಸಿದ್ದಾರೆ, ಅದನ್ನು ತೋರಿಸಿದ್ದೀನಿ ಅವಾಗ. ಗುರುತಿಸುವ ಪೂರ್ವ thereafter, my lord, in the third in the bottom of the 344 page, my lord. ಸೂಟ್ ಶೆಡ್ಯೂಲ್ ಸತ್ತುಗಳ ಅಳತೆ ಮಾಡಲಾಗಿ ಅಳತೆ ಪ್ರಕಾರ ವಾದಿಯ ಶೆಡ್ಯೂಲ್ ಸತ್ತ ನಿವೇಶನವು ನಂಬರ್ 2120 ಎನ್ನು ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ನಮೂದಿಸಿರುವ ಅಳತೆಯಂತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 25 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ 40 ಅಡಿ, ಒಟ್ಟು ವಿಸ್ತೀರ್ಣ 1000 ಚಡಿ ಅದರ ಪ್ರವೇಶ ನಕ್ಷೆಯಲ್ಲಿ UVQPONT ಮಾರ್ಕಿಂದ ಗುರುತಿಸಿದ ವಾದಿಯು ಬಿ ಶೆಡ್ಯೂಲ್ ಸತ್ತ ಶೆಡ್ಯೂಲ್ ಪ್ರಕಾರ 10 × 40 ಅಡಿ ವಿಸ್ತೀರ್ಣ ಚದುರ ಅಡಿ ಎಂಬುದಾಗಿ ನಮೂದಿಸಿದ ಸ್ಥಳದಲ್ಲಿ ಉತ್ತರ ಭಾಗದಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 8 × 11 ಹಾಗೂ ದಕ್ಷಿಣದಲ್ಲಿ 10 × 10.4 × 2 ಉದ್ದ 40 ಅಡಿ ವಿಸ್ತೀರ್ಣದ 385 ಚಡಿ ಚದುರ ಅಡಿ ಅಳತೆಯಂತೆ ಬಿ ಶೆಡ್ಯೂಲ್ ಸತ್ತ ನಕ್ಷೆಯಲ್ಲಿ NOPQRST ಮಾರ್ಕಿಂದ ಗುರುತಿಸಿದೆ. ವಾದಿ ಮತ್ತು ಒಂದನೇ ಪ್ರತಿವಾದಿ ಅಳತೆ ಕಾಲದ ಅವರವರ ನೋಂದಾಯಿತ ಕ್ರಯ ಪತ್ರದ ಜೆರಾಕ್ಸ್ ಪ್ರತಿ ನೀಡುತ್ತಾರೆ. ಸದರಿ ಕ್ರಯ ಪತ್ರಗಳಂತೆ ವಾದಿ ಮತ್ತು ಒಂದನೇ ಪ್ರತಿವಾದಿ ಇವರುಗಳು ಸತ್ತುಗಳನ್ನು ಪ್ರತ್ಯೇಕವಾಗಿ ಅಳತೆ ಮಾಡಿ ಗುರುತಿಸಿದೆ. ವಾದಿಯ ಕ್ರಯ ಪತ್ರದಂತೆ ನಿವೇಶನ ನಂಬರ್ 21-27 ಪೂರ್ವದಲ್ಲಿ ಪೂರ್ವ ಪಶ್ಚಿಮ 25 ಅಡಿ ಇಂಟು ಉತ್ತರ ದಕ್ಷಿಣ 40 ಅಡಿ ವಿಸ್ತೀರ್ಣ 1000 ಅಡಿ ಚದುರ ಅಡಿ ಪ್ರದೇಶವನ್ನು ಅಳತೆ ಮಾಡಲು ನಕ್ಷೆಯಲ್ಲಿ UV ಪಾಯಿಂಟ್ ಮಾರ್ಕ್ ಇಂದ ಗುರುತಿಸಿದೆ. ಒಂದನೇ ಪ್ರತಿವಾದಿಯ ಕ್ರಯ ಪತ್ರದಂತೆ ನಿವೇಶನ ನಂಬರ್ 2119 ಪೂರ್ವ ಪಶ್ಚಿಮ 20 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ ವಿಸ್ತೀರ್ಣ 800 ಚಡಿ ಅಳತೆ ಮಾಡಿ ನಕ್ಷೆಯಲ್ಲಿ Your Lordship, earlier I shown that portion will be outside of the sketch, my lord. ವಾದಿಯ ಸೂಟ್ ಸೆಟಲ್ಸ್ ಸೊತ್ತಾದ ನಿವೇಶನವು 2120 ಪೂರ್ವ ಪಶ್ಚಿಮ 25 ಅಡಿ ಉದ್ದ, ಉತ್ತರ ದಕ್ಷಿಣ 45 ಅಡಿ ವಿಸ್ತೀರ್ಣ, 1000 ಅಡಿ ಚದರ ವಿಸ್ತೀರ್ಣದ ಪೈಕಿ ಪಶ್ಚಿಮದ ಕಡೆ 1ನೇ ಪ್ರತಿವಾದ ಒತ್ತುವರಿಯಾಗಿ ಇರುವುದು ಅಳತೆ ಕಾಲದಲ್ಲಿ ಕಂಡು ಬಂದಿದೆ. ಸದರಿ ಒತ್ತುವರಿ ಪ್ರದೇಶವನ್ನು ನಕ್ಷೆಯಲ್ಲಿ NOPQR ಮಾರ್ಕ್ ಎಂದು ಗುರುತಿಸಿದೆ. ಅಳತೆ ಪ್ರಕಾರ ನಕ್ಷೆಯಲ್ಲಿ ಗುರುತಿಸುವಂತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ.
Yes, I think list tomorrow for dictation. Mr. Sampath Anand Shetty.
Plaintiffs.
Yes, sir. Mr. V.B. Shivkumar.
But our BDA also, one BDA advocate is also there.
Serial number 46.
Mr. V.B. Shivkumar. Yes, suit is for injunction.
No, declaration.
Declaration.
That, now here, your lordship, this suit is an offshoot of the writ petition filed by me, challenging the authority of the Bangalore Development Authority to reconvey the sale deed in favor of the defendants 3 and 4. Now, if your lord, I will take your lordship to the order of the writ petition, because there are certain disputed questions of fact. This have to be resolved in the before the civil court. Now the order, your lordship, make at page 77-80.
Yes.
Order of this one, exhibit P1. The plaintiff is the petitioner therein. Now in this, my lord, I will only, it's a brief order, if your lordship permits me, page 79. Without entering upon the several disputed questions that are apparent from the pleadings in this petition, having regard to the admitted circumstance, the petitioner had in the first instance questioned the conduct of the defendants 3 and 4 by filing a suit for permanent injunction pending on the file of City Civil Court Bangalore, and since respondent number 2, the Bangalore Development Authority, having conveyed the very property which is the subject matter of this petition, as well as the pending civil suit in favor of the defendants 3 and 4, it would require this court to adjudicate on the questions of fact, whereas it would be more appropriate for the petitioner to agitate the same in a civil court, and in view of the pending civil suit, which may be adequately supplemented with the pleading insofar as further contentions that are sought to be raised in this petition. Apart from the pleadings in the civil suit, the present petition stands disposed of without prejudice to the case of the petitioner, and it will be open for the petitioner to supplement her pleadings in the pending civil suit and also seek other comprehensive reliefs. However, whether the petitioner could at this point of time, depending on the stage at which the suit is pending, it is entitled to amend her pleadings and seek additional reliefs would be a matter that civil court would decide. Accordingly, the petition stands disposed of without prejudice to the right of the petitioner to approach the civil court to pursue any remedy available.
So what was questioned in the writ petition?
Writ petition, the conveyance deed, reconveyance deed executed by the Bangalore Development Authority in favor of the defendants 3 and 4.
Who are defendants 3 and 4?
3 and 4, they are private parties. In fact, my lord, your lordship is well aware that reconveyance can be when executed by the BDA if the land had been acquired by the original owner in favor of them. Now, in the instant case 3 and 4, it is none of the neither the defendants 3 and 4 nor their predecessors from whom the BDA has ever acquired the land and property in question. They did not find, when the civil suits were pending against each other, they could not be successful in establishing their title. Instead, they straight away approached the BDA and got a reconveyance deed of the dated 28/7/2000, and that has been questioned. I came to know this only in the year 2010. I filed a writ petition as well as civil suit. So in the writ petition, there are several, because the documents, whether there was a reconveyance, whether the predecessors acquired, all those questions of facts borne out by the records of BDA will have to be determined in the civil court. So if you're in the light, my lord, if your lordship sees.
Where is Mr. Shivkumar?
Yes. Shivkumar is for the private parties. There is a BDA also. They are also important. Because if you're.
Hello, but Shivkumar is appears
yes.
for the contesting
Contesting,
respondents.
yes, correct.
But they are Barbakala.
And Lordship, with your kind permission, may I make one submission, Lordship? I am for the respondent BDA in this, Lordship, for respondent number 1 and 2.
Yes.
Lordship, I had not received a copy yet, Lordship. RFA copy I had not yet received.
Matter is for final hearing, you are saying you have not received a copy.
And they are party in the trial court also.
How unfortunate. Who has stopped you from taking a paper book? Has anybody stopped you? Go and collect a paper book, mister.
I kindly apologize, Lordship.
There is no representation for the respondent number 3 and 4. Yavat after vacation.
As your lordship.
List after vacation.
Still number 47, VB Shivkumar.
Mr. VB Shivkumar, Arvind Patil, ಎಲ್ಲಿದ್ದಾರೆ ಅವರು? Total?
Lordship, I am for the, in serial number 47, I am for the respondent in this, Lordship.
Arvind Patil.
Please, Your Lordship, the council on record, Arvind Patil, sir, is held up in some other court, Your Lordship. Kindly, I seek for short attendance.
Is absent. Learn counsel for the respondent number. Respondent seeks time. List on so and so. Murali BS. Rajeshwar. E. Ramesh. ಏನಾಯ್ತು?
Also, I sent him with them offer regarding 10 lakhs. 10 lakhs I will be paying.
10 lakhs alle yaar, what is 10 lakhs?
Even assuming for a moment, my lords, they have no right over this property. My lords, after the sale deed executed in my favor, after a lapse of 7 years, a will has been executed.
You ready now?
ನಾನು ರೆಡಿ ಇದ್ದೀನಿ ಬಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ ಹಾಕೊಳ್ಳಿ ಸ್ವಾಮಿ 20
Lords, because there are about
24th or 25th.
Lords, the entire property which has been allotted to them has been alienated, my lords.
But you can't offer 10 lakhs, mister. ಎಷ್ಟು 1 ಎಕರೆ ಇದೆ ಅದು?
ಇಲ್ಲ 32 ಗುಂಟೆ.
32 ಗುಂಟೆ 10 ಲಕ್ಷ.
ನಾವೇ 40 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಡ್ತೀವಿ ಅವರಿಗೆ ಕೊಡ್ಲಿ ಅದನ್ನ ವಾಪಸ್.
My lords, if they have right over this property, my lords, they could have come this. Lords, they have no right over this property.
Yes. ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡ್ರಿ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀನಿ, ನಾಳೆ ಸ್ವಲ್ಪ ತೊಂದರೆ ಇದೆ. 24th ಅಥವಾ 25th ಎನಿ ಡೇ.
On 24th. Rashmi Jadhav. Rashmi Jadhav.
49, Rashmi Jadhav.
K.S. Harish.
May I seek an adjournment, my lords?
Mister, ಎಲ್ಲರೂ ಹಿಂಗೆ ಮಾಡಿದ್ರೆ ನಾವು ಏನ್ ಮಾಡೋದು?
Senior is held up, my lords.
Learn counsel for the apparent seeks time list after vacation.
Kindly peruse the order. Defer the matter to the mediation ಮಾಡ್ಕೊಂತಾರೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ
Mediation we tried.
Madam, but don't worry, we'll dispose it of. I will consider and dispose it of.
ನಮ್ಮ ಪಾರ್ಟಿಗಾರೆ 70 ವರ್ಷ ಆರ್ಟ್ ಪ್ರಾಬ್ಲಮ್ ಇದೆ ಸ್ವಾಮಿ. ಇಂಟೆನ್ಷನ್ ಇಬ್ರೇ ಅಕ್ಕ ತಂಗಿ ಸ್ವಾಮಿ ಕೇಸ್ ನಲ್ಲಿ. ಸಂಜೆ ಅಕೌಂಟ್ ಕೊಡಬಾರ್ದು ಇಂಟೆನ್ಷನ್ ಅಲ್ಲಿ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
ಯಾಕೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಕಾಸ್ಟ್ ಕಟ್ಟಿಲ್ಲ?
ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಹಾಕಿ.
2000 rupees cost is imposed. We are not paid.
I was unaware of the cost.
No, another 2000 pay now.
I'll do
Pay to the appellant, respondent.
phone pay I'll do.
ಬರ್ಕೊಳ್ಳಿ. ಕೊಡಿ ಇವತ್ತೇ. ಹೋದ ಸತಿ 2000, ಈ ಸತಿ 2000, 4000 ಕೊಡಿ ಅವ್ರು. ಅವ್ರ ನಂಬರ್ ಇದ್ರೆ ಕೊಡಿ. ಫೋನ್ ಪೇ ಇದೆಯಾ?
ನಾನು ಕೊಡ್ತೀನಿ. ನಾನು ಕೊಡ್ತೀನಿ ಬಿಡಿ 4000 ನಿಮಗೆ. ಸಾಹೇಬರು ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ 4000 ನಿಮಗೆ ಕೊಡ್ತೀನಿ.
4000 ರೂಪಾಯಿ ಕೊಡ್ತಾರ ಅವರು, ಈಸ್ಕೊಳ್ಳಿ ನೀವು.
ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸಾಹೇಬರು 4000 ನಿಮಗೆ ಕಾಸ್ಟ್ ಕೊಡಿ ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ, ಡೇಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
ಕಳಿಸಿ. Learn counsel for the appellant again seeks time. List on so and so, subject to payment of cost rupees 2000 payable to the respondent number 1. Cash ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಹಂಗೆ.
I'll pay through phone.
Next करिए संजय जी.
23rd August.
Serial number 50.
For the appellant. Yes.
Sorry, can I have it next week, my lords? Appear for the appellant.
You still not
No, my lords, I'm not
You're
recovered, my
still not
lords.
ready?
No, my lords, I'm not
Then
recovered.
counsel for the appellant seeks time on the ground that he is still bedridden. List on so and so. Mr. G.S. Venkat Subbarao,
My lords, the interim order may have extended in that earlier case.
imprimor is extended till the next date.
My lords,
Yes.
49 cost has been paid. Cost has been paid. my lords.
Ah.
Complete cost.
ಅವರು ಕೊಟ್ಬಿಡಿ ಕಾಸ್ಟ್. ಎಸ್ ಸುಬ್ಬಾರಾವ್, ರೆಡ್ಡಿ ಪಿ ಎನ್.
Some time to get ready, my lord.
ಯಾವ್ದೋ ಒಂದಾದ್ರೂ ಕೇಸ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
51 GS Venkat Subbarao.
Next week ಅಲ್ಲಿ ಯಾವತ್ತ
Connected
ಇಲ್ಲ ಸ್ವಲ್ಪ ಎವಿಡೆನ್ಸ್ ನೋಡಿಲ್ಲ.
2,000 ರೂಪಾಯಿ ದಂಡ.
ಇಲ್ಲ
ಎಲ್ಲರಿಗೂ ಅದೇ ಆಗ್ತಿರೋದು ನಿಮ್ಗೆ.
24 ಮ್ಯಾಟರ್ ಇಲ್ಲ ಇಲ್ಲ ನಾನು ನಮ್ಲಾಡ್ ಫಸ್ಟ್ ಟೈಮ್ ಇಟ್ ಇಸ್ ಕಮಿಂಗ್ ಅಪ್
24 ಮ್ಯಾಟರ್ ಯು ಶುಡ್ ಬಿ ಥ್ಯಾಂಕ್ಫುಲ್ ಇಟ್ ಇಸ್ ಲಿಸ್ಟೆಡ್.
ಕರೆಕ್ಟ್
ನೀವು ರೆಡಿ ಆಗಿ ಬರ್ದಿದ್ರೆ some counsel for the appellant seeks time list on
second item alle there is an application milad this is directed to post that application appointment of commissioner idralle connected appeal alli
appointment of receiver antide
receiver
suit is for partition receiver for what
coconut trees and milad coconut trees are there crops milad though the partition is milad ella avare tagota idare
ನನಗೆ ಕಾಪಿ ಸಿಕ್ಕಿರಲಿಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ಹೇಳಿದ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಆಗ್ತೀನಿ
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ
ಬರುತ್ತೆ ರೀಚ್ ಆಗ್ತಿದೆ. ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ರೆಡಿ ಯಾರು ರೆಡಿ ಇಲ್ವಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ಕೆ. ನೋಬಡಿ ಇಸ್ ರೆಡಿ ಟು ಆರ್ಗ್ಯೂ.
ಥಿಂಕ್ ಟ್ರೈ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಆಲ್ಸೋ ಬಂದಿದೆ.
Counsel for the appellant in serial number 51 seeks time. List on
any day other than 22nd any day minute.
24th.
24. Serial number 52 Arjun, serial number 53 Somsekhar KM.
KM Somsekhar. Vijay Kumar. Ready up. Ready now. Here.
Matter is submitted.
ಇವಾಗ ಫೈನಲ್ ಇಯರ್ಗೆ ಬಂದಿದೆ. ಅಡ್ಮಿಟ್ ಆದ್ಮೇಲೆ ಬರೋದು ಫೈನಲ್ ಇಯರ್ಗೆ.
It's the defendant's appeal. Defendant's appeal. The plaintiff has filed the suit for declaration and possession, contending that the defendant has encroached the property, who in turn has sold the property in favor of the plaintiff, despite which he has encroached upon the property of the plaintiff, and therefore he sought for the declaration of title as well as possession. The contention of the defendant is that he admits the alienation of the property in favor of the plaintiff by him. There is no dispute so far as alienation of the property by the defendant as well as brothers. Defendant's property is adjacent to remaining property of the defendant is adjacent to the very same site. For the last 20 years from the date of purchase, the plaintiff has not acted upon the property which was purchased.
Not acted upon the sale deed.
Not acted upon the sale deed and not constructed any property, he abandoned the property without constructing any building or whatsoever.
ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಏನೋ ಇದೆಯಾ?
ಅದಲ್ಲ. The reason is that there are about in the same line about 15 sites were sold. ಆ ಕಡೆ ಸೈಟ್ ಇಂದ ಮಾಡ್ಕೊಂಡ್ ಬಂದರಲ್ಲ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿ ಇವ್ರ ಪ್ರಾಪರ್ಟಿನ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. Now they are telling that my property is not measuring so and so 60-40. Therefore, you are said to be encroached upon the property of the plaintiff. Therefore, you have to earmark the property 60-40, and thereafter you enjoy your remaining property, for which we are not responsible. And the learned judges framed the issue only with regard to the possession, whether the plaintiff are entitled for the possession.
Yes.
Then your lordship may kindly see, ultimately the learned trial judges held that the defendant has encroached upon the property of the plaintiff. No issue is framed against the defendant and no burden is laid on the defendants to establish this case, and there is no issue with regard to the encroachment. And another part of decree is that your lordship may kindly see, the learned judges awarded damages also
no issues are framed with regard to that. And subsequently, when the matter was pending before this honorable court has appointed a assistant director of land record to conduct the survey. The survey report is also not clear with regard to the position of the property. So with regard to these two issues as well as the survey report, the evidence has to be recorded in fresh. ಎರಡು survey report ಇದೆ. The same assistant director has conducted the survey of the property. Each survey report is contrary to each other. Paragraph 22 and 23, your lordship may kindly of the judgment.
Yes.
The plaintiff has made efforts to produce the layout plan in respect of the layout formed by defendant number 1 and his brothers, but in spite of para 22.
Yes.
But in spite of his best efforts, he could not obtain the copy of said layout plan. The documents produced by him show that he has filed application under Right of Information Act to the Assistant Revenue Officer, Anjanapura Subdivision, BBMP Assistant Director of Town Planning, Bammanhalli BBMP Commissioner. BDA to obtain plan in respect of the layout formed in Kotanur village in survey number 11, 12/1 and 47/1. But he could not get those documents. The plaintiff have got marked the Xerox copy of layout plan as secondary evidence by laying proper foundation as Exhibit P80. The said layout plan shows that though the plan is not properly legible, it appears that site number 37 to 46 are situated in the same line and they are having equal measurement. However, there is no sufficient evidence to prove the said layout plan. But the certified copy of the sale deed produced by the plaintiff clearly.
What is the measurement of site number 37?
37, it is the remaining land site, it is the agricultural land. So far it was not converted. All the sites are not converted for.
No, but 37 is a corner site.
60 into 80 feet.
60 into 80 feet.
60 into 80 feet bitput ನೀವು ಏನಾದರೂ ಇಟ್ಕೊಳ್ಳಿ. That is the case before the court below.
Yes.
And no issues were framed with regard to encroachment.
How many sites were found? 13.
14 sites, Miller.
13 or 14? 13.
13 sites. 13 sites. ಇವ್ರದ್ದು ನಮ್ಮ ಪಕ್ಕ ಇರೋ ಸೈಟ್ ಅದರಿಂದ ಆಚೆಗೆ ಹಿಂದಕ್ಕೆ 12 ಸೈಟ್ ಇದೆ. ಅವರೆಲ್ಲ ಕನ್ಸ್ಟ್ರಕ್ಷನ್
13 ಆಯ್ತಲ್ಲ ಅಲ್ಲಿಗೆ.
11 ಸೈಟ್ ಇದೆ. 11 ಇದೆ. ಅವರೆಲ್ಲರೂ ಒಂದಡಿ ಎನ್ಕ್ರೋಚ್ ಮಾಡ್ಕೊಂಡು ಇವರ ಅರ್ಧ ಪ್ರಾಪರ್ಟಿ ಬಂದಿದ್ದಾರೆ. We have been in possession of the property for the last 20 years.
Yes.
He has not disturbed us so far.
Yes, please.
And your lordship may kindly see the report submitted by the commissioner, assistant director of land records on the basis of the direction given by this honorable court. The first report is first report is 8/4/2025. Till plan ಕೊಟ್ಟಿದ್ದಾರೆ ಇದು. It is annexed to your lordship.
ವಿಜಯ್ ಕುಮಾರ್ ಕೇಸ್ ನಡೆಸಿದ್ ನೀವೇನಾ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾರು? Who is the advocate before the trial court?
Dinesh.
Plan ನಲ್ಲಿ it clearly shown the site of the ಇಲ್ಲಿ ಇವರು ಮೆಜರ್ ಮಾಡಿರೋದು 1147/47/2 ಇಲ್ಲಿ ಯೆಲ್ಲೋ ಕಲರ್ ನಲ್ಲಿ ಇದೆ ಮಾರ್ಕ್ ಮಾಡಿದೆ.
ಎವಿಡೆನ್ಸ್ ಏನ್ ಮಾಡಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. ಈ ಕೋರ್ಟ್ ನಿಂದ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದು ಇದು ಈಗ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಇಲ್ಲಿ. Before this honorable court has directed on the basis of the submission made by the respondent, Commissioner was appointed and this.
To record your evidence.
ಇಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರೆ ಅಷ್ಟೇ, ಈಗ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಅಷ್ಟೇ.
ಅಲ್ಲ, ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ.
ಯಾರು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ವಿ?
You not marked any documents.
These documents are not marked.
No documents are marked.
No documents are marked. And your lordship may kindly see the report is also, second report is also says that in the report submitted by the commissioner is pertaining to some other property. Suit schedule, your lordship may kindly see the suit schedule. It is carved out of survey number 47 bar 47 11 47 bar 1 and 47 bar 2. The report is submitted in respect of /1, there is no 11 survey number. 47 bar 1, 47 bar 2 and 47 bar 5.
Look. DW1 code. First examination DW1 code. Yes. Thirty-seven measures 16 to 14 ಅಂತ ಹೇಳಿದ್ರೆ. Site number 37 measures 16 to 40 ಅಂತ ನೀವ್ ಹೇಳ್ತೀರಾ, ಇವಾಗ ನೋಡಿ 60/80 ಅಂತೀರಾ.
16 to 40.
All sites are 60/40.
Please come to chief examination. Para 6 of your chief examination.
I submit the para 6. I submit.
Para 6 of the chief examination.
Note that.
It is true that site number 37 and 38 are adjacent to each other, but it is false to say, oh, it is false to state, okay. Your survey number, site number 37 is measuring east to west 60 feet and north to south 40 feet.
There is absolutely no evidence with regard to measurement and with regard to the encroachment and with regard to the damage awarded.
Yes.
And the survey report is also contrary to the case of the plaintiff.
Yes.
Para 22, I am reading. The plaintiff have got marked Xerox copies also. However, there is no sufficient evidence to prove the said layout plan. But the certified copy of the said it produced by the plaintiff clearly shows that the site number 38 to 44 are having same extent. That is east to west 40 feet and north to south 60 feet. It is for the defendant to produce the document in respect of measurement of their site number 37. But he has not produced the same for obvious reason. The defendant number 1 has suppressed the measurement of site number 37 before the court. The evidence before the court clearly shows that there is nothing to accept that the extent of site number 37 east to west 80 feet and north to south 60 feet. The contention of the plaintiff that the measurement of both sites number 37 and 38 is east to west 40 feet and north to south 60 feet. The defendant number 1 has stated in his evidence that his site is measuring east to west 80 feet and north to south 60 feet. And he has put up temporary shed in his site number 37. But he has not produced any cogent evidence to show that his site number 37 is measuring east to west 80 feet and north to south 60 feet. The said measurement to east to west 80 feet and north to south 60 feet is measurement of two sides measuring east to west 40 feet and north to south 60 feet. Therefore, the case of the plaintiff is more probable that both sides are measuring 37 and 38 are having equal measurement, and that is east to west 40 feet and north to south 60 feet. when the defendant states that they have put up shed in site number 37 and measurement of site is east to west 80 feet and north to south 60 feet, it is to be accepted that he has to put shed into two sites. The defendant number 1 himself has admitted that both the sites number 37 and 38 are situated abutting each other. The learned judge has come to conclusion only on the basis of the presumption. The plaintiff has not proved his case beyond. Second report.
Yes, please.
Third, the survey report only. He has conducted survey in respect of 47/1, second survey report. 47/2 and 47/Y. The suit schedule property is also part of survey number 11. So far as 11 concerned, no survey is conducted. And you the sketch attached to the survey report says that the property is situated in 12/2. 12/2 nalli. All these properties are. ADLR report, ಮೊದಲನೇ ರಿಪೋರ್ಟ್ಗೂ ಎರಡನೇ ರಿಪೋರ್ಟ್ಗೂ there is lot of differences. All are the revenue sites.
Yes.
So in view of the survey report, the property where the plaintiff is claiming is not situated within the survey number of zones.
Yes.
Evidence ಬೇಕಾಗುತ್ತೆ. May I request for remanding the matter for.
Evidence ಎಲ್ಲ ಏನು ಬೇಕಾಗಿಲ್ಲ.
Report ಇದೆ. The survey report is not pertaining to the suit schedule property. And they have not claimed they have not pleaded in the plaint with regard to the encroachment, what extent the encroachment was there.
Yes.
And there is no evidence with regard to damages.
Yes.
The learned trial judges passed the degree in respect of damage also and encroachment also.
Yes.
Encroachment is not the case of the plaintiff also.
The encroachment you are sinking into their property ಅಂತ ಅವರು ನೀವು ಅವ್ರ ಪ್ರಾಪರ್ಟಿಲೋ ಕೂತಿದ್ದೀರಾ ಅಂತ ಅವ್ರು
Your lordship may kindly see the suit schedule. Now one side ನಾವು ಇದ್ದೀವಿ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀವಿ. ನಾವು ಸೇಲ್ ಡೀಟೇಲ್ಸ್ is also says that.
ಆಯ್ತು ನಿಮ್ದು 60/80 ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್?
It is a survey number. Therefore measurement cannot be.
But it's a corner site.
Formed in
It's a corner site.
Corner site,
if you look at the photographs, there are roads which are formed. So corner site of 60/80 ಅಂತ ತೋರಿಸೋದಕ್ಕೆ ನಿಮ್ದೇನ ಇರ್ಬೇಕಲ್ಲ, ಖಾತೆ ಪಾತೆ ಏನಾದ್ರು ಇರ್ಬೇಕಲ್ಲ.
ರೆವಿನ್ಯೂ ಲ್ಯಾಂಡ್ ಅಂತ ಖಾತೆ ಮಾಡ್ಲಿಲ್ಲ ಅವರು ಅಷ್ಟೇ.
How did you convey this site then? Without the khata?
Brothers have sold the property. Yes.
Sure it is. How was it sold without a khata then?
ಮಾರಾಟ ಆಗಿದೆ. ಅಸೆಸ್ಮೆಂಟ್ ಇದೆ.
ಮಾರಾಟ ಮಾಡೋ ಖಾತಾ ಬೇಕಲ್ಲ.
ರೆವಿನ್ಯೂ ಅಸೆಸ್ಮೆಂಟ್ ಮೇಲೆ ಬೇಸಿಸ್ ಮೇಲೆ
ನಿಮ್ದು ಇರ್ಬೇಕಲ್ಲ ಹಂಗಿದ್ರೆ.
ಅದು ರೆವಿನ್ಯೂ ಅಸೆಸ್ಮೆಂಟ್ ಇದೆ ನಮ್ದು.
ತೋರಿಸಿ ಎಲ್ಲಿದೆ, ಯಾಕೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಅದು?
There was no burden on the defendant to establish.
Correct, sir, but when you have sold the property to them, to the plaintiffs, it is also your responsibility to show in your sentence helidira. Plaintiff is in possession of site number 37 ಅಂತ ಹೇಳಿದಿರ ನೋಡಿ. Please come to the evidence of DW1.
37 ಅಲ್ಲಿ ಇದ್ದಾರೆ ಅಂತ ಇವ್ರು ಇಲ್ಲ ಅಂತ
Possession ಇದ್ದಾರೆ ಅಂತ ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಾ ನೋಡಿ. Please come to the evidence of DW1.
False anta ಇದೆ.
No.
It is false to suggest that we have constructed a shed including both site 37 and 38.
Site number 38 is in possession of the purchaser, the said site, that is plaintiff number 2. And similar such suit you have filed against other purchasers, OS 4091. ಅವ್ರ ಮೇಲೂ ಹಾಕಿದಿರ ಸೂಟ್ ಹಾಕಿ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. So it looks like you're in the habit of selling.
RFA is pending.
Correct. It looks like you have the habit of selling and filing suits against them. ಮಾರಾಟ ಮಾಡೋದು ತಿರ್ಗಿ ಅವ್ರ ಮೇಲೆ ಕೇಸ್ ಹಾಕೋದು.
ಇಲ್ಲ ಇದು ಅವರೇ ಕೇಸ್ ಹಾಕಿರೋದು ನಾವು.
Correct, but ನೀವು ಅವ್ರ ಸೈಟ್ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡ್ರೆ ಇನ್ನೇನ್ ಮಾಡ್ತಾರೆ? Go and encroach into their property, what will they do?
It's an admittedly it's a revenue sites. ಇವರು 20 ವರ್ಷ ಬಿಡ್ತಾರೆ, ಆ ಕಡೆಯಿಂದ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದು ಅರ್ಧ ಅಡಿ ಒಂದ್ ಅಡಿ ಎಲ್ಲ ಕಟ್ಕೊಂಡ್ ಬಂದಿರ್ತಾರೆ. ಈಗ ನಾ 60-40
ನಿಮ್ಗೇನ ದುಡ್ಡು ಕೊಡಿಸ್ಬೇಕಾ?
ಮಾತಾಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ.
ಅದೇನೋ ಅಂಗಡಿ ಇಟ್ಕೊಂಡಿದ್ರ ಅದಕ್ಕೋಸ್ಕರ ಏನೋ ದುಡ್ಡು ಕೊಡಿಸ್ಬೇಕು ಅಂತ ಕೊಡ್ಸೋಣ. ಒಂದ್ 5 ಲಕ್ಷನೋ 10 ಲಕ್ಷನೋ ಒಂದ್ 15 ಲಕ್ಷನೋ ಕೊಡ್ಸೋಣ. ಇಷ್ಟ ದಿನ ಕಾದಿದಿರಲ್ಲ ಪ್ರಾಪರ್ಟಿ. Mister, he has taken care of your property, Mister. Watchman ಗಿಟ್ಟಿದ್ದು ಎಷ್ಟಾಗಿರೋ ದುಡ್ಡು? ಆಯ್ತು ಇರ್ಲಿ, but he has taken care of your property. ಖಾಲಿ ಇಟ್ಕೊಂಡ್ರೆ ಹಿಂಗೆ ಆಗೋದು. ಸರ್ ಕೋಳಿನ ನಿಮ್ಮ ಗೌಂಡ್ ಇದ್ರಲ್ಲೇ ಬಿಟ್ಕೋಬೇಕು. ಕೋಳಿನ ಹೊರಗ್ ಬಿಟ್ರೆ ಹಿಂಗಾಗುತ್ತೆ, ನಂದು 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 ಅಂತ ಬರ್ತಾರೆ. It's all right, Mister. See, he has looked after your property, he has taken care. ಒಂದು ಅಷ್ಟೋ ಕಾಸು ಕೊಟ್ಟು ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡಿ ಕ್ಲೋಸ್ ಮಾಡಿ. ಎಸ್ ಏನೋ ಒಂದು ಖರ್ಚಾಗಿರ್ಚ ತಗೊಂಡು ಕ್ಲೋಸ್ ಮಾಡಂಗಿದ್ರೆ ಬಿಡಂಗಿದ್ರೆ ಬಿಟ್ಬಿಡಿ, ಇಲ್ಲಾಂದ್ರೆ ಯು ಡೋಂಟ್ ಹ್ಯಾವ್ ಎ ಕೇಸ್.
24th your last matter.
Heard the learned counsel, learned senior counsel for the appellant and the learned counsel for the respondent. List on so and so to explore a settlement. Yes. All other cases summarized. Then Rajshekhar Siri. Then Samachara. Vincent PJ.
Recovery suit.
What is the money? What is the amount?
1 lakh.
Interim order maybe.
Yes. Manu. ಇಲ್ಲಿ ವಿನ್ಸೆಂಟ್ ಎಲ್ಲಿ?
ರೆಡಿ ಇದೀನಿ.
ಹೇಳಿ ಏನು ಅಂತ.
ಏನಿಲ್ಲ, ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್, ದಿ ಪ್ರಿನ್ಸಿಪಲ್ ಬಾರೋವರ್ is the husband of the first defendant, my lord.
First respondent?
First respondent, this is the plaintiff appeal, my lord. Suit has been dismissed. But first defendant happens to be the borrower's wife. Second defendant happens to be the borrower's son. Third defendant is the employer of the plaintiff and the husband of the first defendant. ಏನಾಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇಬ್ರು ನೌಕರಿನಲ್ಲಿ ಇರ್ತಾರೆ, SKF ಬೇರಿಂಗ್ ನಲ್ಲಿ. SKF ಬೇರಿಂಗ್ ಅನ್ನೋ ಫ್ಯಾಕ್ಟರಿ ನಲ್ಲಿ ಇಬ್ರು ನೌಕರಿ ಮಾಡ್ತಾ ಇರ್ತಾರೆ, ಪ್ಲೇಂಟಿಫ್ ಮತ್ತು ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 ಯಜಮಾನ್. 7,000 ರೂಪಾಯಿ ಕೈ ಸಾಲ ಕೊಡ್ತಾರೆ, 7 ಲಕ್ಷ ರೂಪಾಯಿ ಮನೆ ಕಟ್ತಾ ಇರ್ತಾರೆ, ಕೈ ಸಾಲ ಕೊಡ್ತಾರೆ. ರೀಪೇಮೆಂಟ್ಗೆ ಒಂದು ಚೆಕ್ ಒಂದು ಕೊಟ್ಟಿರ್ತಾರೆ. ಕೋವಿಡ್ ಪ್ಯಾಂಡಮಿಕ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಅದು ಬೌನ್ಸ್ ಆಗ್ತದೆ. ದೇರ್ ಆಫ್ಟರ್ ನಾಟ್ ಪೋಸ್ಟಲ್ ಶರಾಯಿ ಏನಂತ ಬರ್ತದೆ ಅಂತ ಹೇಳ ಅಂದ್ರೆ ಸಿಗ್ನೇಚರ್ ಡಸ್ ನಾಟ್ ಮ್ಯಾಚ್ ಅಂತ ಬರ್ತದೆ. ರಿಕವರಿ ಸೂಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ನೋಟಿಸು ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಓನರ್ಗೆ. ಪರ್ಪಚುವಲ್ ಇಂಜಂಕ್ಷನ್ ರಿಲೀಫ್ ಕೇಳ್ತಾರೆ ಫ್ಯಾಕ್ಟ್ರಿ ಅವ್ರ ಮೇಲೆ, ನಾಟ್ ಟು ರಿಲೀಸ್ ದಿ ಅಮೌಂಟ್ ಟು ದ ಎಕ್ಸ್ಟೆಂಟ್ ಆಫ್ 7 lakhs. ಒಂದು ನೋಟಿಸ್ ಕೊಟ್ಟು ಸೂಟ್ ಹಾಕ್ತಾರೆ. ಸೂಟ್ ಅಲ್ಲಿ ಥರ್ಡ್ ಡಿಫೆಂಡೆಂಟ್ ಅಪಿಯರ್ಸ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್, seeks time for filing return statement. He has been notified. Next date of hearing ಗಿಂತ ಮುಂಚೆನೆ 50 ಲಕ್ಷ ರೂಪಾಯಿ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಅನ್ನ ರಿಲೀಸ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಒಂದೇ ಸರಿ. Trial court comes to the conclusion saying that I am unsuccessful in ಒರಿಜಿನಲ್ ಸಿಗ್ನೇಚರ್ ನಾನು ಕಂಪೇರ್ ಮಾಡಕ್ ಆಗ್ಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಸಿಗ್ನೇಚರ್ ಅದು ಒಂದು ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 1 and 2 ಹತ್ರ ಸತ್ತೊಂದು ಬಿಟ್ಟ ಅಂದ್ರೆ ಎಂಪ್ಲಾಯರ್ನೇ ಪೂರ್ತಿ ಅಮೌಂಟ್
7 ಲಕ್ಷ ಎಲ್ಲಿಂದ ಬಂತು? From where did you get 7 lakhs?
ಕ್ಯಾಶ್ ಮಿಲಾಟ್
ಅಲ್ಲ ಎಲ್ಲಿಂದ ಬಂತು? ಮೇಲಿಂದನೇ ಬಿತ್ತ?
1 ಲಕ್ಷ ರೂಪಾಯಿ ಚಿಲ್ಲರೆ ಪಗಾರ ಇದೆ SKF ಬೇರಿಂಗ್ ನಲ್ಲಿ.
1 ಲಕ್ಷ
ಹೆಚ್ಚು. ಕೈ ಸಾಲ ಮನೆ ಕಟ್ತಾ ಇದ್ರು ಅಂತ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಬಂದಿದೆ. ಮನೆ ಸಾಲ ಕಟ್ತಾ ಇದ್ರು, ಬ್ಯಾಂಕಿಂದ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತೆಲ್ಲ ಇದಾರೆ ಅಂತ ಬಂದಿದೆ.
Madam, but you know your husband has constructed a house.
Their claim is they have borrowed some amount, some 43 lakhs.
From where?
From this to legal necessity, they have borrowed 7 lakhs to construct the house. But already they have taken a loan for 43 lakhs from SBI. And for education purpose of the second respondent, 1.5 lakhs, your lordship. For that, I have produced a document also.
What is the extent of construction?
That is almost 80 lakhs.
Huh?
80 lakhs.
80?
80.
18?
80.
From where did you get that?
Because they have some amount that was there. Then along with this.
Madam, you did not have money to pay to your son's education. And you said that you had some money.
For 80 lakhs.
Be honest. Is somebody is
Number 1 is only one daughter. She is only one daughter of the mother. So mother also contributed some amount.
Madam, please keep your parties present. This is honest. If it's an honest transaction, please honor it. If it's an honest transaction.
People are not aware because they are not seeing this appellant for the first time in the court. Telling that they are deceased Ashok Kumar and appellant was very close friends. Close friends mean at least they will come to their house only for one time.
Yes.
They are telling that during COVID time he has met the respondent number 1 and 2. The Ashok Kumar has died due to COVID-19 on 18/8/2020.
ಅವ್ರ ಮನೆಗೆ ಹೋಗಿಲ್ವಾ ಇವರು?
ಹೋಗಿದ್ದಾರೆ.
Quarantine.
Quarantine.
He was quarantine because
ಫಸ್ಟ್ ವೇವ್ ನಲ್ಲಿ ಮನೆ ಮುಂದೆ ಎಲ್ಲ ಬ್ಯಾರಿಕೇಡ್ ಎಲ್ಲ ಹಾಕಿರ್ತಾರೆ.
second respondent was
ಹೋಗಿದ್ರು ಪಾಪ ಕ್ರಿಮೇಷನ್ ಅಲ್ಲೆಲ್ಲ ಹೆಲ್ಪ್ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲ.
ಬದುಕಿದ್ದಾಗ ಹೋಗಿರ್ಲಿಲ್ವೇನ್ರಿ ಇವ್ರ ಮನೆಗೆ?
ಬದುಕಿದ್ದಾಗ ಹೋಗಿದ್ರು ಎಲ್ಲ.
She says I don't even recognize this man.
ಅದ್ರಲ್ಲ ನೋಟಿಸ್ ಮೇಲೆ ಒಂದೇ ಒಂದು ರಿಪ್ಲೈ, ನನಗೂ ನಿನಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ, ನಿನ್ನ ಹತ್ರ ತಗೊಂಡೇ ಇಲ್ಲ ಅಂತ ನೋಟಿಸ್ ನಲ್ಲಿ ಒಂದು ರಿಪ್ಲೈ ಕೊಟ್ಟಿಲ್ಲ. ಆಮೇಲೆ ಇನ್ಫ್ಯಾಕ್ಟ್ ವಾಟ್ ಪ್ರಿವೆಂಟೆಡ್ ದಿ
Madam, but if you decree the suit, you'll have to pay interest. Please think about it. If you now settle the matter, we'll direct him to accept that 7 lakhs and close it. If you decree the suit, you'll have to pay interest. When was the suit filed?
2020.
2020.
Yes.
Almost you end up paying 3.5 lakhs interest. Think about it.
About this transaction, they are totally unaware, your lordship. They are not aware of this transaction.
Yeah, but see the conduct. Your husband's check is with him.
Because both were working in one company. Chances are there, your lordship.
Both are working in one company. Illi heltira. So how can we disbelieve that he has not paid the money?
And the necessity of the
Think of,
money.
you speak to your client. If we pass an order, you will end up paying interest. And your property, whatever house that you have constructed, will come under pressure. Think about it.
Original signature of the Ashok Kumar because the
Yes.
husband of the respondent number.
How will you prove it, madam? How will you prove? Will you have the admitted signature? Yes.
Genuine signature will be there in the attendance register or whatever it may be.
ಅದೇ ಮಾಡಿದಿರಾ?
ಅಲ್ಲ ಕಂಪನಿ itself is
We'll direct now itself. The High Court will do it. We'll get his signature from the company, we'll send it for forensic examination, and it happens, you'll have to bear the cost of examination, forensic examination, interest, and for lying before the court, you'll have to pay cost for him, exemplary cost. It will become 15 lakhs, including all cost and other things. Please think about it. Please speak to your client, or if you want, you can bring your client to the court. We'll counsel her properly. Once we decree, we can do it, madam. We can get the documents from the company. Even now, we can get it done. If you are under the impression that it was not done before the trial court, we can't do it here. You're wrong. We can do it here also. You want it to be done?
I talked to them, they are telling that this person, they are not aware because they are not.
Oh, it's already, if that is the case, you please verify. I list it on 22nd. If your client says that you do not, you want to take an order on merits, we'll direct a comparison with the signature. Think about it.
53 interim order.
Interim order is extended. 41 was passed over. 41. Yeah, LR application. Bandidya, or full. An IA so-and-so is filed by the applicants to come on record as the legal heirs of the deceased appellant. Since the cause of action is served at the death of the appellant, in delay giledia. Since the cause of action is served at the death of the appellant, the applicants are entitled to come on record and pursue this appeal. Since IA 126 is allowed, the applicants are permitted to come on record as the legal representatives of the deceased appellant. Counsel for the appellant is directed to amend the cause title.
Interim order may kindly be extended.
Interim order extended to the next date.
Amendment.
ಇಪ್ಪತ್ತೆರಡಲ್ಲ ಕೊಡು ಸಾಹೇಬ್ರೆ.
ಯಾವತ್ತು ಸರ್?
22.
22 ಇಲ್ಲ ಕೋರ್ಟ್ 22ಕ್ಕೆ ಇದು ಬರುತ್ತೆ ಏನೋ ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್
23
23 ಇವರೇ ನಿಂತಿದ್ದಾರೆ ನೋಡಿ. K1 26 ಅಲೋ ಮಾಡಿ ಸರ್ ಅದು ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ. ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಆಗಿದೆಯಾ ಅಲ್ಲಿ ಬನ್ನಿ ಪ್ಲೀಸ್. 41 ಯಾವತ್ತು ಬೇಕು ಸರ್ ಅದು? ಡೇಟ್ ಬೇಡಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಮೇಡಮ್. ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.